My lord, may I be permitted to mention the matter WPA number 61 of 2025 for inclusion in the list for motion?
It was not taken up earlier.
Earlier it was taken, but His Lordship Justice Joy Sengupta has given an order in passing, keeping the matter under the same heading after 3
What
weeks.
was the direction passed?
My lord, this is the order that I have.
Affidavits directions were passed.
The affidavit of let this matter be listed for a hearing under the same heading after 3 weeks.
Hearing. The affidavit direction was passed, so it's a hearing matter. Not now, yes.
Milord, Milord.
My lord, I have Application 5/11/2024. It was dismissed by Justice Arindam Mukherjee. One technical glitches was happening. Petitioner was supposed to come on virtual mode, but he could not able to come on virtual mode. So it was dismissed by default. And now
When it
we
was
are praying for it.
When it was dismissed?
5/11/2025
5/11?
to the 2024.
Yes, so you are saying 25. All right.
Milord, may I be permitted to mention this matter, Milord? This is pertaining to the contempt matter, Milord. Last year when your lordship had came to this circuit, Milord, you had given order to demolish the illegal construction, Milord. But till date, this Pradhan of the
Well, mentioning now after
Milord, it was
last week.
copy has already, petition has already been filed, but it is not coming in the list. That is the reason, Milord.
Unless
Kindly,
mention
kindly
it
look
cannot
into
come in the
it. Kindly
list.
consider it.
My lord, may I
Grateful,
permit one mention? My lord, yesterday one order was passed. There, the respondent number 2 submitted a wrong document to mislead the court. My lord,
What do you want?
I want to recall the order.
File an application. File an application for recalling. Yes.
My lord, kindly see the correction.
Not correction, you want recalling. Recalling, you have to file an application. Yes, file an application.
We are positive for mentioning for the correction, lordship, in this matter, lordship.
What happened?
Your lordship has directed to respondent number 4 to dispose the representation, but it should be respondent number 2.
May I mention one matter under existing urgency? This is with regard to a student of class 7. The was prepared in the year 2024. When the order was passed, directing the school to allow the petitioner to attend the school and attend the examination, but not to publish the result. Now the final examination is also over. I am not in a position to know whether I have been promoted or not because they are not disclosing the result.
There was an order not to disclose the result.
Take something matter.
Hearing matter, Mr. Paul.
May I hand over the restoration?
Lordship, kindly my matter, keep it to day after tomorrow, lordship. Tomorrow I have for correction, lordship.
Correction tomorrow it will appear.
Lordship, I have a submission.
Tomorrow will not be available.
Day after tomorrow.
The day after tomorrow.
Great.
Lord, may I have your lordship sleep, Lord, after Lord the physical mentioning is over, Lord.
This way, yes.
Lordship, one restoration application for inclusion in the list.
When
matter
was for default?
7 November 2024. That's all. Great for your lordship.
Yes.
My Lord, Lord, may I just mention one matter, Lord?
Yes.
Axis Bank, Lord, filed an application under section 14 before the Lord district magistrate. But the district magistrate, Lord, dismisses the section 14 application, holding that the NPO was not correctly made. Lord, the district magistrate, Lord, exercised the ministerial power, Lord, not Lord the adjudicatory power. Lord, he does not have any Lord power to decide whether section 14 was rightly NPO was rightly exercised or not. Challenging that, Lord, I filed a writ petition. Lord, I pray for inclusion of the matter, Lord, in the list.
When have you filed the writ petition?
Lord, I have filed, Lord, in the 2023. But every time, Lord, this is being, Lord, kindly.
It's not
Lord,
the motion, it's the hearing.
No, Lord, hearing. It will take 2 minutes of your lordship's time, Lord. The service is completed. They have not filed the affidavit till date.
I'm not writing now. Yes.
May
Lord,
I have my lord's kind permission
kindly
to-
take the matter, Lord.
Hearing matter, it's not possible. Only
It will take 2 minutes of your lordship's time because I'm covered by the judgment of.
To you, 2
This
minutes.
is
May not be.
no,
for the
this
court,
is
2 minutes.
this is just Lord, yes, that is the reason, Lord, I've given the subject. Lord, this is 14 rejected by the district magistrate. He cannot do it.
Don't move the writ petition because there's an alternative efficacious remedy.
No, I don't have section 14, Lord. I'm
May I
the
have my
bank. I'm the
my
bank.
lord's kind permission to
Please consider the latest Supreme Court judgments. Yes,
may I have my lord's permission to mention a matter, my lord? It is appearing as item number 87 of my lord's days list.
yes.
My lord, the urgency is that this matter is complete. Affidavits have been completed, and the
Yes.
matter had come up for hearing before the previous circuit bench. However, the matter could not be taken up. I'm mentioning upon notice, my lord, the urgency is that a vehicle has been blacklisted by the ARTO, and which was done ex parte without hearing my contentions. My lord, it will take 2 minutes exactly of my lord's time.
Upgradation not possible. I will call serially. Yes.
Grateful, my lord.
Lordship, may I be permitted to mention one restoration application,
When it was dismissed.
17 December 2024. Lordship, another two matter for withdrawal the petition.
Withdrawal. Withdrawal non-constitution Calcutta. It was not taken up.
But it was earlier taken up.
What was the direction passed?
For a direction to file a report, madam, not in the form.
Yes, for the list. Yes, what is the correction?
And for the petitioner, my lord.
My lord, name of the advocate of the state had not been incorporated, my lord.
Give the appearances of this matter was directed to appear in the hearing you mentioned for correction of a typographical error which has script in the order dated 4th of April 2025. In the said order, the appearance of the learned advocates who represented the state was inadvertently not recorded. It is hereby recorded that the following advocates appeared for the state when the matter was heard on 4th of April 2025. Mr. Let the appearance of the state advocates. Let the names of the appropriate advocates be recorded. We have presented the state on 4th of April 2025. Let such error be rectified. Order shall form part of order dated 4th of April 2025.
Grateful.
Yes, colleagues. Yes.
Lordship, this matter is already got heard. Direction was given to publish the result.
Yes.
Lordship, this is yesterday's screenshot of the portal.
Results published.
No,
Yes.
Yes, that is the.
Madam, I beg to
And for
appear
the
on behalf
college.
of, I beg to appear on behalf of the
College.
university,
Yes.
university.
Yes.
On third, your lordships has been pleased to not direct the university to publish the result of the 6th semester by 7th of April.
Yes.
Now, if your lordship may kindly consider, not ideally, not I should have come up with an application for modification or not for extension of time.
Yes.
Because not the 6th semester results not are due to be published in July 2025 for the regular batch.
No, fifth
Now-
has already been published, Mr. Majumdar.
5th is published in February 25
Yes.
for the petitioners also.
Yes.
Now, not for it's for the benefit of the students. If my learned friend appearing for the writ petitioners would consider, I can't publish a 6th semester result which is prior to the 5th semester. It has to be after the 5th semester result.
Yes. So you
Now
have
the
not
sixth
yet
sem-
published, Mr. Majumdar, you have not yet published the 6th semester result till this date. So it has to be after the 5th semester. You have already published the 5th semester.
So the 6th semester result for the regular students will be published in end June or first week of July 2025.
But Mr. Majumdar, this petitioners did not appear in the 6th semester along with the other regular candidates.
Right.
That is
Now,
the
not they were,
limitation. So they appeared.
yes,
So they appeared earlier.
they appeared pursuant to orders with
Yes.
a reservation that the results would not be published.
Yes.
Now, not the 5th semester result has been published.
Results
sixth
will not
semester
be published till the results of 5th semester is
semester,
declared.
Right.
That
Now
was the order. Now 5th semester
Now-
has been declared. Why are you not publishing this 6th semester result?
The 6th semester result, not so far as 4 out of the 4 petitioners, 3 have to give backlogs.
Say
3 have
so.
not. Right. Now, not in the event I have to publish a supplementary result sort of a thing for them.
Yes.
They will be in difficulty while their future courses will be taken into consideration for treating them at par with the regular students. Because your lordships know not that today it's the odd semester and even semester system. They
Yes.
have to take the not passed subjects in the 5th semester along with the 7th semester examination.
Yes.
So it's for their own benefit that I beseech your lordship that kindly directs us or allows us to publish their 6th semester result along with the regular students.
Yes.
Now the question is, lordship, what for the reason we are fighting is that our backlog, year log, they want to erase the entire year of our career, which we are fighting. Now, lordship, the year log is not due to our fault. We applied correct at the right juncture, but it was the ego between the university and the college that we are suffering. 5th semester,
We don't, so far as
When-
students are,
when-
my
when
learned
your
friends kindly bear.
7th semester exam is due.
7th semester of the regular batch means our batch has already been complete. Now, 5th semester examination was we appeared upon an order of the court. 6th semester also we appeared upon an order of the court. Now, if the 6th semester result is published, we pray before lordship to allow us to sit in the 7th semester result exam and publish the results so that we can appear with the our regular batch on the 8th semester at July.
When July 8th
July.
semester will be held.
Lordship.
The 7th semester exam is due in December 2025.
No, Mr. Bojumdar, what they are saying that
Yes.
their regular batch in which they were, because according to them, due to some problem between the college and the university, they could not appear in due
The
time.
college did not upload their names. There was some
Yes,
difficulty
So,
with the
so it was the fault of the college, not the fault of the students. So now, for that reason, they got their exams or semester exams got delayed. So, according to the learned advocate for the petitioner, their eighth semester exam along with the other regular candidates of their batch, that is scheduled on
July.
that is scheduled on July 2025.
Right.
So
May lordship.
May 2025. So, but you have not appeared in the classes of
No, we are appearing lordship.
No, that's the
8th or
problem.
7th. You are appearing for 7th or 8th semester.
7th, they have to first clear the 7th exam, 7th
Eighth
semester.
even.
8th semester classes were held.
Yes.
Nothing has been, not so far as 7th semester is concerned.
We
But
were
the
allowed to-
internal evaluation along with the
No,
practical
you are
results
allowed
have to be uploaded.
appear in the
No. Participate in the classes.
Yes, participate in the classes for the 7th semester.
8th semester also lordship.
8th semester
Yes,
also.
lordship. Yes.
How can they
Yes,
do
what-
so?
What is your instruction?
I can only pray and submit that the future of the students should not be.
No, that is one thing.
Now, one thing.
Did they participate in the 8th semester classes? Because it's one thing to appear in the examination. Other thing is that
I need,
they have to participate in the classes.
I need 2 minutes time to confirm it. Because last night I asked about the result, but whether they are now participating in the 8th semester or not.
If they have not attended the classes,
Lordship,
it's difficult.
The client said they are attending.
Maybe
No, I just
They are attending.
I just expressed to
I
your
just
lordship
need
not
2
why
minutes.
the 8th semester is not practically feasible. For every semester, there is an internal assessment along with conduct of practical examinations during the period as sanctioned by the university. For each evaluation, these results or not, the evaluation process has to be uploaded by the respective colleges on the portal of the university. For these 4 students, we have not received any uploading of documents or data for these students having participated in the internal evaluation assessment or the practical examinations. But these students' life will be in jeopardy because of this impractical
happened-
stand being taken.
what is the status with regard to the 7th semester, which is
The
concerned?
7th semester, no, I persuade your lordship, as I request my learned friends to consider that the 7th semester regular examination will be considered in December 2025. If these students can bear this 6 months time period, it will be benefiting. This will be beneficial for the students. They will be treated at par with the regular students. Maybe they will be lagging behind for a period of 6 months, but in the long run, their entire course will be preserved.
Not 6 months lordship, because in May the 8th semester will help, and he's saying that in December our 7th semester.
Right, the 7th semester
That's
evaluation
so-
has not taken place.
One is You have attended the classes. What
Lordship.
Mr. Mojumdar says is that in the semesters also there is internal assessments.
Yes, Lordship.
Madam,
Detail.
please give instructions to your advocate.
Lordship, as per their record, the
So-
document, they are giving internal assessments
According
also.
to Mr. Mojumdar, that has not been uploaded.
They're the,
So all these things are to be ascertained, whether it has been uploaded.
now let the college.
All internal assessments, so far as the 7th semester, now you want to appear in the 8th semester in, I think, May
May.
2025, you are saying. So
With
it's
my
only
regular
1
batch.
month. Now from not even 1 month. So for that 7th semester exams, I do not know how many papers you have to appear for in the 7th semester.
Six papers, six papers.
also
Five.
5. 8 semesters also 5. 10, 3. So 8 papers along with those internal assessments. I do not know what is the status
Let the college.
Along with the backlog and the backlog.
and the backlogs also. Please consider, please,
We are ready to give the examination because we are doing regular classes.
sir, it's not that you want to give.
So kindly consider,
Take
Lordship, the
What
1 year,
happened after
1
that?
year log. 1 year.
I
backlog.
appreciate that, but please consider 1 year is one thing, and if you are not equipped, if you have not equipped yourself to appear for the 8th semester, then what will
Lordship,
happen?
we are equipped. And now, if the college is.
Equipment maybe from your end, but from the college, this internal assessment,
I need-
whether that was done.
I need 5 minutes time to confirm on that.
All right, come tomorrow, take instructions, please
Grateful, Lordship.
consider also this thing.
Lordship.
My lord.
I'm grateful, man.
Heard Mr. Mojumdar, learned senior advocate for the Siliguri Institute of, no, for the university.
So I appear for the respondent number 1, the university.
Yes, for the for the
Make out.
university. First up, the learned advocate appearing for the Siliguri Institute of Technology, prays for an accommodation to take instructions with regard to the issues which has cropped up in course of hearing of this victim. List this matter tomorrow under the same heading.
Grateful, Lordship.
Grateful to lordships.
Yes.
This is my application. I am led by Mrs.
My lord,
Sumara. She is
I am
online.
appearing for the petitioner, my lord. Yesterday, my lord had directed the respondents to appear.
Yes, respondents have now not partly.
I'm grateful to your lordship.
You are fully ready.
My
You
lord.
come ready with the matters, I know that. Yes, yes, madam.
My lord. My lord, come straight away to page 133.
133, yes.
133. The impugned order under challenge. My lord, this is an order dated 7th February 2025.
Yes,
My lord, it is seeking to amend and giving effect order already passed in pursuance to an appellate order under section 260A, wherein a refund was due and payable to me without giving me an hearing. They have, my lord, made the demand of rupees 18,66,000, which is at page 134. My lord, comes to the next page.
it was not pursuant to an application from your end.
My lord,
This order was not passed pursuant.
no,
to an
my lord, no, my lord, no.
Suo moto.
No suo motu. No notice was given to me, nothing. My lord, and the facts which I will place, which culminated into this order, in a nutshell, my lord, which is very surprising and very interesting. My lord, an assessment order was passed for the assessment year 2014. My lord, against that, CIT appeal order was passed. CIT appeal order was passed,
Yes,
my lord, on two aspects. One, on one hand, the CIT appeal deleted the other, deleted the additions, and on the second limb, directed the assessing officer to again verify the facts. My lord, tribunal was there. Tribunal upheld the CIT appeals order. My lord, on an appeal before the, my lord, Honorable High Court, my lord, in judgment,
Page 92, my lord.
my lord,
The page
it
92.
is at page 92.
yes,
My lord, the judgment is dated 2nd August 2023.
yes,
2nd August 2023, my lord was pleased to allow the questions of law which has been raised and decided the appeal in favor of the writ petition of the appellant therein. My lord, will come to page 95.
Yes.
My lord, on the last paragraph, we have heard the learned advocate for the appellant on the above submission. Though in the order passed by the CIT appeal, the word prima facie has been used, from a cumulative reading of the order passed by the CIT appeal, we find the case has been discussed on merits, and thereafter finding has been recorded that the assessing officer was not justified in making the addition, and there was a positive direction to delete the addition. If such a find is the finding, mere use of the word prima facie could not make a prima facie view, as the CIT appeal has discussed the matter elaborately, taking into consideration the factual position. Before the learned tribunal, my lord,
Yes.
the limits of the powers statutorily bestowed under as per section 251(1)(a) of the Act and grossly erred in law in restoring the case to the assessing officer for action in terms of the order dated 23rd November 2011 passed by the CITP. Those such specific ground raised by the appellant before the tribunal and noted by the tribunal in paragraph 3 of the impugned order, this aspect was not dealt with by the learned tribunal. Thus, in our view, the CIT, not only the CIT appeal committed an error of law by remanding the matter to the assessing officer for fresh consideration after having held in favor of the assessee. My lord, next paragraph, my lord, comes. The last line, admittedly, the revenue has not challenged the findings of the CIT appeal rendered by the CIT appeal, which was in favor of the assessee. My lord, next, at page 97, the appeal is allowed and the substantial questions of law are answered in favor of the assessee. My lord, thereafter, the giving effect order
Page
was passed,
125.
my lord, which is at page 125.
Yes.
Page 125. This is the giving effect order pursuant to the order passed by the Honorable High Court.
Yes.
Yes. The assessee, my lord, I'm reading from the third paragraph. The assessee filed an appeal before the Honorable High Court and raised the ground the CIT appeal exceeded the limit of the power statutorily bestowed under section 251(1)(a) of the Act and grossly erred in law in restoring the case of the AO for action in terms of the order dated 23rd November 2011. It should be 2021. Next, the Honorable High Court, wide order number ITAT 147 of 2023, has decided in favor of the assessee. So the assessing officer was completely aware of the fact. Accordingly, the computation of the income is hereby recomputed, my lord, and thereafter, my lord, after the recomputation, the assessing officer has calculated a refund of 12,18,636.
Yes.
Next, the order 154 order comes in, my lord. After a period of 1 year, suddenly, without giving me any hearing, my lord, in terms of section 154(3), my lord will kindly take the Act, section 154(3).
My lord.
My lord takes up section 154,
Yes.
which is rectification of mistake. With a view to rectifying any mistake apparent from the record,
So if it has the effect of enhancing, it has to be with notice.
it has to, my lord, says subsection 3 says an amendment which has the effect of enhancing an assessment shall not
Enhancement
be
has
made.
to be with notice.
It has to, and hearing must be given.
Reduction may be without notice.
Without
Reduction
notice.
may be without notice.
My
But
lord,
enhancement has to be with notice.
my lord, another aspect is that, my lord, in the meantime, I come before my lord for two aspects. In the meantime, the penalty order was passed. Against the penalty order, I have made one revision application before the commissioner. My lord, the revision application is still pending. And now they have, my lord, somehow from another account, my lord goes into the writ petition. I'm amazed how it can be done. From another account, which is not the account of the SSC, my lord, they have adjusted rupees 12 lakhs against the refundable amount against the penalty. My lord, they have not given any penalty. Now what they have done, and again in the order dated 7th February 2025, they have raised a
by the
demand of
same
18 lakhs.
officer or a different officer?
My lord,
Is it by the same officer or different officer? This
same
my
was
lord,
officer.
the
before
same
order.
officer.
Same
My
officer.
lord, the
Same
person may
officer.
be,
Yes,
the
madam.
incumbent is different, the incumbent may be different,
No,
but the
I'm
officer is
asking
same.
whether the
Same officer,
incumbent or
same rank. Same rank, same
not
officer.
the same rank,
Yes.
same person
Same
or a
officer.
different person.
Kamlesh
Yes.
Kumar,
Kamlesh Kumar, my lord.
page
And at
one
page
thirty-four and
134,
page
Kamlesh Kumar.
125.
My lord, the
Same
petitioner
officer.
before, my lord, is a 77-year-old man. His wife is suffering from cancer, my lord. They are making him come to his office every day and doing all these things.
Any period of limitation under 154.
My lord, the period of limitation, if I make an application, is, my lord, 4 years.
And
My lord,
suo moto there
if
is
I, but no I have not made any application.
no suo moto there is no period of limitation.
Suo moto, there is no period, but it is assumed it can be made within 4 years.
All right. Yes, anything more?
My
Any-
lord, I have twofold prayers before my lord. First,
Yes.
this order must be quashed. And secondly, my rectification application, which is pending, my lord, which is at page. My lord, gives
You
me a
have filed
moment.
application for rectification of which order?
No, my lord, I filed a revision application against the order imposing penalty also.
Order imposing
Which is at
penalty,
100.
that is the order imposing penalty in which order?
My lord, when the assessment order was passed, my lord, penalty proceedings were initiated. Pursuant to that, my lord, penalty order was passed and a penalty was imposed upon me. Against the penalty order, I preferred a revision
So
application.
if this order at page 133 is set aside and 125 is restored, there is no question of any penalty to be levied.
My lord,
So-
but the penalty order stares at me, my lord.
That is a different
Unless
thing because
I have it set
that-
aside.
that might be because the earlier order was passed.
Yes,
So
my lord.
after that, this order of the Honorable High Court has come. Thereafter, 154 first order has come. No, thereafter appeal effect order has come.
Appeal effect order.
So, yes, so now you are challenging this order at page 133.
Yes, my lord. This is also I would pray the revision application may be disposed of, my lord. It is
That is a different thing. Yes, yes, Mr. Singhania.
Lordships. Though I have the part instruction only over telephone, Lordship, the fact is quite different. Now, assessing officer pass an order under section 143/3 is one aspect. Now, against that order, assessee appealed before the appellate authority. Now, appellate authority makes some observations and remand to the assessing officer for fresh determination. Now, against that order, they preferred an appeal before the income tax tribunal. The income tax tribunal upheld the order of the appellate authority. Now, they preferred and before the Honorable High Court. Now, two questions arose before the Honorable High Court. That is the substantial question, whether the appellate authority has rightly remand back to the assessing officer for refresh determination. Now, page 96, your lordships. And we come to page 96 portion. 90.
96 is the order of the High Court.
Order of the High Court, the portion.
Yes.
Now, Honorable High Court, let's say first paragraph plus 2 line.
Yes.
In light of the statutory embargo, the order of the remand passed by the CITA is not tenable in law and consequently the same required to be set aside, as well as the order passed by the learned tribunal. The learned tribunal's order and the CIT first appellate authority is gone. The assessing officer's order is uninterfered, your lordships. Because, lordship, because
So Singhania, it says the order of remand.
Yes, my lord.
Remand
I'm
part
ready.
is set aside.
remand part set aside means in appellate order, assessing officer demand raised from some 80 lakhs and odd for the appellate. On that part, 3 lakhs and 60,000 rupees is the deletion amount. Appellate authority says, you know, you have wrongly added the 3 lakhs rupees in one head and 60,000 rupees in one hit. One hit.
Why is he going?
Then only that part set aside by the Honorable High Court. If I am gone through the entire episode of the Honorable High Court, the two questions. Substantial question is to your lordships, whether on the facts and circumstances of the case, learned tribunal was justified in upholding the order of CIT when the same is beyond the scope and power vested upon CIT under the provision of section 251 1A of the said Act. Whether the facts and circumstances of the case when the addition made in respect of the Sunday creditors, namely Messrs. Goodwill Corporation India, Messrs. Quality Udyog, Mr. Swastik Trading Manufacturing were directed to be deleted as being unsustainable can be subject to the inquiries conducted by the assessing officers. Now, assessing officers' entire order has not gone, your lordships. Now, in the meantime, assessing officers.
Assessing officers, entire order has not gone.
No, lordship.
So some portion has gone.
Some portion
Has gone.
addition,
If
and
that
no,
is gone.
that is no, lordship.
Mr. Singhania, there are two
Lordship,
aspects.
one minute. Now, after the passing of this order, now in this order also, Honorable High Court observed that that's required a fresh hearing after by the appellate authority.
Okay.
And that is pending. That is pending. The one part.
Yes. So, and the appeal is pending.
Yes, lordships. Assessing officer's order now again pending
So
before
according to you, your submission is that the appellate authority has to decide
the
the appeal
yes,
in terms of the order passed by the
passed
by
by
the High Court.
passed by the High Court. Now,
So-
there is the another
So
proceeding.
now my question is before you, if an order of an original authority
Lordship,
is challenged before the appellate authority
lordship,
and the appeal is pending,
lordship,
what is the effect of the order of the original? authority?
lordship. I'm
What is the effect? I'm
Lordship.
asking you, please.
Lordship, if there is a
Not in these facts. I'm giving you a
lordship,
hypothetical
if
example.
the appellate authority passed any stay, your lordships, then your lordship, the order was stayed. If the appellate authority did not pass any stay order, now the assessing officer is free to proceed in accordance with law. If the appeal is succeed, then SSC are entitled to refund back if they paid the amount with
So if
interest.
you're under 154.
150, I come.
Without notice you can enhance.
Lordships, I come on the later.
Without
Lordship, I will
notice, you
come.
can enhance.
Lordship, I will come. That is not the enhanced amount. Now, your lordship, in this proceeding, another proceeding is the
বলছি?
penalty proceeding. That is annexure P5, show cause notice and order.
Page.
104 is the order of the 271-1 and earlier show cause notice on the basis of penalty.
But this is a
provision.
penalty order, penalty notice and penalty order. My lord, my learned friend is confusing himself.
No.
I must
I'm
respectfully
not
say
confused.
so.
Allow us. Show cause notice is 101. That is the penalty provision.
Penalty.
Yes.
And order is 104.
Yes.
Now, your lordship, as per the order of the first appellate tribunal's order, some portion is deleted. In accordance with that, assessing officer passed the order, which is first passed the order for and issuing the remand amount, refunded amount, with giving effect of the appellate author. Now, this order, at the Income Tax Act, the assessing officer, as and when any refund amount was processed, then before the refund amount, the file placed before the CIT. Now, ACIT or CIT. Now, in this case, your lordships, with the observation, it is not giving effect as because as the assessing officers, first assessing officer is unfettered, appellate's order and the tribunal's order, appellate's order, first appellate authority order is set aside by the court. So, this amount is not refunded as yet because this is under challenge. The appellate of the assessing authority and the P11 lordships, as the assessing officer, first assessing officer's order is unchallenged, uninterfered, your lordships, and penalty was imposed by and several proceedings. Show, your lordship, amended. The P11 is the rectification of the order of appeal, effect order, which was passed in pursuance of the Honorable High Court's order first order, not effect, this is a rectification of P11. In this case, your lordship kindly consider P11.
Page.
In this case, 133, I am gone through it.
Yes, 133.
133. The case of the SSC was completed under section 143 of the IT Act 1961 dated 31st August 2016 at an assessed income of rupees 85,42,009. Being aggrieved, the SSC preferred an appeal before the learned CITA Siliguri. Subsequently, the CITA National Faceless Appeal Center passed by the appellate order by such and such number in appeal CITA Siliguri and allowed certain relief. Certain relief, your lordships. The order was here. Aggrieved by the appellate order of the learned CITA, the SSC preferred second appeal before the Honorable Tribunal, and Honorable Tribunal upheld the order of the CIT without deciding the substantial question of law as to whether the CIT was right in satisfying the order of the AO. The SSC then filed the appeal before the Honorable High Court and raised the grounds that the CITA exceeded the limit of power statutory based towards as per section 251(1)(a) of the Act and grossly erred in law in restoring the case of the AO for action in terms of such and such. In this case, the Honorable Jurisdictional High Court of the Calcutta, by order and such, has set aside the order of the Honorable ITAT Calcutta and the CITA NFSC order under section 251 dated such and restored the manner back to the file to the CITA for fresh adjudication. As the Honorable High Court had decided that the learned CITA has erred in law by remanding the matter to the file of the AO for fresh reconsideration. Considering the above fact, the impugned assessment order of the assessing officer passed under section 143(3) of the Income Tax Act dated as such remained uninterfered and still remain in force, and as such, the question of issue of remand does not arise. But in the appeal effect dated 3 January 2024, high order under section 268, reduced section 143 of the Act under D number such dated such as a refund of rupees 12,18,000 odd amount was raised, which appears to be gross mistake, which needs to be rectified. As such, appeal effect order dated 3rd April 2024 such is hereby rectified as under. Now is a head. SSC amount, relief amount, revised amount, rounded off is the amount that is the order, your lords.
You have
That is the
exercised
question.
power under what provision? This order was passed.
As per the order of the Honorable Court,
No. Under what provision you have passed this order at page 130?
lordship is the revised order, your lordships.
Under what
The
provision?
revised,
Under what provision?
lordship, I check up, your lordship.
What you will check up? It is apparent from the order. You are saying gross mistake, you are rectifying. You are rectifying another order. So you are rectifying an order.
No, lordship, I will state
This
it.
is the order.
This order, the
Sir, it's under
order is uploaded
Is
but
it-
not
is it
affected,
not
your
an order
lordship.
under section 154.
No, your lordship, 154 process.
Not under 154.
That is the enhancement and others, your lordship.
Please come to the tabular chart.
Lordship,
Please come to the tabular chart at page 133.
133.
Yes, last DIN number. What is this 154
That
stands
is
for?
the D number,
Yes.
Yes, I'm grateful to your lordship.
This is.
lordship.
Mr. Singhania.
I'm grateful to your lordship.
You have
But-
yourself specified it's under 154, and if you say it's not under any provision, it's liable to be set aside on that ground alone. Liable to be set aside on that ground alone. Because you are rectifying another order.
But this order was not
If you say
affected
it was
because
not under any
because-
provision,
earlier order, your lordship, the refund amounts order was not affected, your lordship.
so you have rectified that order. So earlier order at page 125, you have
But your
rectified.
SSC is not entitled to refund at this stage,
Maybe
your
Mr.
lordship.
Singhania, I'm not on that, whether he's
Lordship.
entitled to refund, whether he's
Lord,
you are
lordship,
liable to
lordship,
pay penalty, I'm not on that.
lordship,
So 125
lordship,
has been rectified at
Lord-
page 133.
lordship,
Under what provision?
lordship, then your lordships, my proposal, your lordship, subject to corrections. I use the affidavit, stay the order as a
What
limited period, your lordships.
What evidence? Mr.
Lordship,
Singh, for what? For what purpose?
Lordship, some documents and other facts I am
What
enumerated by
document
the
will you
affidavit, your lordship.
Mr. Singhania, it's a
As
point of
because your
law.
lordship assessing first assessing of order, your lordship is in force. So question of
yes.
refund is not arise at all.
All right, I will consider that whether the first.
And your lordship, penalty and assessee is liable to the order as per the penalty provisions order. He liable to pay your lordship the amount. Two question, either.
That you.
And your lordship, for the recovery is a limitation. So your lordship, this order was passed.
You recover, I'm not stopping you from recovery.
But your
Just
lordship,
recover.
if your lordship revenue department within the specified time did not pass any order, now subsequently, and that keep in this file, your lordship, sit in the file, then your lordship, after that, after all the proceeding, I presume your lordship, then recovery is got by the limitation.
I'm not saying anything about the recovery. I'm only on this order at page 133.
Lordship,
I'm only on this order at page 133. And the reasoning is contained in that order, nothing more than that.
133, the order.
but this order is not, this order for
And you have said
rectification.
the appeal is pending, Mr. Singhania. I will record
And
your
yet-
submission.
Lord-
Appeal is pending.
Lordship, there is no instruction,
You
but
have said
the-
in your submission, appeal is
Lordship,
pending.
Lordship, in 33, they say your lordship and restore the matter back to the file of the CITA for case adjudication.
My lord,
My
Whether
submission,
appeal is pending or.
case adjudication, your lordship, as
My-
per the order, as per
I'm
this
asking you
order,
whether the appeal is pending before the appellate
Lordship,
authority.
lordship, then I'll come back 12, your
my
lordship.
lord, may I
No,
please
madam.
your lordship?
At
12,
2 p.m. Come at 2 p.m.
My lord, may I please your lordship?
10 to
Yes.
PM.
My lord, learned friend, my lord, with deepest of respect, my lord, is trying to sit over the order passed by the Honorable High Court at Calcutta, my lord.
Mr. Rachodi, one thing is, according to Mr. Singhania, the effect of the order of 260 capital A is reviving or restoring the appeal with the appellate authority.
My lord, it cannot be so. There is no specific direction in the order of the Honorable High Court, my lord. The Honorable High Court, my lord, on the other hand, has held.
Let
My
me,
lord,
let me check up,
on
let it
what-
come with the instructions whether the appeal is pending before the appellate authority. Let me
My lord,
check.
no appeal is
But
pending
I-
before the
He made
appellate
this
authority.
submission when I asked him, he wanted to take instructions.
Lordship, I'll confirm. with that.
2 p.m.
My lord is at, কখন হবে?
2 p.m.
2 p.m.
Yes,
Okay.
today.
Lordship.
Yes. And Mr. Singhania, if that is pending, tell me the stage when is the next date of hearing for the appellate
Lordship,
authority.
I've already intimate sent to the one-page instruction and they stated lordship what
my
3:30
pending
or
with
4
you.
today your lordship they sent.
All right, so take
I have
instructions,
already
what is the
intimated.
next date, please?
Lordship.
What's the
My
date?
lord, appeal is not pending, my lord.
Let him, he says it's pending, he has instructions. Let him take instructions so that,
Lordship, there
because
is
he
no
is a
pending.
creature of instructions, so.
My lord, I understand his difficulties. I'm grateful to your lordship.
Just call the next matter.
I am for the petitioner, my lords.
Yes,
I am aggrieved by my lords a decision taken
he's
in a.
opposing you.
Lords, I have served the office of the Deputy Solicitor General DSG.
Where is Mr. Singhania?
Item 4.
Item 4, you are appearing.
কি আছে দেখো?
Union of India, you are representing.
Lordship in all matters.
He is the Union of India.
He is so you are the Union of India, your learned friend says.
Yeah, he is the de facto DSG.
State of page long Mr. Phone state of SSB.
Yes,
No, no, this is a matter relating to Union of India.
yes, ma'am. This is a tender matter.
Appeared, but okay, and let's tomorrow.
State, you are appearing.
No, 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 no. State is not a party here.
State is not a party.
The party. They copy them. Lordship can I tomorrow. I have no brief, your lordship.
Union of India is without brief.
But SG office the brief as and when.
I would have sought for
What
a
is the date in the communication letter?
Lords,
You have
we
mentioned?
have served it on 4th of April.
What is the date mentioned in the communication letter when it will
Yes.
appear?
RA
Eight.
Enterprise versus the government
You have served
e-markets.
in the office of the Deputy Solicitor General.
Copy করতে হবে কি अधिकार?
The original is handed over to Mr. Singhania.
আমি এখনই 4
Lords, I would have otherwise preferred for a interim protection because the financial is going to open. I have been rejected in the technical.
You're rejecting the technical, when the financial bid will be opened.
They will tell it. It can be done any moment. And Rule
What is
26
the
exemption
ground
I
of
have also
rejection?
sought.
What is the ground of your
Yes,
rejection of
the
technical
ground
bid?
of rejection, my lords will find is at page 88.
No, tell me. because you-
Cartel bidding. Cartel bidding. Cartel bidding. But that is
That
not a
is
valid
going
ground,
on
lords.
in all
I
tenders.
will satisfy my lordship. It is not a valid
That is
ground.
going on in all tenders.
No, but this is not one of those cases, lords. I will satisfy my lordship on that. Tomorrow, some preference, my lords. Even today, my lordship, item number 4, let it be retained at the same position.
Third, planner advocate for the petitioner, from non-appears for the respondents. The Singhania, who usually represents the Union of India, is present in court today and is requested to appear in this matter. Let a copy of the petition be served upon Mr. Singhania. Mr. Singhania, we are appearing along with the junior.
No, Lordship, learned senior. Learned DSG, your
No,
Lordship.
no. Do you have any junior?
No, Lordship, not allotted by the union.
Let a copy of the petition be served upon Mr. Singhania, learned advocate. In course of this day, let the appointment of Mr. Singhania be regularized by the competent authority. This matter tomorrow.
Lordship. Copy de dena apne ko, हाँ?
Yes, next.
I am for the petitioner, my lords. The
Yes.
matter, my lordship, pertains to my lords state examination for primary teacher, my lords. The
Yes.
examination, my lordship, was held in 2015. And my lords, the results were
What do you
published in
want
2016.
now?
My lordship, I have missed a counseling session. If I can have my lords for a moment on my lords.
When the counseling was held?
The counseling, my lords, was held on 1st and my lords
1st of
31st
31st of
January 2025, my lords.
January.
Yes, my lords. And I was ill, my lords. Page 41 is my medical document, my lords. And on
Yes,
top
what
of
is the stage
everything,
of counseling now?
I have been informed, my lords, that the 5th round of counseling,
Fourth stage of counseling has already been done.
fifth is
So
yet
can he
to
be
be done.
allowed to participate in the fifth?
Yes, it
round?
can be because, my lords, if I can have my
From
lords.
when it will be started?
Now the list, the selection of the 4th round has already been completed. Now
Yes.
it's going to be 5th round.
So fifth, can he not participate in the 5th round?
They can allow me to participate, my lords. Otherwise, those who are below my rank,
And if
they will get an
fix it
opportunity.
tomorrow, Lordship, I will come with the
All
instruction.
right, take instructions in the 5th round because
Lordship.
in the earlier round he has missed his chance. So in the 5th round, the prayer of the learned advocate for the respondent discuss matter tomorrow. Yes, next.
I am deeply.
Next.
I'm led by very additional advocate general.
This your
That is the-
lordship,
He's in the virtual mode.
My lord, I am here, my lord. I am here.
Millard has considered this, Millard, on the earlier occasion. Millard, I was only, Millard, trying to impress upon your lordship,
What is
Millard.
this matter?
Millard, this claim of pension, Millard, who apparently, Millard, admittedly is a state government employee. So a question of jurisdiction was raised by Mr. Chaudhary.
Yes.
Millard, I was only impressing upon your lordship, Millard, that since the administrative tribunal, Millard, is virtually non-functional because only one bench is there by a non-judicial member. Now, Millard, I'll just place a order passed by a coordinate bench. If Millard, can you take note of this? Millard would
Please hand over the copy to my learned friend, Mr.
turn over at page, Millard, internal page 2.
Yes.
The fact
How
remains that
you
the
will
West
see
Bengal,
if you do
the
not
fact
hand over?
remains that the West Bengal State Administrative Tribunal is virtually inoperational as there is only one bench comprising of only the administrative member is functioning. There is no chairman or judicial member to the tribunal. In such circumstances, in view of the ratio laid down in Roger Matthew, I am inclined to exercise the jurisdiction vested on this court under Article 226 of the Constitution in granting reliefs. Now, Millard, I am only saying this, Millard, this is a claim for pension. Millard, probably, Millard, considering the Millard, it is not an
They have to take a
adversarial
decision
litigation.
on
They have to take a decision. They have already granted an interim PPO. They have to give me the final PPO. That's all, Millard. It's not an
Yes.
adversarial litigation. I don't know,
My lord,
Millard.
I am not.
That the tribunal is virtually not functional.
My lord, I am not. I am not strictly on that, my lord. Because the efficacy as alternative remedy, it falls within the word of efficacy, though alternative. So I'm not my lord, hunching on that. My lord, kindly see what my learned friend is seeking for.
Yes,
My lord, the learned friend is seeking for the entire pensionaries benefit to be released.
yes.
Now, my
No,
lord,
no, I am asking them
No,
to take a
you take a
decision.
decision.
no, my lord, just a second.
Yes.
The prayer is that, my lord. Let me.
Yes, yes.
The prayer 1 and 2, my lord, kindly see at page, my lord, 20, my lord, 2017. The lordship will find these are the prayers.
Yes.
Now, my lord, what happened? My lord, the criminal case has been initiated pursuant to, my lord, an application before the Honorable High Court at Calcutta, my lord, by a petition of habeas corpus. CID, my lord, the CBI has caused an inquiry and found him a guilty. Then the my lord, the FIR was registered. The case, my lord, the sections or the charges which has been brought against him, my lord, are the, my lord, more than punishment is more than 10 years. 304 surplus 2.
Yes.
Now, my lord, what happened that my lord, the case is still pending. It has
Criminal
not been.
case is still pending.
My lord.
Yes.
Now, in the meantime, the pensionary, as he is supposed to retire, all the, my lord, the papers were sent to the, my lord, the competent authority. Then competent authority had raised certain queries. Then, after evaluating the entire, my lord, evaluations were made on the basis of the documents placed by my learned friend's client. Then the offer was given to him that interim pension can be because he pleaded because of his
Provisional pension. That is
yes,
provisional pension.
provisional pension. And then he has agreed upon. Malad, kindly come to page 44. 43 was the request.
Kindly be processed.
Malad, 43 is the page
Yes,
of Malad, 43, Malad.
Yes, 43, 44 I have seen.
Yes,
But
Malad.
45, they have said that it is admissible.
Yes.
His authority.
Yes.
Malad,
Kindly see 45.
Yes.
Then, Malad, then Mr. Ghosh, what is the purpose of to address this honorable court?
Yes.
You are addressing on behalf of me.
Yes, yes, learned additional advocate general. Yes, you can proceed.
Malad, this 43 and 44, Malad, 44, he said that these pensions, the interim pensions, he is accepting. Subject to these are these others. Now, what Malad 45, Malad 45, what Malad 45 said, it is written by the Malad from the Siliguri Police Commissionerate to the Accountant General. Malad, may I read?
Yes.
In reference to such and such respect of pension case of Ramchandra, it may be mentioned that no departmental proceeding vigilance case court case is lying pending on the moral turpitude ground against Sri Ramchandra Singh from the end of the department. The criminal case mentioned in the pension file was, however, initiated by the third party and does not involve with the regular pay and allowance of Ramchandra Singh in the matter filed beyond the purview of Rule 14 WBS. DCRB Rule 1970. In view of the above, superannuation pension case, including issuance of authority of pension management, may kindly be processed. This was the request made to the Milord by the from the Deputy Commissioner sent to the Milord, the Principal Accountant General at page appearing at 45. Now, Milord, what is the reply, Milord?
The next paragraph also, please, kindly.
Yes.
All right, let me read. However, to overcome immediately financial hardship of the incumbent, interim allowance suggested in the above cited memo, senior accounts officer may be sanctioned immediately on purely temporary basis.
Yes.
Till the issuance of final pension payment order, all earlier papers along with the revised single comprehensive form is attached herewith that may be ignored on admissibility of superannuation pension.
Provisional pension has been released.
Milord.
Provisional pension has been released.
Yes, yes.
Now, Milord, Milord, what happened? Thereafter, Milord, the Milord, kindly come page 50.
50.
Yes, Milord.
Yes.
Milord, the letter addressed on 23rd August 2023 by the Milord Senior Accounts Officer of the said department, Milord, addressing to the DCP. commissioner. My lord, I have to read full because my learned friend will say I have read half. So in inviting reference to this office letter number such and such, under which administrative interim allowance in respect of she issued with some observation. It may please be confirmed. Next paragraph, whether Sri Singh was acquitted from the criminal case under CR case number such and such arising out of case number such and such, if so, supporting documents may be furnished. If not, specific sanction for interim allowance not exceeding 29,567 with effect from 1st March may please be accorded and forwarded. Single comprehensive form showing class of pension such and such also may furnished. So in response to that, Milord, this was the observation. Milord. Now, Milord, the next page, 51, again on the basis of such correspondence, Milord. Then the second paragraph, he said, petitioner herein before you, my lord. Further, I would like to inform you that such interim allowance is without prejudice to my rights and contention towards my final pension gratuity others. Then, my lord, page 52.
Yes.
Page, see the page 52. That, my lord, it was written by the same police commissionerate. Then, with reference to the such and such memo, allows for an amount of 29,500 per month with effect on this unit, along with the following documents, it has been accepted. So, my lord, the page which my learned friend is impressing on, page 45, which is written by the commissionerate, my lord, that he do not fall or he doesn't fall within the case of moral turpitude. So, my lord, the 14 WBS rule would be applicable. Now, my lord, the competent authority, my lord, the principal accountant general, my lord, had clarified. And then again, he has accepted by page 51 that accepting of 29,567. And he is accepting. Now, my lord, the considering the what representation would be considered. Now, my lord, kindly can page 57.
Yes.
Now, the page 57, my lord, what the contention is that he is facing the hardship. 1, 2, 3, 4, 5, 6, 7, 8, 9. More than half a dozen of lawyers appeared on behalf of him before the Honorable Apex Court, my lord. And but a lighter note, Mr. Ghosh is also an expensive, my lord. Now,
probably I cannot prove this. This is a so moto matter I am doing.
No. That is
He is
lighter
not
note.
doing.
Mr. Ghosh, lighter note, I said.
A matter of pension, Millard.
Yes.
So, Millard, this Honorable Supreme Court, Millard. So, what is the habit, Millard? The Millard jumping without following the process. Here, Millard, jumping here without following the due process. The tribunal is there, though I'm not. He has approached to the High Court, maybe pursuant to the direction of the Honorable Supreme Court. Maybe. So this is the reason, Millard. Perhaps I thought that my learned friend will take up this issue that person is direction of the Supreme Court. I approached to the High Court. I have approached. So this is the reason, Millard. So now the Supreme Court said, no, it cannot be interfered. You go and approach to the High Court.
According to you, there is no scope to consider his claim now.
My suggestion
because you have taken a decision.
Yes, my suggestion
you have taken a decision that since the criminal case is pending, only provisional pension can be released, not the full pension.
And he has accepted, Millard. That is after acceptance, Millard.
Yes,
Millard,
Mr. Ghosh.
Millard, then let him, Millard, by way of a short affidavit, let him explain. 2 persons were implicated in the same case. Why the other officer has been favored with the full pensionary benefit?
My lord, now. I knew that this question.
Only one minute. The point is whether in the pendency of a criminal case.
Millard, not connected with service, no moral turpitude involved. Millard, the Supreme Court decisions are there. Millard allows one day, I will come back and show.
So let them
pension cannot be withheld.
file affidavits.
Let them file affidavits.
Yes.
Let them file affidavits.
My lord, if you see what my learned friend, that's our reply.
Let them file affidavits that in such circumstances, final pension can be withheld.
One is Mr. Pradyut Das, who was then the inspector in charge of Siliguri police station. His involvement here by a CBI inquiry and subsequent registration of FIR is a punishment imposed for wrongful confinement for 1 month and exceeding up 1 year.
Same with
just a second, Mr. Ghosh, why I did not So let me reply. I know that because you have the request for us affidavit, we will exchange it. Now, Mala, how and he is 304 sub clause 2. It can be a parity, Mala. That's all, Mala.
All right. The petitioner has prayed for release of full pension. Full stop. Paragraph. The learned additional advocate general submits that a criminal case is pending against the petitioner, and for such reason only a provisional pension has been sanctioned. Stop. Mr. Ghosh submits.
Instead of affidavit, if it can be a report, so that it remains in the motion. It's a matter of pension.
Mala, in a form of report, nothing can be disclosed. It is a bypass method. Always we adopt. I do not want to adopt this bypass method. Full-fledged affidavit I will use. Let Mr. Ghosh
Submits that since it is not a case of moral turpitude, the pension of the petitioner cannot be withheld. Could not have been withheld. This court feels that such an issue has to be decided after a report in the form of an affidavit is called for.
Grateful.
Malad, report would be I will deal the paragraphs, Malad. Report, and then I will take Malad the report the same time. At the same time, I will take a time to file to prepare the Malad the affidavit in opposition. So let it be full-fledged hearing be made.
Only after exchange of affidavit. Let affidavit in opposition be filed within 2 weeks from date. Semicolon reply thereto, comma, if any, comma, be filed within a week thereafter. Parties will be.
Malad, can it be 3 weeks? Because the AG, Malad, Accountant General, this is the reason, Malad.
2 weeks.
2 weeks, 2 weeks. Oh, 1 week. My reply 1 week.
3 weeks, 1 week.
Same, 2, same is 4. Grateful, Malad. Much happy.
To pray for inclusion of this matter immediately after expiry of the time.
Grateful, sir. Extremely grateful.
Point of
Grateful, Malad.
That is so I could not have.
No, Malad, Mr. Pal, leave it. Because
that point, I will have to decide that point.
No, Mr.
You are taking that point.
Malad, if you see the Supreme Court's order, Malad, that's why this is the reason I do not. Malad, let it be decided. I do not want to go back because in any event, if he goes back to the tribunal, matter would be heard by the tribunal. Then again, will come back to the High Court.
Yes.
So I am not. I am on merit, Malad.
So not on maintenance.
I'm on merit, and I leave it to your lordship's decision.
All right.
Malad, my one indulgence, Malad. The
Yes.
item number 22, Malad, kindly fix it at 2 p.m. Malad. 2 p.m. or any subsequent time, Malad, because if it is reaches by this time, I will not be able to reach Malad Jalpaiguri.
22.
Yes, Malad. Which I said
Who
that
is assisting you? Who is assisting you?
my Sumit Kumar, my junior will be there.
All right, ask him to.
Yes, Malad. Mr. Ray is my other hand adversary, Malad.
Yes.
Almost Ray, Malad.
Yes, call the next matter.
Grateful, Malad. With your lordship team, I am leaving, Malad.
Yes. Yes. Then now you are physically present. Yes.
My humble prayer will take item number 9 first. 7, 8, 9, I didn't share.
9. Saka, you are appearing in all these matters.
No, I am appearing in item number 7 and 9, madam.
9 also you are.
Yes.
All matters can be taken. I'm not seat, but the issue starts.
Yes. But the volume of the writ petition does not say so.
When the documentations are not accepted, then we have to attach everything that we have attached there.
Yes.
What is the main crux of the matter here? The input order of appeal has taken the whole eye of the small business
that one of my suppliers in the global field, that person's certificate of registration had been cancelled in the retrospective effect. It is an admitted fact that at the point of time when I made the transaction, the RC was valid. Now it has been cancelled. Now what has happened? The authorities have gone down into completely irrelevant considerations. What are the considerations? I'm sure, but completely irrelevant. My only humble submission on day one, in rely others, and then only one, that once person comes the supplier has filed his CSTR one, my 2A has already generated. I have made use of that 2A, paying that credit. More clearly, the suppliers even paid the taxes by filing CSTR 3B. All other questions become innocuous. All these questions cannot be asked any further. The government has received the tax. Thereafter, the government cannot sit over my tax. Your lordship said, I will quote your lordship. Lordship now kindly comes to page 107, that is the appellate order. Operative portion will be one.
So 107 appellate order will suffice because it has taken into consideration the. So this order is applicable before the tribunal,
Yes,
and
but the tribunal is not
functional.
functional.
Final.
107, the order of it starts, but lordship will kindly take from 122 because they have cited the whole.
122.
On 122. Prior to that, they have simply copy pasted my statement of that.
All right. So consideration is at page 122.
One thing.
Yes.
Third thing, and what to written sir. Grounds of appeal and the order of proper officer and PO order. Observations are noted below. Regards to non-existence and no business activity in the extent place of business of the instant supplier. Measures global victim. The latter day has subject the supplier has challenged the rejection order of restoration of arts in Calcutta. But where it is submitted, the case is still pending in the court. Hence, the findings of the respective charge authority with respect to the existence of business activity of the supplier is still valid and not proved wrong in the book of account. Carry here for a rest of that. Completely rest of that. Whether these RC has been cancelled or anything else cannot be the cup of tea in this actually. The question is whether he had paid the tax or not. And the answer is he has paid the tax. Then why going to? There. With regards to the objection raised by the administrative authority, some of the consignment notes produced, rate is mentioned to be paid by the consignment. Hear that? That they have failed to provide any documents or books to the rate has been discharged by the applicant. According to this, submitted the transactions were done on F4. But most of the agreement has been provided on demand. In the transactions remain down. Okay, carrying the forward. First, what they say that I could not prove that the transactions of the transportation were taken care of by the supplier. So I have made it an F4 basis. How on? What to pay it out 65 months?
Yes.
This is an appellate of it. Driving resort. This is a certificate issued by global beginning. What does the certificate say? This is for your kind information that in the year 1899-1920, we had sold the caption farm. As per invoices mentioned below, we have supplied the food at delivery point that is at their site, and transportation costs were borne by us as per the delivery terms. Hence, entire transportation costs were borne by us. The details of invoices given. Next page, my lord. The ledger is given. And
Yes.
the next page, PSTR 2A, the copies of PSTR 2A attached.
Yes.
Everything was there before the appellate authority. And the adjudicating authority, unfortunately, nobody bothered to bring us next. There are. Paragraph 2.
Yes.
With regards to the objection raised by the adjudicating authority of non-existence of measures harmful to some transporters who is appointed by my supplier. Now they will say the transporter does not exist. I do not know how relevant it is.
the appellant is not liable with respect to the existence of the transporter. They further submitted that the transporter might be shifted, might be shifted his business after the transaction made. But in the consignment law, claim to be issued by the above transporter, this claim of the transporter declared so and so from the proposal side, no recordings. So I fail to understand what is the requirement. Even if that person was registered at that point of time, later on that transporter has deregistered itself, does it bother my claim? I fail to. There. From the above observations, it is evident that the transactions are dubious. Now comes the infallible conclusion of the review. I do not know from that. When the supplier is non-existent, and he has no business activities in the same case of business, and even when the transporter is also dubious later, how the same transactions are occasioned with that when the questionable, they are fixed to expense. Now we are telling here for a moment, they have accepted tax on the same supply when it was paid by the supplier. If they say there was no transaction, let them refund that tax. Or give me the input tax credit. Thereafter, what does the Remand adjudication authority deny the ITC to appellant for failure of the genuineness of the transaction? Appellant failed to establish the fact that he has actually received the same goods, which is one of the infinite criteria of saving ITC. Now again, I will trouble your lordship and invite your lordship to pages 44 to 59 of the report. It is the delivery channel that given. What else should have done for the person to be followed? I asked. But the pen tells each and every tax invoice I have produced, along with delivery channel with e-invoice, with the e-webing. Right from page 44, each has been coordinated and corresponded. Page 44, the first tax invoice. Page 45, the next tax invoice, 46. Yes. And thereafter, what should be kindly take?
So according to you, these documents were not taken into consideration. So they have not considered those documents.
Yes, and another. There. Now they go to economy. Economy is not at all applicable here. Why it is not at all applicable? It is again beyond the purview of the scope of this adjudication procedure. But if you were to not here, I will address that.
Yes.
Next page. In the case in hand, the petitioner has only brought on record the tax invoice. Now, tax invoice, which is also come challan, e-way bills, party that payment to bank together, but no such detail of payment of state charges.
No, I think this is quotation of that Allahabad judgment, not in your case.
Yes.
This is quotation of this Allahabad judgment.
So, yes.
In the case in
Yes,
hand
and
is
there are,
that.
no, I'm doing this, that they are pending on this part. But it's the, why is it there? In instances, RT has failed to prove payment of claims, where he has failed to produce the payment of rent charges and acknowledge the payment. I produce the whole person who are not believing because it's not very respectable. That is a sort of argument produced. And thereafter, once again, it has been, the LTW has been put in, and as a result, all the LTW favors me. As a result, the original, now Lord, I have placed the whole operating part of the order. Now, Lordship, I'm candid that Lordship.
Where is the order of the original authority? Yes.
Lordship had not find anything on GSTR one or GSTR supplied by the furnished by the supplier. Lordship, I can down the page, comes to page 127.
127. Yes.
From page 127, in page 146, the whole GSTR one is annexed, it was produced there. Again, from page 147 till page 158, 3B is also there. My humble submission is this: once it is produced, showing payment of tax, there can be no case to hold my credit. And this was again your lordship observation. Because your lordship observation is now reported that way. 122 GSTR 87. Also necessary online. Lordship favored Lordship kindly see the operating paragraph, page 2, Lordship kindly takes.
Yes.
Mr. Bhattacharya, the learned advocate for the petitioner refers to the copy of the return from the sheet of the supplier for the petitioner may be which has been annexed to the petition and submitted to the same supplier, filed his return to the period so and so and so. It submits to the appellate authority did not take into consideration the return filed by the supplier for the period so and so while passing the order dated so and so. Or Mr. Agarwal, who is equal to the subjects. That is the event of the petitioner is able to satisfy the authority, the same supplier has filed the return for so and so. Then the petitioner should be indicted. The court cannot decide as to the off or short. And therefore, for the reasons as aforesaid, this court is considered to that the interest of justice will be such a if petitioner is given liberty to produce the document and the appellate authority directed to review the order. Here the only difference is I have already produced. And
Not considered.
never. In fact, I should use
Where is the order of the original authority?
I would use the term that royally unworks of what I did.
78.
Page 70 goes to 90 comes.
78.
Yes.
Here as well. 79 will be essential. 79. The paragraph, third paragraph from the top.
Yes.
In response to the reminder notice, your cry of the representative of the RP appeared for hearing and for submission and documents which are as follows. What are the documents produced? RP has submitted, RP is in possession of tax invoice, e-way bills, transport documents, bank statements, bank ledger. What else could I like? Thereafter, goods have been received by the RP. Payments have been made to proper bank. Supplier has submitted all the returns pertaining to the same period, which is also reflected in this year to be filed by the supplier. What details I think on this? The question I asked myself.
And page 81, it says that the case on hand, the petitioner has brought on record the tax invoices.
Yes.
E-way bills, party ledgers, payment through banking challan, but no details as to freight acknowledgement. So this is, so suspicion is being created with regard to the movement of the goods.
Absolutely.
Or whether the goods were actually received by you or not.
Right. Now, if the goods have not been received, then they should not have accepted the tax from the supplier vendor as well. Because
Actual physical movement of goods. Yes, anything more?
so my only humble submission is this, we have see the tax of that implied. What the rectification order and the appellate order maintains eloquent silence on the question that the supplier has furnished 3B and what is German. 3B means he has paid, without paying, he cannot find 3B. STR 1, that also can be said that yes, he has declared but not paid. But 3B means they don't do very shadow of doubt they have paid. And it is not a need. It is not a need. So he has paid either by using of IPC adjustment or by using tax. That's my argument.
Yes.
My lord, as per section 16, my lord, it is important to
Create a deal.
start with
Yes.
eligibility and condition for taking input tax credit. And one of the condition is he has received the goods or services or both, my lord. And that is the condition on which the department is lying, which is not being able to be fulfilled by him, or he couldn't show adequate document to that score, my lord. Because the person, the supplier is not in existence, my lord. And
Not in existence at what point of time? Whether at the point of time when the transaction took place or subsequent.
subsequently, my lord.
So at
But
that
his
relevant
registration
point
has
of-
been cancelled from
but
initially. my lord.
Subsequent,
Subsequently, it has been cancelled.
not at the relevant
be,
point
my
of time registration. was
But
done.
he is also required to prove the fact that he has received the goods, my lord. With regard to that, the transport document which is showing, my lord, of the alien transporter, there is no such transporter. In that regard, investigation has been done by the authorities, my lord.
How the revenue is affected?
My lord, the thing
How
is
the
that
revenue is affected?
this point has not been dealt with, my lord. This point has not been, I am candidly submitting, my lord, this point has not been dealt with.
Madam,
But what
what is the object of giving ITC?
my lord?
It's that he has paid, that has been deposited, so he will take the benefit from the as ITC. Now, whatever he has to remit, he can make adjustment from that way. That is the whole object. So what you can say is that he might have paid to the supplier, but the supplier has not deposited.
My lord, that aspect has not been seen firstly.
But here, the Bhattacharya says those returns and those documents were produced.
But has not been considered.
So if you have not considered,
My lord,
that is the route. So if that is paid, kindly consider one thing.
my lord.
So there may be a case that there is no actual movement of the goods,
Yes, my lord.
not actual payment.
Yes.
Now,
No.
only by generating some tax invoices, he is actually not paying, but only showing some documents and then taking credit.
My lord.
But when there is a corresponding entry of deposit of this amount
My lord.
from the supplier saying,
My
you
lord.
cannot say nobody will do this without any transactions deposit.
This is
So you are only concerned with the revenue. aspect.
my lord.
So if the revenue is
My lord.
that
What is happening?
ascertained,
Certain cases have been seen of circulating ITC. This is not the case in hand. But what is happening, my lord? The
there is
supplier.
no allegation in this.
No,
case.
no, no.
So let
But
us not go into that. So here, the
My-
revenue aspect we have not taken into consideration.
that has not been considered, my lord. Whether the revenue has been paid and that is to be considered. That is one aspect, my lord. But even this aspect is
But
also
the other
important.
documents also what he has said that the
My lord.
seller has confirmed. Shoot those. Those also you have not considered.
That has
Yes.
not been considered.
No document you have considered. He has produced all those. I think he has also produced the delivery challans also. No
The thing is that the transport doesn't exist, my lord.
Maybe subsequently transporter does not exist. Let us take a hypothetical case. At that point of time, is it your case that at that point of time it was not there? But the revenue, the tax has been paid. Kindly consider whether without any movement, without any
Yeah, that is
transaction.
happening, my lord. That is happening.
But that is
Just the
not the
tax
case here.
invoices are being prepared, my lord. The fake invoices, the
Fake
fake
invo-
delivery challans are being prepared
Maybe
prepared,
fake
my lord.
invoices,
for
but
circulating the ITCs, my lord.
fake invoices may have been generated, but there will be no corresponding deposit in the revenue tax.
That is also happening. That is all.
That is not your case
Yeah,
here.
this is not the case. Which
So let us not go, when that case will come, we will consider that. So here you have not made out that case.
my lord, but those documents are required to be considered, my lord.
You have not considered that.
Yes, my lord.
All were before you. Mr. Bhattacharya, these
No,
were
no.
produced by you.
My
Show
lord,
me
it is
that,
he
you
says
have
that.
Yes, yes. I think page 79.
79. That. And all my.
Yeah, 3B has not been produced, my lord.
They are all.
Everything he has produced.
But that is not considered, my lord.
I would say. This is why you need to produce somebody else's ticket. It is for the.
Yes.
To see. No, how? How
The-
can I?
Yes,
How
it is.
can
The
I
burden
decide?
lies on you under 155. The burden
Madam,
lies
please
on
come
you.
to page 79. Page 79 has already filed his monthly GSTR 1, GSTR 3B up to the month of July 2019. So I think this is a transaction prior to July 2019. So if that is so, these documents are, you can verify all these things.
My lord, if it is sent back to the earth.
Because at the time of the show. Right from.
My lord,
So
as per this
before
judgment,
the,
as per this judgment, he has relied on, my lord. Jitendra Nath Roy.
there it was, I think there it was not produced, here it has been produced. Is able to satisfy has in fact filed the returns. But here it has been filed, documents are produced. It's on a much better footing. This application. Now, this writ petition is at the instance of a registered person under the West Bengal Goods and Service Tax Act 2017 and is directed against the order dated April 16, 2024, passed by the I think I'm looking at the wrong order. Where is the order of the appellate authority starting page? Yes, I think I was looking at the original. Minute 7.
Otherwise, the only problem affiliate of the judgment of the authority is the act. So, you know, my lord.
Yes, madam. My lord.
Adjudicating.
Adjudicating.
Where is the no, not the appellate order, first page.
107.
107.
107. কি বললাম? And is directed against the order passed by the Additional Commissioner of State Tax within bracket appeals, Shiliguri Circle, Shiliguri, West Bengal, dated January 20, 2025, affirming the order of the Deputy Commissioner of State Tax, Shiliguri Charge Shiliguri, dated April 16, 2024. The allegation against the petitioner is that the petitioner claimed input tax credit in respect of supplies made in respect of supplies made by, what is the name? Global. Where is that? Which page? 78. Page 78. Yes. Yes. In respect of the supplies made by Global Bitumen during the financial year 2019-2020. 2019-20. Oh, yes, yes. Where is the timeline? In the table. Oh, yes.
And the last one on its page is 8/7/29.
During the period 31/5, yes, because July they were.
July 31st till July 31st.
During the period May, যেটা বললাম না financial year 2019-10 না করে আচ্ছা ঠিক আছে, during the period such as, to be more specific, for the period from to be more specific, the date of invoice starting from May 31, 2019 till July 8, 2019, on the ground that the supplier was found to be non-existent and non-operational at the declared place of business. The adjudicating authority, by the order dated April 16, 2024,
held that the petitioner is liable to pay the ineligible ITC claimed and availed by him, along with interest under section 50 and penalty under section 73 within bracket 9 of the WB GST/CGST Act 2017. And the petitioner was directed to make the payment of the amount as specified in the said order within the time limit indicated there. So being aggrieved by such order, petitioner preferred an appeal. Any appeal case number is there? It's a very long case. Preferred an appeal being appeal case number G 107. There is GST, kindly check up GST/APP/226/2024-2025. And the appellate authority by the order dated January 20, 2025 dismissed the said appeal, thereby affirming the original order passed by the adjudicating authority. Mr. Bhattacharjee, learned advocate appearing for the petitioner, submits that at the relevant point of time when the supply was made, the supply dealer was in existence. But subsequent, the registration of the dealer was cancelled with retrospective effect, and such cancellation of registration is the subject matter of a pending writ petition before the Honorable High Court at Calcutta. He submits that in reply to the show cause notice, the petitioner produced, in reply to the pre-show cause notice as well as the show cause notice, the petitioner produced the relevant documents in support of the transactions in question. First up, he submits that the relevant tax invoices all right, so A to G, he submitted that he has produced the invoices, that is the tax invoices, that the tax invoices, e-way bills, copies of RTGS, payment details, a certificate regarding terms of delivery and transportation costs issued by the supplier, ledger accounts, and a summary of GSTR to get the 2 capital A returns, as well as the dealer's such details from the official website of GST, showing that the supplier of the petitioner has filed his returns in GSTR to get the 3 capital B and GSTR to get the 1 for the relevant period. He submits that in spite of production of such documents, the adjudicating authority did not take into consideration such documents and arrived at a finding that there was no actual physical movement of the goods. Submits that the appellate authority, before
Even also you have produced this. He also submits that before the appellate authority, the aforesaid documents, including the returns of the, including the GSTR 3B and GSTR 1 returns of the supplier were also produced. However, the appellate authority, without considering such documents, mechanically affirmed the findings of the adjudicating authority. Paragraph. Ms. Sarkar, paragraph. Ms. Sarkar, learned advocate appearing for the state submits that the petitioner failed to substantiate the actual physical movement of the goods by way of production of documents relating to payment of freight charges, acknowledgement of taking delivery of goods, toll receipts, and payment thereof. She submits that in absence of the said documents being produced by the petitioner, the authorities were justified in holding that the transaction was a bogus one, as there was no actual physical movement of the goods in question. Paragraph. Heard the learned advocates for the parties and perused the materials place. It appears the documents in support of the fact that the movement of the goods were under the movements of the goods were with the documents prescribed therefore, namely tax invoices, e-way bills, etc. And the documents to show that the supplier has borne the transportation cost, and also that the supplier has paid the relevant tax and duties and filed the returns as prescribed under the statute have been annexed to this writ petition. Full stop. Upon going through the orders passed by the adjudicating authority as well as the appellate authority, this court finds that such documents were also produced by the petitioner before such authorities. Though the authorities, both original as well as the appellate, proceeded on the basis that no documents with regard to payment of freight charges, toll taxes, etc. were not produced. But such authorities did not return any finding as to whether the supplier complied with the provisions of the WB-GST Act 2017 by payment of the tax and duty and filing the returns for the relevant period. For the relevant period. So the registration of the selling dealer may have been cancelled, but it is not in dispute that at the relevant point of time, such registration was valid. The revenue has also not scrutinized as to whether the stand of the petitioner that the selling dealer has complied with the provisions under the GST Act to enable the petitioner to avail of the input tax credit has been complied with, arrived at a finding that the petitioner is liable to pay ineligible ITC claimed and availed by him along with interest and penalty. Stop. The question as to whether the selling dealer has paid the tax and duty is very much relevant for the purpose of deciding as to whether the petitioner is entitled to avail of the income tax credit, input tax credit in respect of the payment of such tax for the transactions in question. Stop. Then it is not necessary I am passing this order directing them to consider. Is it necessary? Stop paragraph. That is what I have said. Without that is the basic thing which is to be considered with the কি বলে শেষ করুন last sentence level of the input tax. Such a factual adjudication has not been undertaken either by the adjudicating authority or by the appellate authority. This court is therefore of the considered view that both the authorities failed to perform their duty vested upon them by the statute. For such reason, this court is inclined to interfere with the orders impugned. Accordingly, the order of the appellate authority dated January 20, 2025 and the order of the adjudicating authority dated April 16, 2024 are set aside and quashed. The adjudicating authority is directed, the matter is remitted to the adjudicating authority. The adjudicating authority is directed to take into consideration the materials produced by the petitioner in support of his claim for availing the income tax, input tax credit. And after scrutinizing the same and after verifying the authenticity of such documents, shall consider the matter afresh and pass a reasoned order after giving an opportunity of hearing to the petitioner or his authorized representative. The entire exercise shall be completed as expeditiously as possible, but positively within a period of
6 weeks.
6 weeks from the date of receipt of a server copy of this order. Yes, what are the other matters? Only the dates will be different. So only in a piece of paper, please put the order of the appeal number, order of the appellate authority.
Rate petition number 8, the question of the transportation has been discussed.
Yeah, we have said.
The transportation.
Yes, but the issue of revenue has not been discussed. Yes.
The problem with the transportation option, these two transporters, either they have mentioned the transaction.
All right, you decide all points.
Either they have mentioned the return.
All points are at a line. It is however made clear that
I will reply to the letter because this time. What my lawyer said, no one I know, here, balance of that is there. The balance of that is very one. There are two transfers. One, the same with Madam. And the second one, he has not hybrid returns. That is the two things. One was knowledge system, one was not hybrid return. The whole.
but the tax has been paid. All right. Yes. And disposed of. Disposed of with the above observations. Above observations and directions. Yes, call the next matter. 6, 7, 7, 8, 9. শুধু ওই এগুলো দেখে নেবেন, শুধু অর্ডার ডেট গুলো আর অথরিটি গুলো চেঞ্জ করবেন। Yes, call the next matter. Yes. Yes, call the next matter. Yes. Yes, Mr. Ghosh. Yes. Yes, Mr. Dhar, why are you laughing? Yes.
Millet, I am for a tea company, Millet. Millet, initially what has happened here, Millet, an OTS settlement was granted in my favor. Under
You are the borrower.
there was a surface proceeding that is not
You are
in
the
dispute.
borrower.
I am the borrower. I am the borrower. And OTS settlement was granted in my favor. Subsequently, prior to grant of this OTS settlement, they have exhausted all their remedies. Surface proceedings, e-auction failed. Then, as a matter of last resort, this settlement was granted. And the period during which this default happened was during the earlier management. I am the new management who has subsequently taken over the company. Now, once this OTS was granted, a third party approached before this honorable court, said that I am ready to put in more amount of money. Kindly allow me to take over the property. The honorable coordinate bench, the honorable single judge said a third party cannot have any right. It's between the borrower and the bank. That went up to the division bench, up to the honorable Supreme Court. The honorable Supreme Court, Justice M.R. Shah's bench held that you are an interloper, you have no right herein. Pursuant to that observation, the division bench dismissed their appeal, which was pending before the honorable division bench, with costs. Now, this is Millard, this part goes, this ended in 2023. 2024.
The third party is a party.
No, I'm just giving your lordship the short backdrop of the matter. Thereafter, Millard, we approached the bank that now this litigation part is over. Supreme Court has also said that this scheme is sacrosanct between me and you. kindly finalize this. Several communications exchanged between them. We have made the final offer of 2.26 crores, which they have not concluded yet. And they have not closed the scheme also. From their communications, Millard would find even till the last month, the discussions were alive. They have repeatedly asked me to enhance my offer. We have lastly enhanced it to 2.26 in terms of their
Initial was 2.25.
It was 2.26. The initial
So
offer.
you have said you have increased, enhanced to.
Yes. The first offer, sir, please don't interject. Let me finish. I will not, I promise I will not interfere when you submit. The first offer was 2.30. Subsequently, after several discussions, we enhanced it to 2.26 in pursuance of their discussion. And
2.26.
2.30 was their original offer back in 2019 when prior to all this litigation. Subsequently, Millard, all this happened. Then we offered initially 1.30. From there, they insisted for enhancement. We have enhanced it to 2.26. So there is a difference of 4 lakhs. Pursuant to this, from time to time, for confirmation of the OTS, they have taken money from me also, which I have also paid. Now, Millard, I must admit, Millard, in the writ petition, there is a slight, Millard, error in the drafting. The amount paid is around 20 lakhs, which we have already paid pursuant to this scheme. The amount is slightly, Millard, an enhanced amount is mentioned. Millard, I will probably crave leave of your lordship to correct that. That's a wrong pleading which we have made. Now, in between, suddenly, since 2022, we had doubts that the bank has misplaced my original deed from their custody because in the DRT, they had obtained an order against me without even producing the original deed. And this raised a suspicion. From 2022, we are writing them, yes, we are ready to finalize the OTS, but kindly show us the document that is in your possession. Because the deed of mortgage, there was.
Now what happened? The deed is there.
Deed is not there. Now they have, now the last communication from them, Millard would find, they're on one hand, they are not finalizing the OTS. That is one part of my grievance. I have sought a prayer that this should be immediately finalized. Second, I should be adequately compensated because a document which was in your custody since long, you have misplaced it. Now, subsequently, they have admitted that we have lodged an FIR back in 2022, but they're intimating it to me in 2024. That the document is lost, it is nowhere. Now, Millard, I am seeking compensation for that. This is my second prayer. These are, Millard, my 2 grievances in the writ
So
petition.
you want a direction for
Finalization
enforcement
of the OTS and adequate compensation for loss of the deed. Now, Millard would kindly, for once, Millard would take.
Have they taken any steps in that surface proceeding?
Surface proceeding is now over.
DRT pending.
DRT proceeding has culminated into a final, Millard, certificate. The recovery proceedings is now pending. Recovery proceeding is pending. So they have not taken any further steps.
This OTS is in connection with the recovery.
Yes, the same thing. So once, so once the OTS is finalized, that proceedings shall automatically become infractions.
Recovery proceedings is for what amount?
Recovery proceeding, Millard, the exact amount is not with me.
Is it more or less than this?
It will be more. It will be more. Definitely it is more. But this OTS, Millard, has been granted in 2019. Subsequently, they are, Millard, probably under an obligation to conclude it because till date they have not revoked it. Millard, kindly take page 78 once before Mr. Mishra submits. Page 78, this is the last communication from them. Page 78. We are in receipt of your revised compromise offer letter dated so and so, by which you have revised your compromised offer amount from 1.50 crore to 2.26 crore. While going through the above mentioned offer letter, we have noticed that you have requested for providing original documents mortgaged to our bank at the time of sanction of loan, such as deed of Kohinoor Tea Estate and the deed of Kohinoor Tea Building in Jalpaiguri, my original lease deed and the purchase deed of my main registered office, the building in Jalpaiguri. You have also mentioned that you want to inspect the original documents before making any further payment to the with regard to the OTS. In view of the above, we would like to apprise that the original documents, that is the original lease deed of Kohinoor Tea Estate as well as the title deed of Kohinoor Tea Building is missing from bank record, for which bank has already lodged a police complaint on 30th September 2020. So after 4 years, they woke up to inform me this. And in between, they have obtained orders from the DRT without producing the original deed. In the event of compromise settlement and on deposit of the offer amount, we will hand over FIR copy to you, and you can obtain certified copies of the original documents from the office of the concerned district sub-registrar, which will work as good as the original documents. In view of the above, we are requested to submit revised compromise application to us so that we can proceed further with your compromise offer. So my prayer is enough of communications. You finalize this, because pursuant to this, we have written at least 3 letters.
Yes, what is their instruction?
First of all, this rectification is neither mentionable in law, and they have not come before this honorable court with clean hand. They have suppressed the fact that a decree has already been passed by the learned Debt Recovery Tribunal in which they participated, and the decree amounting to the tune of rupees 5,37,39,463 has been passed, and in pursuance thereof, a recovery proceeding has also been initiated.
That is Mr. Ghosh has said.
Debt Recovery Tribunal, they are not participating there. They are not participating, Lordship, in that recovery proceeding. Another
Recovery proceedings, you have not participated.
No, it has been the original, order by the tribunal initially was granted ex parte, because at that point of time, the new management was
Alright.
yet to take over.
But you have not challenged that also.
No, it's not challenged.
So you participate in the recovery proceedings,
Blood-
make all these players in the recovery proceedings.
No, they cannot take 2 stands. Either you say that the OTS is revoked, because if you in one hand, you are extracting money, showing me
Yes,
the
what is
lollipop.
stand with regard to the OTS?
Lordship, I'm coming to that, Lordship. First of all, this the respondent number 6, HSS and Sons, which has been made party by the writ petitioner, is the new managing committee of the new board of directors who have taken over the petitioner company.
Yes, we have. They are the major.
Done a debt recovery tribunal. Lordship, they have come up with the allegation that without those title documents, we have obtained a decree by fraud. Lordship, this is the decree passed by the London Debt Recovery Tribunal.
No, now the decree is there.
Lordship,
Now, whether you are denying this proposal for one-time settlement,
yes, Lordship.
there was no proposal.
Proposal has already been denied. Lordship,
Where is that?
When it has been
Show
denied?
me that denial.
Okay.
That is the end of the matter. If you said that you have denied that, where is that?
Lordship, the first OPS proposal was given from the bank only in the year 2020.
No,
Yes.
this OTS proposal of 2.26, where is the proposal? What is the fate of that?
So, fate of that, I have got instructions from the bank to submit before this honorable court that the OTS proposal has already been rejected in principle.
Show me that document.
The letter will be issued within a day or two, Lordship.
So it has not yet been,
It has not yet been, but on the 2 principles, it has been, first, they have quoted an amount which is much lesser than the decree amount, and even the earlier, the first OPS proposal was made for an amount of rupees 2,38 lakhs. And after enhancement, they have made an offer for 2,26 lakhs.
not enhancement, it's reduction.
So, first, provided.
Enhancement from my initial offer.
They have made this OTS proposal a conditional one, that first they need to see or verify the document, whereas they very well know that these documents were already exhibited before the debt recovery tribunal, and these documents
From whose custody it has been lost?
from the London debt recovery tribunal. Lordship.
So, but the
Debt recovery
18th,
tribunal was
From
lost.
18th November, they have said something else. How many stands can they have at the same time? You said from bank records.
Show me that it has been lost from bank records.
In these 2 orders, it is specifically mentioned that the original lot of documents filed as by way of affidavit has been lost. And it was lost in transit, Lordship. The last paragraph of the order dated
Lost in transit. কোথায় নিয়ে যাচ্ছিল?
Kolkata থেকে transit.
ও,
last paragraph of that page, sir.
Which page? This?
Thereafter, the same thing was reiterated by the learned debt recovery tribunal in its order dated 6th of February 2020. And bank was directed to file duplicate copy. By that time, Lordship, the evidence was also completed before the learned tribunal. And those two documents were marked as exhibits.
Yes, Mr. Ghosh is not available. It was filed, it was not available from the case records.
Well, in page 78, they have said something else. I know from them.
But the tribunal says
Another thing, Lordship,
original evidence on affidavit filed by the applicant is not available in the record.
Right.
So that is they may not be responsible.
So
for
now,
that.
my
All right, so
yes.
this is one part that
Lordship, okay. Honorable in a plethora of cases, Lordship, Honorable Supreme Court has made it clear.
Writ petition, writ court cannot direct.
This is not a matter
Mr.
of.
Ghosh knows this.
That Bijnor will be placed in Bijnor. Justice Emarsa held. Bijnor is
I know Mr.
the
Ghosh knows those.
says that initially
There are series of
Aravind Electronics
And it
relies
was the
upon
judgment
Bijnor.
Of some high court, some observations was made by the honorable.
Yes. That is in Aravind Electronics, which has relied upon Bijnor. And Millard, the ratio is without paying. At the first inception, I cannot go before an honorable high court and say that I have a right to get an OTS.
These writ petitions are on the face of it, not maintainable.
No, this is Millard, a completely different one. I am saying,
Also,
Millard, kindly consider Bijnor Para 11. Bijnor,
now, Mr. Ghosh, only one thing. If they have rejected your prayer for.
they have not rejected, they cannot reject. They cannot reject. But why I say this?
Say now,
Millard,
they have rejected according to them.
no,
You can
Millard, that
challenge
is submission from the bar. Submission from the bar, they cannot, because it's Millard an offer and acceptance. The offer they made already accepted, they have accepted my advance also. Now they cannot reject.
No, not the earlier, this proposal.
Present proposal that I have received instructions that it has already been rejected in principle.
Have you communicated it to them?
It will be communicated.
It will be all,
Lordship, the same.
everything is in future tense, not past or present tense.
Lordship,
Everything is future tense.
that we cannot make an offer even lesser to the earlier. What was made in the year.
Could have rejected, what prevented you from rejecting this offer at the earlier?
You had in November 2024, kindly see what they have written.
This writ petition was filed when?
25.
Yes, Lordship. And
Yes.
Lordship, they made two conditions. We were inquiring about the documents. This is an order of 2015, Lordship. Some of the part of the documents are lying in Debt Recovery Tribunal, Kolkata. So part of it is lying in Debt Recovery Tribunal, Siliguri. We were not.
Why it has been transferred now to Siliguri?
Yes, Lordship.
Yes.
Established Debt Recovery Tribunal in 2017. The
Has been
records were
transferred.
transferred from Kolkata to Siliguri. And in that transit, it was lost, most probably. Before 2017, what used to happen, every after 3 months, a circuit court used to be set up in Siliguri for a week or so. And there, in that circuit court, while the documents were being carried from Calcutta to Siliguri, it got lost. And this is mentioned, and they were parties to that proceeding. They have not.
Alright. So let them state their stand on these.
Millard, let them, so far as Millard, page 78 is contrary to what Mr. Mishra is submitting.
Let him come out. with some
Let him say by way of a short affidavit that what is their stand regarding loss of the documents as well as the OTS.
I'm keeping that point of.
No, Millard cannot. If Millard says that it is not maintainable, Millard, I have only
I'm
two
not
lines of
saying that. I'm
submission.
keeping that mentality point open.
Millard cannot, Millard. Subject to correction,
Why?
Millard should not rather. I withdraw my words, cannot, Millard
Yes.
should not.
Why?
Because Bijnor says, the Honorable Supreme Court says, at the first inception, you cannot go and say that OTS is a matter of right.
Yes, Mr.
Here is a-
Can place those.
Here is a case, Millard, here is a case, Millard,
Mr. Ghosh.
here is a case where,
Mr. Ghosh, I can
well-
do two things.
well-
I can give
Millard.
them, direct them to produce these documents. Maintainability may be kept open. You can argue that the point of.
Miller kindly does that. Miller kindly does that.
Relying upon the judgments of PHR invent, Lordship, I'm relying upon the judgment of.
We have relied upon PHR invent in a division bench judge.
PHR Invent Educational Society, sir, Bijnor is the mother judgment.
PHR invent is on a proposition that when there is a specific mode has been given,
Yes.
then you cannot. Even quoting those exceptional cases in which Article 226 can be.
Yes.
After quoting that paragraph, those exceptions, the next
Right,
paragraph
right.
says. And it says that in this bank, this matters, surfacey matters, 226 should not be.
There's no dispute with that. Satyavati, Tandon, Miller, long back, it is clear.
Plus the parent judge
Yes.
following that, but now the recent judgments,
Miller,
different
Miller,
says
kindly
it
see the
should not.
scope of the writ petition.
Earlier-
Miller, I am
earlier
only
was
impressing upon this.
Can under exceptional
Right.
circumstances. you can-
Absolutely, absolutely.
but
When the
recent
DRT is
decisions-
not functional, so and so, but your lordships have in 227 entertained some of the petitions. when-
Non-functional you can, but
Yes.
even functional, under some cases, that
Right,
failure
right.
to principles of natural justice, ex facie barred by jurisdiction on.
Now, Miller,
Under section 20 of RTD Act.
Which
on
order?
order.
Which order they have challenged?
The decree that passed by the.
The
That
decree
they
is
have
not in
challenged.
question.
They have not challenged the decree.
They have.
I'm not passing any order for stay. The learned advocate appearing for the bank raises an objection as to the maintainability of this writ petition. Mr. Ghosh, learned advocate appearing for the petitioner submits that the bank made a proposal for one-time settlement and the petitioner accepted such proposal and has also paid an installment
20 lakhs. Miller can record 20 lakhs.
and also paid an installment of rupees 20 and also paid an installment and also paid. That was an installment as per.
No. In
And
terms
also
of the
paid a sum of
ODS,
rupees-
upfront amount in
and
terms
also
of the
paid
ODS.
an upfront amount of rupees 20 lakhs in terms of the said
Yes.
settlement. So the learned advocate paragraph, the learned advocate appearing for the bank submits that the said one-time settlement has already been, that the proposal for said one-time settlement has already been cancelled, has already been rejected by the bank. First up, the bank is directed to file a report in the form of an affidavit in support of this, of such stand. First up, let such report in the form of an affidavit be filed within week from date.
So 7 days, Lordship.
Within a week from date. First up, the point of maintainability of this writ petition is kept open.
Miller, in the report, they should disclose regarding the documents also, because what they're saying now is contrary to page 78. They said it has been lost from
Yes,
bank
yes,
records.
that
that
report
part.
in the form of an affidavit disclosing the, যেটা বললাম না, place for a report in the form of an affidavit, disclose the document cancelling the one-time settlement.
No, Miller, and regarding my deeds,
So stuff, it has been alleged in this writ petition that the title deeds and other original documents
yes,
of the petitioner, the company, has been lost. Pusta, the learned advocate appearing for the bank submits that such documents were not lost from the custody of the bank, but the same was lost from the custody of the debts recovery tribunal, which will be evident from the orders passed by the debt recovery tribunal. Pusta, যেখানে বললাম না later পরে এগুলো বলুন না later reporting the format disclosing the documents in support of the contentions made by the in support of the aforesaid submissions made by the learned act.
grateful, Miller, extremely grateful.
Maintained point of at the time of hearing. At the time of final hearing.
Grateful, Miller.
আচ্ছা এই ডকুমেন্ট গুলো দিয়ে দিন ওটা একটু। Yes, call the next matter.
But I'm appearing for the West Bengal Board of Primary Education.
Yes. So Ghosh, you are for the petitioner?
No, no, no.
I am for the petitioner, my lord. I am for the petitioner, my lord.
Board Millard led by Mr. Bishas.
Petitioner paid for transfer on
Transfer?
medical ground, my lord. His daughter suffering from heart disease as well as his father also suffering from cancer, my lord.
Who is for
Petitioner
the
is the
school?
assistant teacher of a
Who is
school,
for the
Holdibari Girls, my lord.
Have you served the school?
But
School
school is not
required, my
required.
lord.
School is not required.
My lord.
No objection from the school is not required.
No,
Not,
my
in the
lord.
primary matter is not required.
All right, yes.
My lord, my application is page 36. My lord, Secretary West Bengal Board of Primary Education can consider my application in accordance with law.
Mr. Why are you not considering this?
My lord, we will consider and pass the recent order, your lordship.
How
Your
soon?
lordship can dispose it of, but within 4 weeks.
Ashwin, the petitioner who is presently functioning as an assistant teacher in a primary school.
Primary school.
My primary school.
The teacher in a primary school in the district of Kuch Bihar has prayed for transfer on medical ground. Such prayer has been made before the Secretary West Bengal Board of Primary Education, which is annexed at page 36 of the writ petition. Paragraph. The grievance of the petitioner is that no decision with regard to the prayer of the petitioner for transfer has been communicated to the petitioner till date. First paragraph. Mr. Bishas, learned advocate representing the West Bengal Board of Primary Education, submits that the decision on such representation shall be taken and communicated to the petitioner within the time limit that may be fixed by this school. First paragraph. In the light of the submissions made by the learned advocates for the respective parties, without entering into the merits of the claim made by the petitioner in the representation dated with
16 December 2024, my lord.
dated the representation dated 16th December 2024, WPA 715 of 2025 is disposed of by directing the Secretary of the Bengal Board of Primary Education, being the fourth respondent hearing, to consider the representation of the petitioner dated 16th of December 2024 and to dispose of the same in accordance with law by passing a reasoned order. First up, if such authority is of the view that if such authority decides in favor of the petitioner, consequential steps in that regard shall be taken by such authority. First of the entire exercise shall be completed as expeditiously as possible, but positively within a period of?
My lord, 8 weeks, your lordship.
Why 8 weeks?
8 weeks. My lord, I tell your lordship, my lord, the past board, then my lord, there are 2 councils, my lord, the petitioner from one council to the other council. My lord, we have to take the, my lord, data from the all 2 council, both the council. But it will take some time, my lord. Your lordship, kindly, my lord, give us 8 weeks time.
8 weeks from the date of receipt of a server copy of this order along with the copy of the representation dated 16th of December 2024.
Grateful, man.
Grateful.
Yes, yes, Congress matter. But 12, I am for the petitioner, led by Mr. Kumar Ray. Says, Lordship, this is a matter regarding.
My lord,
Of
my
registration.
lord, Mr. Mittal may submit, my lord. If required, I will assist, my lord.
Yes, Lordship, this is a matter regarding cancellation of registration certificate.
Who is appearing for the state?
Generally, Mr. Dilip Kumar Agarwal appears.
What is appearing? So it's Union of
So
India.
this is CGST. Main answering respondent is CGST. CGST. CGST is the answering respondent.
Not received the copy.
Lordship, I have already served to
He has
the.
served me on the mail, but it is not being allotted by our class.
And my lord, this is the non-filing of returns, my lord, covered by your lordship judgment, Shubhankar Golder.
But
And our court's view is that, my lord, state is benefited if the registration is restored, my lord. So, my lord, the portal may be open for a period of 15 days or 20
I
days. Then,
appreciate
my
this.
lord,
Serve a copy.
Lordship, already served a copy. This affidavit.
Can you not serve an extra copy?
Lordship.
Serve him a
kindly,
copy.
please have one copy, my lord. That
It has to be regularized, your lordship, because without allotment we cannot.
Tomorrow.
Either it can be regularized, regularized from this state.
Yes, yes.
Then today only we can move because they will take the cancellation registration.
You have an extra copy.
Lordship, I have my copy. I am handing it over.
Please go through that. That is that order. Have you brought
my
it
lord,
up?
page number 29. Page number 29. And I am also requesting Mr. Mitchell to hand over the copy of judgment of Shubhankar Golder. Honorable Division Bench judgment.
Yes.
And also judgment of Coordinate Bench judgment Amirul Islam.
It's only the
For not filing of returns.
No, that is true, but they are coming very late because 2023 and now 2025. That only the observation, my lord. They come
Now they are willing to do this.
No, we have no objections, but only thing can be included that they are coming.
State will be benefited only.
They will be benefited. That is not an issue, but why have you come so late?
Yeah, my lord, I have mentioned, my lord, in para 8, my lord, of the read petition, that, my lord, I am a small contractor. And after COVID, my lord, my business collapsed, my lord, that I have no idea, and my consultant did not guide me to file the nil returns, my lord. I have stated, my lord.
All right.
I'm grateful, my lord.
This application under Article 226 of the Constitution of India is directed against the law dated 9th of March 2023, passed by the Superintendent Jalpaiguri, cancelling the registration of the petition. Paragraph, after going through the field order, this finds that the registration of the petitioner was cancelled on the ground that the petitioner failed to file consecutive 6-monthly returns. Paragraph, the learned advocate appearing for the petitioner places reliance upon a division bench judgment of this court in the case of Shubhankar Goldar versus Assistant Commissioner of State Tax, reported at 2024 bracketed bolte 163 taxman.com 99 within bracket Calcutta, in support of his contention that an opportunity can be granted, an opportunity has to be granted to the petitioner to remedy the breach. To stop paragraph, the Mr. Agarwal, an advocate appealing for the Union of India, submits that the registration was cancelled long back.
My lord, it is being regularized because I am not.
Oh, sorry.
with Vishwaraj.
Have you filed your affidavit of service, Lordship? File your affidavit of service. Affidavit of service filed in court today is taken on record. In spite of service, none appears for the Union of India. Mr. Agarwal, the honored advocate who usually represents the Union of
Along
India,
with Vishwaraj.
along with such and such, is present in, Mr. Agarwal, honored advocate who usually appears on behalf of the Union of India, is present in court and is requested to appear in this matter. Let the appointment of Mr. Agarwal along with a junior of his choice be regularized by the competent authority. First up, let a copy of this writ petition be served upon Mr. Agarwal in course of this day. After going through the writ petition, Mr. Agarwal submits that the registration of the petitioner was cancelled long back, sometimes in the month of March 2023, and the petitioner has approached this court after 2 years of cancellation of such registration. First of all, submits that that this court should not entertain the writ petition on the ground of delay and latches. First of all, however, after going through the amendments made in the writ petition, this court finds that the petitioner has explained the reasons for approaching the court at a related stage. For such reason, this court is inclined to entertain this writ petition and to decide the same on merits. Paragraph, the Honorable Division Bench in Shubhankar Goldar, within bracket, Supra.
Hello.
Held that in case the registration is cancelled on the ground that the registered person failed to furnish the returns for a continuous period of 6 months, an opportunity can be provided to the safe dealer, to the safe assessee to remedy the breach. First up, the said decision shall squarely apply to the facts of the case on hand. First up, in view thereof, the order dated 9th of March 2023, cancelling the registration of the petitioner is set aside, subject to the condition that the petitioner files the returns for the entire period of default, pays requisite amount of tax and interest and fine and penalty. If the petitioner complies with the directions passed herein before, within a period of 4 weeks from the date of receipt of a server copy of this order, the registration of the petitioner shall be restored by the jurisdictional officer. If the petitioner, however, fails to comply with the aforesaid directions, the benefit of this order shall not inure to the petitioner, and the writ petition shall automatically stand dismissed without any further reference to this court. For the purpose of ensuring compliance of this order and directions, for the purpose of ensuring compliance of these directions, the respondents are directed to open the portal so that the returns can be filed and tax, interest and penalty can be remitted by the petition.
But they will open the portal, my lord, within 7 days. Otherwise, my lord, I cannot submit my lord return or cannot pay tax, my lord.
Within 7 days?
My lord, maybe 50 days is because some technicalities may be there. So otherwise, it will be again contempt.
Lordship, then our time may be
extended to 8 weeks. You make yourself ready. Once they open, immediately thereafter. You open, I'm not fixing a time limit. No, open.
But if do not, Malad, if they do not open, Malad, I cannot submit,
Yes,
Malad.
yes,
And
direction,
that is
Mr.
why
Rai, directions have been passed to open the portal. That direction has
open the
been
portal,
passed.
Malad. Suppose, Malad, they will open the portal on 25th day, Malad, then it will be very inconvenient for me, Malad. That is why I'm praying, Malad.
Why 20?
Within 7 days, Malad, they will open the portal, I will submit
Sir,
that.
directed to open the portal. যেখানে বলেছি না, within a period of 7 days.
Yes,
7
Malad,
days
I'm
from
great.
the date of. Within a period of 7 days from the date of communication of a server copy of the file.
I'm so grateful.
Be granted because it has to be sent to the GST and for
server. Because now it is controlled by the. Otherwise, there is no hesitation. We can open it tomorrow.
2 weeks তাহলে ওটা যেটা 4 weeks বলেছি না সেটা 6 weeks.
I'm grateful.
যেটা বলেছি না 4 weeks এর মধ্যে ওটা 6 weeks.
I'm grateful.
Yes, call the next matter.
Item 13, my lord, I am for the petitioner.
Yes.
My lord, here matter relating to dying in hardness, appointment in dying in hardness category, page 31 and my lord, page 33, to order impugn order passed by the district inspector of school, Jalpaiguri.
Who is appearing for the state? You are appearing.
Yes. My lord, kindly come to page 31, third paragraph. They are relying upon to my lord Geo 251 EMP and my lord 26 EMP. Both EMP, my lord, I annex, but both EMP relating to labor department. Page, my lord, my appointment in my lord clerk or group D in school. Page 35 and 38, both the notification I annex. All the notification applicable to government employee. And my lord, according to them, they rejected my application on the basis of those two, my lord, notification, 251 and also 26. My humble and respectful submission before your lordship, those two notifications are relating to labor department notification.
What is the relevant notification applicable to your case?
My lord, education department notification regarding teachers and non-teaching staff. My lord, that notification within 2 years, what has happened? Within 2 years, I have to submit the application.
Where is that notification? Where is the notification of the education department? Where have you annexed?
My lord, that notification, my lord, my lord, my lord, that is the compassionate appointment rule for teaching and non-teaching staff. My lord, that notification not annexed here, but
show me the rules. Show me the rules. Where is the rules?
My lord, they, my lord, stated in the order, rules taken into the public. They stated in the order, page 33, that within 2 years, I have to submit the application. My lord, here in the instant case, that time, the petitioner was minor. The mother filed the application. And thereafter, my lord, when the petitioner attained majority, within that time, she filed an application. So, my lord, 2009 rules, these rules, West Bengal School Service Commission, selection of person for appointment to the post of non-teaching staff rules 2009.
Yes.
Now that rule, DI forwarded to School Service Commission. If I am eligible in respect of financial crisis and other, my lord, criteria. First criteria, within 2 years, I have to file the application. But it is true, this is not my hand. My lord, I was minor. That time my father died, my lord. And my mother applied. My mother that time had overaged. And when I, my lord, attain majority, then and then I file application. This is the fact, my
When
lord.
you attain majority?
My lord,
When you attain majority,
my lord,
give me two dates. The date of death of your father and when you attain majority.
my lord, list of dates. My lord, my father passed away 2014, November 20, 2014. And my lord,
And when you attain majority.
I attained majority 2019.
So it's not within 2 years.
Within 2 years.
How can it be within 2 years?
No.
Your father died in 2014.
That time I was not major. I was not attained majority within
Then
2
how
years.
could you be considered for appointment under compassionate ground?
My lord, my mother applied, but that time my mother overaged.
So your
Thereafter-
mother was not eligible. You are also not eligible.
But this
You
is
have to apply within 2 years.
my lord,
You have attained majority after 5 years.
my lord, that time, my lord, I was major. It is a fact, and it is also a fact I cannot apply it. But because I was a minor, and
Show me the rule. If you are a minor, it is to be kept pending. And when you attain majority, you have a right to apply. Show me the law.
No, my lord, that is not a rule. My lord, no such rule in that respect, my lord.
There is a decision, Mr. Chatterjee, in your favor, Supreme Court decision. You have not brought that.
Your lordship is there, my lord. Your lordship.
No.
No. My lord, lordship kindly. This is not.
You have not
my
brought that
control.
judgment.
This
There
is
is a
not
Supreme Court
my
judgment
lord,
on this.
majority or minority, not my control. My death of my father is not my control.
Mr. Chatterjee, compassionate appointment. You do not have a right to
Yes,
compassionate
my lord.
appointment.
That is true, my lord. That is true, my lord. That
So
is
this
true,
is
my
the
lord.
departure from the line of
Recruitment
employment.
process. Yes, my lord.
Yes.
That is true, my lord.
So you do not have any right. You only have a right to be considered for compassionate appointment in terms of the relevant scheme or the rules in that regard.
And that is true, my
Do
lord.
not come within the scheme or the rules, you cannot claim any right of compassionate
But
appointment.
that is silent, my lord. That portion silent, my lord.
No. Mr. Chatterjee, it says within 2 years of the date you have to apply.
But if
That presupposes that you have to be eligible within 2 years. And more so, Mr. Chatterjee, if the death occurred in 2014, and for 5 years you could wait.
because that time I was minor, my lord.
Yes, that is lost. So the family could survive for this.
But agriculture day level.
Tide over the financial crisis, immediate financial crisis.
Immediate financial crisis admitted by the district magistrate. But that portion, my lord,
Cannot be, Mr.
we cannot
Chatterjee.
overcome.
You could wait for 5 years. You could wait for 5 years for you to become major, then apply.
That is true, my lord.
Next circuit bench, I think Mr. Chatterjee will
No,
be
no,
better.
my lord. Your lordship, my lordship. That judgment, your lordship, and thereafter, my lord, you pass.
What judgment?
Your lordship already, my lord. My lord, that judgment. Otherwise, my lord, that I am. Your lordship passed the
You
necessary
bring,
order.
I have forgotten. I only recollect that there is some judgment. I argued a matter relying upon that judgment, but thereafter I have forgotten.
Then,
Now
my
it's
lord,
you to search out that judgment.
My lord,
I
one
can
day,
give you only the year of the judgment.
the year, my lord, lordship,
Sometimes in the year 2006.
2006. My lord. My lord, then, my lord, not today, my lord. Or day after tomorrow.
All right.
Day after tomorrow, my lord.
You will not bring the judgments which are in your favor and you will come.
My lord,
You will not bring the judgments which are in your favor.
I shall try my best, and then your lordship pass the order. If not, then my lordship pass the order.
The learned advocate appearing for the petitioner. After some argument, the learned advocate appearing for the petitioner raised for an accommodation to assist this court on the next occasion. In view thereof. So I think it's better in the next circuit bench.
No, my lord. Your lord, no, my lord. Your lordship pass the order, my lord. My lord, positive, negative, any order, my lord, your lordship pass the order.
Negative also.
Again, no, my lord. If law permit, your lordship pass the order.
Yes.
My lord, day after tomorrow, my lord.
Yes. The next occasion. This matter, tomorrow.
Tomorrow, my lord, tomorrow. My lord.
Yes. Do such research work today night. Yes. I've given you also the year of the.
My lord.
Yes, next.
Lordship, I have the affidavit of service.
Affidavit of service filing.
Get full, your lord.
Yes, call the next matter.
My lord, I am for the petitioner.
Yes.
My lord, the 98 decimal of land acquired by the National Highway Authority.
National Highway is creating problem to everyone. Taking over the land, not paying compensation.
Not paying compensation.
Yes. When did you purchase the land?
No, my lord, it is purchasable.
You are the
is
recorded
for
owner.
Recorded owner, my lord.
Yes.
For the
What's the
usage, sir.
recorded owner?
There is a Khatian, RS Khatian, in the name of the
RS
father of
Khatian
the
or-
petitioner. That is what has been stated. But whether subsequently that has.
What is your instruction?
Well, this land.
The plot has been acquired.
That is the plot has been.
There is no dispute with
But
regard to that.
We definitely this person is not recorded.
Have you paid compensation?
That
The
is
award has,
that has to be instruction has to be taken.
and where is your representation?
My lord,
Page 22.
page 22.
Yes, you take a
21.
decision on that.
21 months.
21.
21, my lord.
21. In
Indeed.
my copy, 21 is the track report.
In my copy is 21.
My lord,
Heading is to the special land language.
Yes, yes, that is page 22.
page 20.
What is the plot number in question?
My lord, plot number the 12 LR plot number 1223 and 1224.
Both these plots have been taken over.
My lord,
You have inherited from your father. Your father has passed away.
passed away.
The petitioner claims to be the owner of LR plot numbers 1223 and 1224 within Mouja Kathal
Purbo Kathalbari. Purbo Kathalbari.
Mouja Purbo Kathalbari under police station
Alipurduar.
under police station Alipurduar in the district of Alipurduar. By virtue of inheritance from his father, namely Ajit Kumar Ghosh. The petitioner states that the aforesaid plots of land were utilized by the National Highway Authority of India for the purpose of construction or widening.
Construction.
For the purpose of construction of the national highway. The petitioner has submitted a representation before the Special Land Acquisition Officer, Jalpaiguri, by a letter dated 10th of December 2024. The learned advocate appearing for the petitioner submits that no decision on such representation has been communicated to the petitioner till date. The state and the National Highway Authority of India are represented by the respective learned advocates. After hearing the learned advocates for the respective parties, this court is of the considered view that the Special Land Acquisition Officer, Jalpaiguri, is required to communicate its decision on the representation submitted by the petitioner within a specified time. Paragraph without entering into the merits of the claim made in this representation, WPS 723 of 2025 is disposed of by directing the Special Land Acquisition Officer, Jalpaiguri, being the
Respondent number 2.
Respondent number 2.
Being the second respondent to consider the representation of the petitioner dated 10th of December 2024 and to dispose of the same in accordance with law by passing a reasoned order after giving an opportunity of hearing to the petitioner or his authorized representative and communicate such decision to the petitioner immediately thereafter. The entire exercise shall be completed as expeditiously as possible, but positively within a period of 6 weeks. 6 weeks from the date of communication of a server copy of this order along with the
copy of the representation dated 10th of December 2024. If your service of political has taken on. Yes, next.
Grateful. Appealing for the petitioner. It is the sort of court. Yes. Lordship, here, the only complaint is that not a single opportunity of being heard was ever given. Page 15, Lordship, kindly comes. This is the first, I don't know what to call this. It is neither a notice, but an intimation, yes. Whereas the following production of documents, a list is given. Page 17, my lord, sees the list is given.
So list is given by whom?
There only appended with that production.
We are required to produce these documents.
These documents I produced all
Where is that?
excepting the last one, because there was no date given for personal hearing. So my representative went there, produced, because these are all my books
What
of
is the
accounts.
order passed against you?
No, there is no order. Thereafter, what happened on the next page, Lordship kindly says. Another reminder. What is said? With reference to the show cause notice, there was no show cause. Referred to the above, neither you have filed any reply. My lord, what to file reply? It's a production of document.
Yes, madam. Where
Then
is the show
nor
cause?
you have appeared on the date mentioned. There is no mention.
No show cause notice, nothing.
And thereafter, no, asi. My lord, and thereafter in that page 18 only, Lordship says date of personal hearing, NA. Date of time of personal hearing, NA. Venue of personal hearing, NA. Documents in support of the claim, NA. Now, Lordship kindly comes to the page 20. Another reminder notice. Same saying that show cause notice, etc., and NA. Now comes for the first time, the show cause notice at page 23. Page 23.
Yeah.
Here, suppression of turnover is written, and Lordship kindly goes back to page 22.
Where
This is the body.
suppression of turnover?
Page 24, my lord, I'm sorry.
24.
Page 24. At the
Yes,
bottom.
in the box.
Yes, in the box. Suppression of turnover, and then here comes the page 22, Lordship kindly turns back. This is the body of the show cause. Lordship kindly sees the body of the show cause. Regarding suppression of turnover on such and such difference amount declared in GSTR 3B filed, amount reflected in 26 As. That means I need to produce and explain all my books of accounts, which is a voluminous thing. I need a date. Now, Lordship kindly comes to the next paragraph. You are hereby advised to file a reply or pay the amount of due tax interest accrued ascertained from 15% by 16/4/2024. There was no date for personal hearing. Again, now comes the main show cause notice. Lordship kindly takes the main show cause notice. That is at page number 28. It starts from 28. The first page, Lordship, the grounds that same, suppression of turnover. Then the next page. Here also at the box, at the end, date of personal hearing, NA, time of personal hearing, NA, venue where personal hearing will be held, NA. So there was no opportunity of being heard. What will I find? I cannot explain by a letter my books of accounts.
No, but have you replied to this?
But what will I reply? How will I reply? They are saying there is a mismatch in my 3B and 26 As. I do not even know the figures. So I need to sit with my books of accounts. The same case happened in this matter, Milord. In this matter, Lordship kindly sees these. It's all, copy but Lord, it's marked a bit. Lordship will take it. Lordship will take it. Yes. The petitioner alleges that he was issued a show cause notice dated so and so under section 73. Following the receipt of the show cause notice, requested a personal hearing. Sought to submit documentary evidence. We have orally submitted there a defense to justify the availability of ITC. However, the revenue, without granting any opportunity for hearing, determined the petitioner's liability through an adjudication order.
So now no final decision has been taken.
They have passed the final adjudication order.
Where is that?
In the next page. Page 32, Lordship says. The assessee visited. The assessee visited. No appeal file. No appeal file, because I am on natural justice point only.
Appeal what they will do. So
let me be given
the date of hearing.
Yes.
And,
in page number 31, my lord, that they are
Yes.
talking about the show cause.
No, no, that is what I'm saying. After that,
Says show cause
after
notice,
show
you
cause
have
notice,
asked him to produce the documents.
Documents.
So you fix a date.
oh,
you
they
produce
fixed.
all the
My
documents.
lord, they fixed. On after the show cause notice, I went and personally met the officer concerned. I said, give me a date. Now, page 31, he issues me a reminder. Reminder all of a sudden, as if they had given a date. Now,
Alright, so
on 12/9,
on 12th night, what happened?
my lord, 12/9 I went. But on that day, the officer was busy with some official work only. He
No
was
hearing
not,
was
nothing took place. And on 20th, I do not know how this date comes. On 20th, the order was passed.
20th of
September itself. Page 33 will speak for itself, my lord, at the bottom. I do not know where from
Shaka,
this
what
date.
is your instruction? It says that 12th of September, no effective hearing was conducted. So conduct
RP failed again to submit any explanation nor prayed for
But-
further adjournment on 12/9/2022.
12th night, his specific state is
Yes.
that he went.
He
But
went.
officer was busy, no effective hearing was taken. So fix a date, he will. appear.
Yes, I will once again appear with all my books of
Can you
accounts.
give
That
me a
is,
date so that I will direct him to appear on that date itself?
yes.
Then there will be no necessity of giving a notice.
My lord, then I have to take instruction which day.
Not any day can be given 7 days from
You
today. I
give a
will go
date.
and
On that date and time, you give a date.
yes, I will
I
go
think
and
what you-
get the notice.
Give me a date.
I do not know.
7 days hence, 10 days hence.
24th April,
Yes, yes.
My lord.
it's a Friday, it's a Thursday.
My lord, let me go there on 24th April. He will issue me a date of hearing.
No.
Or I will start it. I will start. Not an issue. I have no
Or
problem.
I will direct them to fix a date of hearing.
Yes.
My lord.
On that date, he will.
Yes,
Fine.
yes.
The order dated. What is the date?
September 20, 2024.
Where do you get the date?
My lord, page 33, bottom left hand side.
Yes. The order of the Deputy Commissioner of Revenue, West Bengal State Tax, within bracket WB GST, Darjeeling charge, dated September 20, 2024, is under challenge in this writ petition. Full stop. The grievance of the petitioner is that notices were issued to the petitioner directing him to give reply to the show cause on the allegation that there has been suppression of turnover. Paragraph. Mr. Bhattacharjee, learned advocate appearing for the petitioner, draws the attention of the court. Mr. Bhattacharjee, where is that letter which says list of documents? Where
Yes,
is that?
page 17, my lord. Yes.
Draws the attention.
Page
of
15. Page 15
Yes.
is the letter.
Yes, letter and the documents is
Yes.
draws the attention of the court to a notice for production of documents, which is annexed at page 15 of the writ petition. First up, from the said notice, it appears that several documents and books of accounts, as well as the bank statements, were directed to be produced. First up, unless a date is fixed for such, Mr. Bhattacharjee submits that unless a specific date for production of such documents was fixed by the authority, it was not possible for the petitioner to produce such documents before the authority. First up, Mr. Bhattacharjee took this court through the several documents annexed to this writ petition in support of his contention that several dates were fixed for
My lord,
giving.
he appeared before the authority, my lord, and he submitted the documents with regard to year 2017-18, and thereafter 2017-18 demand was dropped, my lord.
That is
But
what I'm saying.
they could not produce any document with regard to 2018-19, and therefore
Let it produce, you
Yes,
consider that.
yes.
In support of his contention that only the date for giving reply to the show cause was fixed, but no effective date of personal hearing was fixed. Paragraph. The Sarkar learned advocate appearing for the petitioners, appearing for the state submits that on the date fixed for hearing, the submits that the petition on the date matter, submits that the petitioner produced several documents pertaining to the period 2017-2018. And considering such documents, the concerned authority dropped the proceedings for such period. And this is for
18, 19. It's 18.
the period which is the subject matter of this writ petition is for the period 2018-2019.
But he did not furnish any document to that.
It appears from the record reveals that a date of personal hearing was fixed on September 12, 2024. Mr. Bhattacharjee submits that the petitioner appeared on that date, that is on 12th of September 2024, before the concerned hearing officer. But since such officer was busy with his with other matters, no effective hearing on that date took place. First up, Ms. Sarkar learned advocate appearing for the state, however, disputes such submission of Mr. Bhattacharjee. However, without entering into such factual disputes, this court is of the considered view that that one more opportunity can be granted to the petitioner to produce the documents as directed by such authority. To stop, the paragraph in view after going through the order impugned, this court finds that the same does not refer to any documents being produced by the petitioner. To stop, for such reason, this court is inclined to interfere with the order impugned. Accordingly, the order of the Deputy Commissioner of Revenue, West Bengal State Tax within bracket WBGST dated September 20, 2024 is set aside and quashed. To stop, the matter is remanded to the said authority, who shall decide the matter afresh after fixing a date of hearing and giving notice the petitioner in that regard well in advance. To stop, the petitioner is directed to produce all the relevant documents and materials as required by the as was directed to be produced by the authority on that date.
For the year 2018-19.
For the year 2018-2019. To stop, the such authority shall verify the documents and shall pass a reasoned order after giving an opportunity of hearing to the petitioner or his authorized representative. First up, needless to mention that the reasoned order shall be communicated to the petitioner immediately thereafter. First up, it's up to you when you will fix the date. Conclude that.
Right.
Entirely in your hand.
Grateful. But my learned friend,
observations and directions, it petition stands.
my learned friend Mr. Shah is saying that Mr. Bhattacharjee will go and appear now. My lord, I would have been very happy because it is in Darjeeling. No, I would have been very happy because it is in Darjeeling.
It's a very effective day for Mr. Bhattacharjee. Yes.
My lord, I hope it to be more effective, Lordship. I'll travel in, Lordship, when your Lordship comes back. 2-3 matters more, my lord.
That means after 2 p.m.
My lord. Grateful.
Great.
Deeply obliged.
for today.
Yes.
If after completion matter, it can
Will be called on Syrian.
If
Yes.
My lord, I am appearing for the petitioner.
Yes.
My lord had directed the respondents to take instructions.
Yes, Mr. Singhania.
Lordship,
Appeal is pending.
Lordship, two documents which is not annexed in this.
My lord,
No appeal, whether appeal
Yes,
is pending or
yes,
not.
yes, Lordship.
where my lord, may I place?
Madam,
Yes. Give me a minute. Yes.
Lordship, the first order, this is the approval of the refund memo. Now, in refund memo, AICT categorically stated.
No, Mr. Singhania.
Yes, appeal, last page.
Where is
Lordship,
From their perusal of this document,
last page,
nowhere it is stated
serial
that
number 2, second page. This page, this table, your lordships.
Yes.
Second column from the bottom.
Yes.
Lordships, pen number. Appeal is pending, your lordships. The pending appeal
My lord,
file.
appeal pending.
Where is
My lord, they
appeal
have not
pending?
preferred any appeal against the order
No,
of the
my lord.
Honorable High Court.
Lordship, the column.
My lord.
AO Ward 1/1 Siliguri.
Yes.
Now you say assessment year 2014. PAN number. Now assessee's name Arun Kumar Bose.
Yes.
Now demand amount of rupees such and such. Demand type is assessment demand. Raised date 6/2/2025. Section code 154. Appeal filed before the CIT. Yes. Appeal
154.
Lordship, because last demand.
No. Mr. Singhania, after 260 capital A, according to you, in the order passed under section 260 capital A,
The second.
the appeal revived, according to you.
Yes,
So
Lordship.
the appeal will be pending.
Lordship.
That appeal cannot be under section
No,
154.
This section.
Cannot be under 154.
Lordship, may I permit your lordship?
Yes.
My lord, my respectful submission is
Lordship, may I-
Mr.
Certainly,
Singhania
please
is
give me a
trying
bit-
his utmost best.
Please give me a
Lordship,
minute. Yes.
may I permit?
Yes.
Lordship, the first page.
Yes.
This order is clear, your lordship. The appeal record submitted by you via your letter mentioned in reference number above in the case of Arun Kumar Bose for the assessment year 2014-15 has been perused by me. On going through the record, it is observed as per your letter number such and such dated such and such and the rain heads letter such and such that the Honorable Jurisdictional High Court of Calcutta by its order dated such and such had set aside the order of the Honorable ITA Kolkata that is such and such and Lanet CITA number such and such and restore the matter back to the file of its CIT to fresh adjudication. As
Where
the
is that
Honorable High
order?
Court has decided that the Lanet CIT had erred in law by remanding the matter to the file of the AO for fresh consideration. Further, the then assessing officer had given the appeal effect to the CIT's order on 27/7/2022 and revised of income of 82 lakhs and such, which is the evident from the computation sheet dated such and such and also from the penalty order dated such and such. Considering the above fact, the impugned assessment order of the assessing officer passed under sections such and such remain uninterfered and still remain in force. However, on going through the appeal of record, it is observed that you have already given the appeal effect on the 3rd January 2024 by its order number such and such, dated such and such, and issued the refund, which appears to be a gross mistake, which it needs to be rectified at the earliest. Further, it is pertinent to mention that the order of the Honorable High Court of Calcutta should be uploaded in the ITBA portal so that the appeal is being brought to the work list of the Lanet Appellate Authority CITA. Since the matter has been set aside to the file of Lanet CITA, the matter shall be pending with the Lanet CITA. Therefore, the give effect order dated 3rd January 2024 in pursuance of the order of the Honorable High Court requires rectification. Therefore, the approval for the issue of refund cannot be given at this juncture and you are directed to take necessary remedial measure as per the law for the error committed on your part. The case folder received in 1 volume is hereby returned and refund approval request is being returned back to your work list in ITBA refund banker module. Now, your lordship, subsequently they pass an order of 154. Now, in 154 section, your lordship, this is a case not for enhancement. This is a case for restore the original claim. And second intimation, 154, the one portal, now is ordered, your lordships, in 154. In the case of Sri Arun Kumar Bose, PAN number for the assessment year 2415, the Honorable Jurisdictional High Court of Calcutta, by its set aside the Honorable ITA Kolkata or such and dated such and restored the matter back to the file of line at CIT fresh adjudication, as the Honorable High Court had decided that the CIT had erred in law for reminding the matter to the file of the AO for fresh consideration. Considering the above fact, the impugned assessment order of the assessing order passed under section 143 of the Income Tax Act dated such a remain uninterfered and still remains in force, and as such the question of issue refund does not arise, but in the appeal effect dated 3rd January 2024, why it is under section such and such, reduced section such and such, under D number such and such, a remand of review was raised, which appears to be gross mistake which needs to be rectified. Now, since the facts of assessment order shall now be pending with the CIT, therefore the question of give effect of penalty order such and such dated in pursuance of the order of the Honorable High Court does not arise, and refund cannot be raised in this stage.
So penalty order has also been stayed by you.
Lordship.
Penalty order has been stayed by you.
Now today the situation is, your lordship, in this file, assessing officers pass an order. Now in appeal, appellate court only says 3 lakhs. Madam,
Mr. Chaudhary will be getting you a chance. Let him submit first.
My lord, he is submitting totally contrary to the.
All right. He will be having your chance to clear the contradictions.
Yes.
Yes.
Now, your lordship, the appeal, when the first appellate court says, the appellate court says 2 entries, one lakhs and one and odd, which assessing officer in addition add the amount which deleted. Now this order.
Show me that from the appellate order, which was deleted.
Lordship, may I? Appeal order. Okay, page 67.
Yes.
Decision.
Yes.
Last question. At the outset, I do not agree with the AO presumption that there seems to be no existence of the party on the ground that the notice issued in the full address as per tax invoice, that is purchase bill, was returned answered with the comments of the postal authorities unknown. This is precisely because of the reason that when the assessee furnished the details of the last transaction, it had with the party concerned, and the AO did not contradict the same. As such, the AO presumption that the party seems to be not in existence is baseless and devoid of merit. Coming the issue to accessibility of brought forward opening balance, which is also operating as closing balance as on 31st March 2024, as the income of the SCC either under section 68 or under section 41(1) of the Act. I have already adjudicated the matter in detail by para 6.12 to 620 above. Accordingly, I am considered opinion that the addition made by the AO cannot be sustained in the eyes of law. Thus, the AO is directed to delete the addition subject to the following conditions. Now, it is imperative on part of the SSC to explain the year in
this has been set aside.
Only this part, addition part. Addition.
No, not the addition part. Mr. Singhania, not the addition part. The inquiry, further inquiry has been set aside.
Yes.
Addition
I bow down to
part not been interfered with. Mr. Singhania, addition part, please come to the
order.
Addition part.
Lordship, kindly effect of the appeals order is clear.
Deletion, not the effect.
Deletion.
First, you have to come to the division bench judgment. Please come to the division bench judgment.
Page 92.
And what was not.
Lordship.
Only with regard to the remand.
Division main problem is, your lordship, in the division bench order. Division bench set aside entire appellate authorities order and the income tax tribunal order.
No, my lord. Kindly come to the page number 95, my lord.
Sir, please allow him to submit. If both of you argue at the same time, I cannot follow.
But your lordship,
please take your seat. Yes.
And your lordships, in this also, 2 substantial question. Now, your lordship, in one part, Honorable Court says there needs to be fresh adjudication. adjudication.
So according to you, entirety has been set aside
Up to first CIT order and the
and
time
it has been remanded to the appellate authority. Show me the order of remand to the appellate authority.
press adjudication.
Where is that?
Lordship,
Show me the order in the division bench. It has been remanded to the appellate authority. Show me that.
Lordship, if the assessing officer's order not set aside, partly in the first appellate court, allow the assessees.
Mr.
They are-
Singhania, is there any observation in the division bench that it has been remanded to the appellate authority?
But no, there is.
I'm asking you, is there?
Yes, fresh adjudication is there, your lords.
Show me that.
No.
Fresh adjudication by the appellate authority.
Lord,
Show me that.
Lord,
That is the end of the matter.
Yes, Lord.
Show me that.
In 95, I'm reading from 95 page, your lords.
Yes, yes.
In the light of the above statutory embargo, the commissioner could not have remanded the matter back to the assessing officer after having deciding in the case in favor of the assessing in its entirely. The learned standing counsel of the respondent revenue points out that in the findings recorded by the CITA, the expression prima facie has been used by the show that the CITA had wanted a face exercise to be done by the assessing officer, and therefore it would have been well open to the CITA to call for a remand report and thereafter to inquiry into the matter and proceed to take decision. Therefore, it is the submission that the case should be remanded back to the CITA to undertake in such an
So
exercise.
this was the submission of the revenue.
Let's
This was the submission of the revenue. Then proceed.
We have heard the learned advocate for the appellant on the above submission, though in the order passed by the CITA, the word prima facie had been used. From the cumulative reading of an order passed by the CITA, we find that the case has been discussed on the merit, and thereafter a finding has been recorded but that the assessing officer was not justified in making the addition, and there was a positive direction to delete the addition. That is the first appellate authority says, your lords. In such it is finding.
If such is the finding.
If such is the finding, Mayor used the word prima facie could not make prima facie view, as the CITA has discussed the matter elaborately, taking into the consideration the factual position. Before the learned tribunal, the assessee had specified raised the ground that the CITA had exceeded the limits of power statutory bestowed as per section 251(1)(a) of the Act and grossly erred in law in restoring the case or to the assessing officer for action in terms of order dated 23rd November 2021 passed by the CITA. Though such a specific ground raised by the appellant before the tribunal and noted by the tribunal in paragraph 3 of the impugned order, this aspect has not been dealt with by the learned tribunal. Thus, in our view, not only the CITA committed an error of law by remanding the matter to the assessing officer for fresh consideration after having held in favor of the assessee, the tribunal also did not deal with the said issue. In the light of the statutory embargo, the order of the remand passed by the CITA is not tenable in law, and consequently, the same required to be set aside as well as the order passed by the learned tribunal. The Honorable High Court set aside two orders.
My lord, next paragraph is more important.
Chaudhary, please allow him to submit. Please interrupt. Yes.
Now, first appellate authority remand back to the assessing officer with a certain observation. Now, Honorable High Court set aside entire two orders.
So the adjudicating of the trial court's order remains.
Trial court's order remain. Now, if I presume the assessee has entitled to delete some two portion, who passed the order? Either assessing officer, as because till today the original order is in force, either the appellate authority who committed error to remand back to the assessing officer. Now, that's why, your lordships, now face order is required by the appellate authority. One of the authority passed the order, but today, the order of the assessing officer is in force because two orders have already been set aside.
I follow your argument. According to you, the assessing officer's order is in force. The order of the appellate authority as well as the tribunal has been set aside.
But what on the several observation is there? We have followed the observations time to time. So now, your lordship, one more reason as to why the order of the learned tribunal has to be interfered with is that the impugned order has been passed in an appeal filed by the SSC, and in such an appeal, the SSC cannot be a words of position as the learned tribunal has got into the correctness of the findings of the CITA, who held in favor of the SSC. Thereafter, has recorded this his opinion. CITA record his opinion, your lordship, partly allowed in some portion 3 lakhs and something. Admittedly, the revenue had not challenged the findings rendered by the CITA, which was in favor of the SSC. Therefore, this is also one more error of law which has been committed by the learned tribunal, justifying the interference with the said order. For the above reason, the appeal is allowed and substantially question of law are answered in favor of the SSC. Consequently, the application stands disposed of. Now, here 2 questions only substantial of law, your lordships. Now, in the appeal order, there is no order for the set aside the entire assessing officer order, or there is no direction to reassess by the assessing officer or the appellate authority. So, your lordships, the question arose before the passing this order, as the assessing officer has the obligation to proceed with the matter. That's why earlier say rectify as per the appeal order, now subsequently say issue the refund order, now sent to the for approval. Approval authority says no, as the order is enforced and the matter is pending for adjudication of the appellate authority. Because the appellate authority assessing officer is not entitled to reopen his own order sumoto. That's why section 154 invoke for mistake, the rectification of the mistake. Section 144 says, your lordship,
144 or
154, 154 of the income tax says, your lordship. I manage the copy of the books, your lordship. If
mistake apparent on the face of the record.
And if the enhancement is it, then your lordship notice is before passing of the order, notice is required.
This is not that case.
That is not the case, your lordship.
Anything more?
That is, your lordship. So the remand note, your lordship, passed on the by the annexer P1 is, your lordship, in accordance with law. Pending is appeal is pending for adjudication.
And there is no stay of the assessment proceeding.
No, your.
Anything more?
That is my submission.
Yes, Mr. Rajoti.
My lord, I am still at a loss, my lord, to understand Mr. Singhania's submission, but from what I've understood of this case, my lord, first of all, order of rectification, whosoever instruction, howsoever it is done, if there is an enhancement or amendment which enhances the liability of an SSE, a notice is required under subsection 3 of section 154 for this purpose. And my lord, to construe the order of the Honorable Appeal Court, my lord, in no uncertain terms, have dealt with this matter regarding 2 aspects. One, when the CIT appeal in no uncertain terms held that these additions are liable to be deleted, are to be deleted, but subject to some verification. Since the CIT appeal did not have the power to remand it, the High Court set aside the order of remand. With regard to the deletion of the additions which were held in no uncertain terms, upon a very exhaustive appellate order, upon reading the same, the Honorable Court has held that there is the revenue has not challenged the findings of the CIT. So it remains unchallenged and unfettered. My lord, the revenue has not preferred any appeal before the Supreme Court. My lord, pursuant to this order, appeal effect order was given. Remand was refund was calculated, my lord, and there is nowhere, no direction that the appeal has been revived. And if revived, to what extent? Where? My lord, there is not a whisper anywhere, neither in the appeal effect, my lord, Honorable High Court's order is there. Nothing should be read more by the assessing officer into the order unless the same is challenged. Nothing should be read. So he has given effect, which was fine, my lord, in 2024, 3rd January 2024. 1 year he did not issue any refund voucher. Thereafter he adjusted the refund. Now he makes a rectification application after 1 year, my lord. It raises some serious suspicions and doubts, my lord. Activities of the same person.
All right, anything more? Statutory, anything more?
My lord, if my lord is satisfied, my lord, in my favor, I have nothing more to add.
That I will consider while dictating the judgment.
My lord, if I am unable to understand, my lord, the appellate order
Mr.
stands.
Chaudhary, your simple submission is that the High Court, the division bench, while considering the order of the tribunal, was of the view that the order directing deletion remains, but with regard to further inquiry, it has been set aside.
My lord.
So,
I'm
and
waiting, your
in
lordship.
the giving effect to the order, that was complied with. Subsequently, under section 154, liability enhancement without issuing any notice, whether it is possible or not. And Mr. Singhania's
Apart
submission
from
is,
that, my lord,
and
one
Mr.
more prayer I have made in the writ petition. My revision against the penalty order is still pending, my lord.
Yes.
A direction may be
penalty
given to
order, Ms. Raichaudhary, they have said they have kept in abeyance because
my
of
lord.
this.
My lord, they have
Their prayer kept in abeyance.
me, my lord.
Their prayer kept in abeyance, your
Lord.
lord.
Yeah.
My lord, if they have not given me any written, I do not know anything about it.
I am not on the penalty. I am now
But
here
your lordship,
with this.
once the order was
My lord,
by
since
the appellate authority,
my lord
first
will
the
kindly
assessing
appreciate.
officer's order
Made a
rectified
specific
that
prayer.
next
My lord, if
calculation
Mr.
is there.
Singhania now interrupts me, my lord, he has finished his chance.
You proceed.
He has
Yes,
finished
Mr.
his
Raichaudhary.
chance.
Yes, Mr.
My lord,
Raichaudhary.
I have taken a specific prayer C, that the revision petition be disposed of. My lord, if my lord it does not give me a direction, my lord, it will be assumed that my lord has considered and not chose, did not pass any order. My lord, I will be suffering from serious prejudice. He's a 77 and counting his days, my lord, 77-year-old man.
No, revision is against which order?
The penalty order arising out
order,
of the assessment
no,
order.
but that is not under challenge here.
Yes.
No, my lord, I'm seeking direction that the whole case may be come to
All
some
right. Yes,
shape,
let me
my lord.
consider.
Some
Yes.
shape.
All right. This application under Article 226 of the Constitution of India is at the instance of an assessor and is directed against an order dated February 7, 2025, passed by the income tax officer, ward number 1 within bracket 1, Shiliguri. Full stop. By the order impugned, by the order, paragraph. The assessing officer passed an assessment order dated August 31, 2016. The assessee filed his return of income for the assessment year 2014-15, declaring a total income of rupees 10,23,320. The return of income was processed under section 143 within bracket 1 of the Income Tax Act, and the same was selected for scrutiny under capital CASS. The assessing officer issued statutory notices under section 143(2) read with 142(1) of the Income Tax Act. Hearings were conducted, and after considering the submissions of the learned advocate for the learned authorized representative of the assessor, the scrutiny assessment under section 143 within bracket 3 of the Income Tax Act was completed by order dated August 31, 2016, thereby determining the total income of the assessee at rupees 85,42, 009. The total income of the assessee was determined by the assessing officer after adding an amount of rupees 75,18,689 towards unexplained sundry creditors, which was outstanding as on March 31, 2014. Being aggrieved against such assessment, the the assessee preferred an appeal before the Commissioner of Income, preferred an appeal under section 250 of the Income Tax Act 1961 before the
National Faceless Assessment Center.
Before the National Faceless Assessment Center.
Appeal Center.
Appeal Center, full stop, paragraph. The appellate authority, the Commissioner of Income Tax within appeal, within bracket appeals, National Faceless Appeal Center, passed an order dated November 23, 2021. Directing the assessing officer to delete the additions subject to following conditions. Being aggrieved by the order of the appellate authority, by the order of the CIT within bracket appeals, the petitioner preferred an appeal before the Income Tax Appellate Tribunal within bracket B Bench, Kolkata. The Learned Tribunal, by an order dated February 9, 2023, refused to interfere with the order passed by the CIT within bracket appeals, bracket closed, challenging the order passed by the Income Tax Appellate Tribunal, in bracket B Bench, Kolkata, from a petitioner preferred an appeal under section 260 capital A of the Income Tax Act 1961. The said appeal came up for hearing on August 2, 2023, and the same was allowed thereby answering the substantial questions of law in favor of the assessor. Paragraph.
In the appellate authority's order, I find there are several heads, several companies' names. And only two is challenged under the two companies, one goodwill and your lordship Sasthis Trading is the before the High Court.
Thereafter, the assessing officer passed an order dated January 3, 2024, thereby giving effect to the order of the Honorable High Court and recomputing the income of the assessee by holding that the assessee / petitioner herein is entitled to refund of rupees 12,18,636. The order dated 3rd of January 2024 was, however, rectified by the assessing officer by a subsequent order dated February 7, 2025, which is under challenge in this writ petition. Paragraph. Mr. Rai Chaudhary, learned senior advocate appearing in support of this writ petition, submits that the Honorable Division Bench, while hearing the appeal filed by the assessee under section 260 capital A of the Income Tax Act, was of the view that the was of the view now, while deciding, did not interfere with the portion of the order passed by the CIT appeals directing deletion of additions, directing the assessing officer to delete the additions. She submits that the portion of the order of the CIT within bracket appeals directing further inquiries to be made was only set aside. She further submits that the assessing officer rightly gave effect to the order passed by the Honorable Division Bench while passing the order dated 3rd January 2024. She submits that subsequently, the same assessing officer enhanced the tax liability of the petitioner assessee by exercising powers under section 154 of the Income Tax Act 1961 without serving any notice upon the petitioner assessee. In support of such contention, she placed reliance upon the provisions of subsection 3 of section 154 of the Income Tax Act. Paragraph. Per contra, Mr. Singhania, learned advocate, appearing for the revenue, submits that the Honorable Division Bench in the order dated 2nd of August 2023 was pleased to set aside the orders passed by the CIT appeals as well as the order of the tribunal. He submits that the consequential effect of such an order is that the order of the assessing officer automatically stood revised. Thus, the assessing officer, now, he further submits that the assessing officer on a bona fide mistake passed an order dated 3rd of January 2024 directing an amount to be refunded to the petitioner, and immediately after detection of such bona fide mistake, the order dated 7th of February 2025 was passed. First, he submits that the liability of the petitioner, that the tax liability of the petitioner was not enhanced by the impugned order, but only a bona fide error in giving effect to the order of the Honorable Division Bench was rectified by the subsequent order dated 7th of February 2025 and the provisions of section 154 within bracket 3 of the Income Tax Act 1961 does not stand attracted to the case on hand. Yes, Mr. Singhania, this is all.
Let's see. Only one refund, order of the refund, but approved by the appropriate authority subsequent.
He further submits that the order of refund.
I am hand over the copy of the.
He further submits that the order of refund was not approved by the higher authority, for which the assessing officer passed the subsequent order dated 7th of February 2025. Yes. Nothing more?
Let's. And
yes,
appeal-
Mr. Chaudhary, your submission has also been recorded.
My lord, only the document he is relying upon, a copy may be given to my learned.
Already,
Yes, please
already
give it.
hand over, already
Yes,
hand.
given.
That's if the appeal is pending.
Mr. Singhania further submits that the effect of the order of the Honorable Division Bench is that the appeal before the CIT appeal stood restored to the file of the appellate authority. Yes. Heard the learned advocates for the parties and perused the materials best. After going through the assessment order dated August 31, 2016, this court finds that the addition was made.
Let's see, one in them. In the last order, I find the penalty order was passed, and in the last order, you know, see penalty order amount is included.
Which order?
Lordship. Here, Lordship, so cause of the penalty and order of the penalty is annexed here with your Lordship in the writ petition. That is page P7.
Yes.
Penalties for the original assessment.
Lordship, in the last
For the
order.
original against which a revision application is pending.
Mr.
And last order, your Lordship, the amount
You
of the
go through.
penalty is included in the order, your Lordship.
Which order? Which page?
Order 134, last column. Refund issued adjusted with penalty demand 12,18,636.
Yes, yes.
Including the penalty order amount, your Lordship, this order. So my understanding now.
Yes. All right. Akiola? Towards unexplained sundry creditors, which was outstanding as on March 31, 2024. The CIT appeals passed a detailed order and expressed an opinion that the additions made by the assessing officer cannot be sustained in the eyes of law. First up, the appellate authority, the CIT appeals, however, directed the assessing officer to delete the addition subject to certain conditions as indicated in the order passed by the CIT within bracket appeals. The Honorable Division Bench in ITAT 147 of 2023 passed an order on August 2, 2023 after framing two substantial questions of law which would be relevant for the purpose of deciding this writ petition and for which the same is extracted hereinafter. Page 92. One substantial question of law. One of I. The Honorable Division Bench took note of the provisions, took note of the amendment of the Finance Act 2001, by virtue of which the power to remand the matter back to the assessing officer for fresh assessment was deleted. After noting the provisions of section 251 within bracket 1 within bracket small a of the Income Tax Act 1961, the Honorable Division Bench observed that the commissioner could not have observed that in view of the statutory embargo, the commissioner could not have remanded the matter back to the assessing officer after having decided the case in favor of the assessee in its entirety. At that stage, the learned advocate appearing for the revenue submitted that the observations, that the findings recorded by the CIT within bracket appeals was only within double inverted comma prima facie case, was only prima facie inverted comma close and not conclusive finding, prayed that the case should be remanded back to the CIT within bracket appeals to undertake a fresh exercise. So, The Honorable Division Bench, after elaborately going through the order of the CIT appeals, held that though in the order passed by CIT within bracket appeals, comma, the word prima facie, double inverted comma, has been used, comma, from a cumulative reading of an order passed by CIT appeals, the case, the Honorable Division Bench was of the view that the case has been discussed on merits and thereafter a finding has been recorded that the assessing officer was not justified in making the addition and there was a positive direction to delete the addition. First up, the Honorable Division Bench further observed that mere use of the word prima facie could not make prima facie view, as the CIT appeals has discussed the matter elaborately, taking into consideration the factual position. First up, after going through the order of that Honorable Division Bench, this court finds that the Honorable Division Bench noted that noted the factual finding recorded by the CIT within bracket A that the assessing officer was not justified in making the addition and there was a positive direction to delete the addition. First up, the Honorable Division Bench was of the view that the CIT appeals committed an error of law by remanding the matter to the assessing officer for a fresh consideration after having held in favor of the assessee, and the tribunal also did not deal with such issue. First up, in the light of the statutory embargo, comma, it was held by the Honorable Division Bench, comma, that the order of remand passed by the CITA is not tenable in law and consequently the same is required to be set aside as well as the order passed by the learned tribunal. First up, a bare reading of the order of the Honorable Division Bench would imply that only the portion of the order remanding the matter to the assessing officer for fresh adjudication on merits was interfered with by the Honorable Division Bench, and the positive observations and the positive finding recorded in the order of the CIT appeals that the assessing officer was not justified in making the addition, and also there was a positive direction to delete the addition was not interfered with by the Honorable Division Bench. Thus, paragraph. This court is therefore of the considered view that the order of the assessing officer directing addition of amount on account of unexplained sundry creditors was in which was affirmed by the appellate authority was not interfered with by the Honorable Division Bench. First up, thus the appellate authority's order directing deletion of addition by the directing the assessing officer to delete the addition stands. Full stop. Paragraph. For such reason, this court is not inclined to accept the submission of Mr. Singhania that the order of the assessing officer automatically stood revived upon passing of the order by the Honorable Division Bench. Full stop. Paragraph. This court finds that the assessing officer rightly gives effect of the order of the Honorable Division Bench by passing the order dated January 3, 2024. The assessing officer passed the subsequent order dated 7th of February 2025 by exercising powers under section 154 of the Income Tax Act 1961. The effect of such order is enhancing an assessment or reducing a refund, as it would be evident from a bare perusal of the order dated 7th of February 2025 that the order dated 3rd of January 2025 directing refund was rectified by adjusting the penalty demand with the refund order and arriving at an amount of tax payable. Such an exercise undoubtedly falls within the scope of subsection 3 of section 154 of the Income Tax Act 1961. Section 154 within bracket 3 of the Income Tax Act states that an amendment, which has the effect of enhancing an assessment or reducing a refund or otherwise increasing the liability of the assessee or the deductor or the collector, shall not be made under this section unless the authority concerned has given notice to the assessee or the deductor or the collector of its intention so to do, and has allowed the assessee or the deductor or the collector a reasonable opportunity of being heard. Paragraph. It is not in dispute that no notice in terms of section 154 within bracket 3 of the Income Tax Act was served upon the petitioner. As such, there is no question as such. And also no opportunity of hearing was also afforded to the petitioner before passing the order dated 7th of February 2025. That apart, only for such reason, the order dated 7th of February 2025 calls for interference. That apart, the assessing officer, while passing the order dated 7th of February 2025, held that the impugned assessment order of the assessing officer passed under section 143 within bracket 3 of the Income Tax Act dated 31st of August 2016 remains uninterfered and still remains in force. That apart. Full stop. Such finding this court has already observed that the effect of the order of the Honorable Division Bench is that the uh, order of the appellate authority directing the assessing officer to delete the addition stands. To stop, in view thereof, this court holds that the observation made in the order dated 7th of February 2025, that the order of the assessing officer dated 31st of August 2016 is still in force, calls for interference. To stop, for all the reasons as aforesaid, the order dated 7th of February 2025 is set aside and quashed. Consequently, the order dated 3rd of January 2024 stands revived. First up, the authorities are directed to take consequential steps in terms of the order dated 3rd of January 2024. So with the above.
My lord, only one humble prayer, my lord. My revision petition may be disposed of. Prayer C, my lord. I'm deeply.
What remains with the impugned order?
My lord,
That assessing
my
of
lord, the
order
penalty order
goes.
stays at my
Chaudhary,
face,
if
my
the
lord.
assessing, that assessment order goes, this refund order revives. What
My
remains
lord,
with
but
the
that order
penalty?
stays at my face. Again, another complication will be created, my lord. They are not easy people, my lord. That much I can assure.
It has been submitted by Ms. Rai Chaudhary, and at this stage, it has been submitted by Ms. Rai Chaudhary, the learned advocate for the learned senior advocate for the petitioner, that the petitioner has preferred a revision petition against an order against a penalty order dated.
My lord, this is at page.
Penalty order dated December 21, 2023.
No, my lord. That is the application dated December.
What is the penalty order dated?
My lord, the penalty order is dated
20th February 2023.
Yes.
The penalty order dated 20th of February 2023. Has filed a which is still pending. First up, it will be open to the petitioner to approach the concerned authority for disposal. Petitioner will be at liberty to place this order before the revision authority, before the divisional authority in accordance with law.
I am deeply grateful to you.
Yes, next. Disposed of. Again, a revenue matter.
16. Will not trouble your lordship much with this.
Entire day.
My lord,
These are motions by effective hearings. What I am doing? This has taken so much of time. I could have disposed of.
1 hour.
Mr. Singhania, I have disposed of these matters, motions. It's nothing but a hearing matter. Singhania, I appreciate, but see, I proceeded only up to, I think, 20. What is this item number?
16.
21 or 22?
But I
No,
think
16.
But I think Mr. Singhania wouldn't have made any submission had the verdict been in the other way around. I hope so.
No, it's not that. What is the matters to be taken?
Yes, of course, my lord. We all want that. So many hearing matters are actually pending. I myself have, my lord, 4 hearing matters in the list. All 4 are
Now
mine.
we will cut the court saying that.
No, that I will never. That I will never.
You may not. The advocates whose
Lord,
motions are being held up.
At the learning stage, I learned from my seniors that a court is very good when you get the order, and
that is
it's out of bounds if you do not. So
yes. What is this matter?
Lord, this is a second round of litigation. Here, the only point that is to be decided is this: it's a 129 matter, section 129, seizure penalty. Our contention was the movement did not even start when they made the seizure. And precisely that was to be decided by the appellate authority. The matter was remanded by this honorable court. Went before the appellate authority. The only crux remains in all their documents, they are saying the goods were seized at Bhaktinagar. And I am saying it was seized at Bakra parking ground, which is in Bhaktinagar. They are not saying that it is not at Bakra. They are always saying it is at Bhaktinagar. That is the crux. And my contention is this: the goods were being loaded in that vehicle. Holi was in the vicinity. So all the laborers will go off for, Lordship knows, in their weekly off. Holi is a long-term affair for them. So the vehicle was parked in that parking complex. Around 30,580 kg was already loaded in the vehicle. 17,000 more was loaded. 70 kilo more was yet to come. That point of time, the interception, not interception, I should say apprehension, took place. And from the parking ground itself, they took control of the vehicle, they took it out. That will be apparent from my weighing slip, from the parking ground receipt, when I went and when I got out, and from their detention memo, which is in between, falling in between. Now, my only humble submission is this: they say you do not have the invoice or the way bill. I say, why will I have the invoice or the way bill? My consignment was not loaded completely. If I had the way bill or the invoice, then you will come up with the plea that I have misdeclared the goods. I have surreptitiously sold those goods which are not yet been loaded. So only when I start my journey, then only, my lord, I am supposed to generate the invoice and the way bill. And I am not saying that I forgot. I had not generated till that point of time. I am very candid on this. I have not generated the invoice nor the way bill because the goods were not yet loaded. Had those last 70 kgs not received, although it's a very meager quantity, then I would have to draw the bill without that 70 kgs. So that is why, my lord, I waited. And in the middle of that waiting, they had apprehended my truck. Now, Lordship will kindly see, come to the page 89, my lord. This is the parking receipt that I received. Lordship will see this is 5:55 p.m. issued on 5/3/2023. At the bottom, 4:30 p.m. 6/3/2023. This is the time when I went out. So if I went out at 4:30 p.m. 6/3/2023, the detention should be subsequently placed in order to be myself being in motion. Now, Lordship kindly sees the detention memo. When was it done? Lordship will take.
Where is the order?
Yes. I'm coming to the detention memo, 92, page 92, Lordship takes. It's written in hand at the very top, page 92. The goods conveyance bearing number such and such, carrying such and such goods was intercepted. I say it's apprehended by the undersigned on 6/3/2023 at 3:47. So that means I was still in that compound where they said check post Bhaktinagar. Now, check post Bhaktinagar is that area where Bakra compound is also there. I'm handing over a map, my lord. Lordship kindly sees this. Side, other side, copy down.
Yes, now what is the order which you are challenging?
Yes, I'm coming to that, my lord. Just Lordship kindly takes the map once.
Yes.
Lordship sees the point Lama Lodge, Yons. This is where my godown is. And 6 minutes from there, point A is the Bakra compound. And the whole colored area, this orangish colored area, this whole area is Bhaktinagar. So they are saying Bhaktinagar check post. It's like if I say Kolkata and Hastings. Hastings is in Kolkata only. Now, kindly, Lordship comes to the impugned order. The impugned order starts from page 130. This is the backdrop of the 36. This is the backdrop of the case.
Appellate order.
This is the appellate order. Because the appellate the order was set aside, sent to the appellate authority to look into this issue. Now, 138, page 138, aggrieved by the order, then Honorable High Court directed so and so. The Honorable High Court further held so and so. This appellate authority has received the order, the Honorable High Court on so and so hearing comments in response to personal hearing notice. Lordship can take it from here.
Yes.
In response to the personal hearing notice, the appellant, through its authorized advocate, appeared on so and so, duly heard. Furnished following documents, copy of tax invoice, etc., etc. I'm skipping it a bit, corresponding e-way bill number. By going through the e-way bill, it can be seen that the time of generation was after 27 minutes of interception. Quite true. I am on that only. I have generated it after interception because my vehicle was not fully loaded. Impugned vehicle loaded with the goods, quantity declared as well as tax invoice through the actual, though the actual quantity found upon physical verification was, Lordship says, only 70 kgs difference. 30,580 and 30,510. The tax invoice was prepared at the same time, way bill was generated, as has been admitted by the appellant at the tax invoice and e-way bill were not generated at the time of interception, since loading was yet to be completed. He accepts that thereafter. So the question arises as to why the tax invoice was prepared, e-way bill generated by the RTP, declaring quantity so and so, when the actual quantity was so and so. Now, Lordship, tarrying here for a moment once again. 70 kilogram of the scrap, the goods in question, had not been received by me till that time. And that is why I could not generate the way bill of the invoice. But once they had taken it into custody, I had to generate it. And that is why within, even if not having that
place of loading,
Pakra compound, it was stationed in a big commercial complex compound where all the goods are loaded. They are carried in handcarts because what happens, my lord, that road, it is not
Narrow.
suitable. Yes. So the goods come with handcarts and small vehicles. They get unloaded in that compound. And there are commercial laborers who put it on. And now since Holi was in the offing, we had parked it and we had, by installments, we had loaded the vehicle. 70 kgs were still remaining when they came to me and they caught me there saying that you do not have tax invoice or way bill. Of course, I will not have. Unless the goods vehicle is completely loaded, I'm not supposed to give the tax invoice or the way bill.
Mr. Bonik, what is your instruction?
It is a matter of state
Appellate authority of the state GST.
My instruction is, my lord, the weighment slip was dated 5th of March,
Yes.
6:22 p.m. 6:22 p.m. And parking slip entry was at 5:55 p.m. on the same day.
Yes.
So there was movement from parking.
Yes.
Weighman center. So once there's a movement under the provision of GST, he has to carry a delivery charge.
No, one has to know what is movement under GST Act. My lord, kindly says, first, when the lot of goods came, I have to weigh my vehicle to see that that supplier has given me a correct amount of goods. I go out of the compound to the weighman strip, which is right nearby, get it weighed, come back to the compound once again. Had I not come back to the compound, they wouldn't have got me there.
Weighbridge is near to this.
Yes, it is always like that, my lord. It is
At
within
least
15-20 minutes
3
from
kilometers.
the 3 kilometers. Yes. So
At
it is.
least.
Huh? Yes,
3
it is
kilometers.
15-20 minutes around this compound where it is always the practice, my lord, that wherever there is these commercial godowns, nearby, not only 1, 2 to 3 weighbridges are there. So this is what the matter was, and it is their contention only. I'm taking it as a reliance, my lord, that it is true. Weighman slip, because otherwise, how will I know how much quantity I have received? The goods journey only starts when it goes for the destination, not for any other purpose. And how do they know that I did not have delivery challan when I was going to the weighman slip of that only 30,580 kgs?
My lord, may come to page number 139 of my appellate authority's order.
Yes.
My lord, paragraph number
তাই
5.
তো হয়, তাই তো হয়।
My lord, on closer scrutiny of the delivery challan so produced by the petitioner, this appellate authority finds that the quantity of goods as mentioned in the delivery challan is found to be 12,900 kilos.
which is not in agreement with the net
Yes.
weight of the goods of 30,500.
Yes.
He is carrying a challan of 12,900 kilos.
True.
But his goods intercepted is carrying a weight of 30,500 kilos.
My learned friend is supporting my contention only.
No.
When it was
Says your delivery challan.
what they got there was that incomplete delivery challan, which I used to get it weighed and come back to the Bakra compound again.
So why did that delivery challan will be 12,900?
It will not be 30,580, my lord, because I have received a part of the goods first. It was
When it was weighed, what was the measurement?
12,500 something, 900 something. Nahi.
30,580.
My lord, that is thereafter. I have received the goods in 3 or 4 tranches. The first
Where is the
tranche.
delivery challan? Which you have produced?
Yes.
Page number 59, that is their submission that there was.
Yes. I'm coming to that.
Now they are saying that subsequently it was added, but in their submission they are saying that it was always loaded from the
59
page
also.
number 59, my lord. Paragraph number 4.
What happened? What is the penalty amount? You have paid.
Yes. No, I have. Yes, I have paid, my lord. I have paid.
So let them file affidavits to be decided.
Should.
Heard the learned advocates for the respective parties. It appears that the issue involved in this litigation can be decided only after affidavits are exchanged. To stop that affidavit in opposition be filed within
4 weeks.
4 weeks from date. Reply thereto if any be filed within
2 weeks.
2 weeks thereafter. To stop parties will be at liberty to mention this matter for inclusion in the hearing list. Immediately after expiry of the time fixed for exchange of letters. Yes, call the next matter.
My lord, in this matter, it is only the show cause notice and the orders being vague completely. I will show your lordship. Page 54, lordship kindly comes to.
Who is appearing?
My lord.
Yes.
54.
Rejected on the ground of limitation.
True. But the only problem is the show cause notice itself, lordship kindly sees.
If it is on the ground of limitation,
They
that
have
has to be
considered and thereafter they have refused my condonation.
Yes,
There is
on
my
merits,
predicament.
that cannot be.
On merits.
That cannot be. I am restoring that application. Let it be
Lordship
considered.
will kindly condone the delay. What happened? The Lordship will see what has happened because I have filed a condonation application. They went into the merit of it, and on that,
that cannot be gone into once they say they do not have the power.
no, that is why I am not. No. They are not saying that in this case.
Yes.
No, my lord, that is not what they are saying in this case. They have
accepted that.
Yes,
power.
they have gone into it and used
Yes.
certain Supreme Court
Yes,
document.
have accepted the appellate authority as the power.
Page 87.
Page 87.
87. It starts from page 86. 86, the bold portion at the top.
It is found.
It is found from the database. So he is considering my application.
87 top.
86.
Cannot be accidentally.
Huh?
Has been said.
My
The
lord is?
absence of any ambiguity, improbability, anomaly as to the determination of the. Please come to page 86 last.
Yes, my lord.
Last line. The provisions
Yes.
of 107 are expressed, clear and intelligible, and in the absence of ambiguity as to the determination of the period of limitation, in file the pair of cannot be exceeded.
Had the appellant
been allowed to file the appeal beyond the and had the appeal allowed to be accepted, would be reduced to a dead letter and unless number. So
yes, useless. Then, my lord, let their findings here not be an impediment to mine.
Restoring that application, it will be decided.
And just lordship will
without being influenced by the observations.
Yes, because the proprietor was in the deathbed for 2 long months in Bangalore. Let them take a lenient view. Lordship will kindly observe that. That will because
with Sarkar, you are.
I've also
view on condonation.
It's only I've also given the hospitalization certificates,
That is
etc.
the order. You have a copy of the similar orders passed.
1829. Copy down. 1829 copy down.
I will get at section 5 limitation.
My lord, here. Oh, sorry. 1829 of 2024.
1829 of 2020. This application
Sure.
under the petitioner has challenged the order
Case number হলে বের করে
of
নাও।
the appellate order dated
My lord, the order is dated,
Second April.
order dated
Second April.
2nd April.
25. Abdullah.
August 2nd,
Uh,
2024.
August 2, 2024, passed by the Additional Commissioner of State Tax within bracket appeals Siliguri Circle, Siliguri, West Bengal, in appeal case number GST/APP/179/24-2025, thereby rejecting the appeal on the ground that the same was not filed within the
Period of limitation.
no, was filed
Extended.
beyond the
Extended
period of
period of
4
limitation.
months from the date of communication of the order appealed against. Mr. Bhattacharjee, learned advocate appealing for the petitioner submits that the appellate authority has the power, submits that it is well settled that the appellate authority has the power to condone the delay. Paragraph, the issue as to whether the appellate authority has the power to condone the delay was considered by this court in WPA 1829 of 2024. In the case of Abdul Aziz Sarkar versus Assistant Commissioner of Revenue, Jalpaiguri Charge, Jalpaiguri and others. Order passed on 2nd of April 2025, wherein this court has held that in the absence of specific exclusion of Section 5 of the Act of 1963, it would be improper to read an implied exclusion thereof. The operative part of the said order is extracted, the relevant part of the said order is extracted hereinafter. The said decision is squarely applicable to the case on hand. Is squarely applicable to the case on hand. This court therefore holds that the appellate authority was not justified in rejecting the appeal on the ground that the same was filed beyond the period of 4 months from the date of service of the order. At this stage, Mr. Bhattacharjee, learned advocate appealing for the petitioner, would submit that the appellate authority has also rejected the application for condonation of delay on its merit. By entering into the merits of the said application. It is well settled that when an authority is of the view that there is no power to condone the delay, such an authority would not have entered into the merits of the application and decided the same. Paragraph, in view thereof, now, for all the reasons as I first said, this court is
Lenient view,
to
lenient view.
interfere with the, is inclined to interfere with the order impugned. Accordingly, the order dated 2nd of August 2024 is set aside. The application for condonation of delay is restored to the file of the appellate
But
authority.
it is not very happily drafted.
Stop.
May I
The
file
appellate
one more?
authority is directed to
The condonation of delay petition is not very happily drafted.
The appellate authority is directed to consider the application for condonation of delay on its merit and dispose of the same in accordance with law by passing a recent order after giving an opportunity of hearing to the respective parties and without being influenced by the observations made in the order dated 2nd of August 2024.
Grateful, I'm grateful.
শুধু একটা
CGST also represent.
ভট্টাচার্য submits that এখানে যেটা বললাম যেখানে আমি বললাম না যে could not have entered into the merits after having held that it is not যেখানে বললাম তারপরে তারপরে সেন্টেন্স at this stage, Mr. Bhattacharjee would submit that the application for condonation of delay was not happily drafted. So it will be open to the petitioner will be at liberty to file a supplementary affidavit stating in details the grounds for which the appeal could not be preferred within the stipulated time.
Grateful, great.
Yes.
One intelligence CGST department is also represented.
GST authorities are also represented. Yes, next.
This was now should be joined by. In this matter, my learned friend will be the pro forma respondent joining issues with me. Yes.
Former respondent.
Yes, here, my supplier. My supplier who they say that he's not in existence. And so
you have physically produced your supplier.
Yes.
Yes, who is this?
Yes.
His existence.
Along with
Yes.
invoices and everything.
Everything,
CGST
everything.
authority.
Yes, the CGST
yes.
authority.
Only the
Yeah.
physical presence of the
I have first time
But
on your right hand side.
I left it to no chance, Willard. So
but those documents are required to be verified.
that should be done by the appropriate assessing authority or the adjudicating authority.
What is this case?
My lord, here they again say that the person concerned supplier is not traceable. RC has been cancelled, so your ITC will not be given.
No, RC may be cancelled. So whether the
No, not at that point of time. All
may
retrospective.
have been
Yes.
cancelled subsequently with retrospective effect.
Yes.
But whether
GST 3B,
yes,
that my learned friend will say.
have you
Only for respondent number 7 here.
Yes.
So there are 11 different.
There are 11.
who have been
11
added. I don't know
respondents.
about the other.
Acha.
Altogether 11 response.
But have you
11 suppliers.
Five.
Only one supplier.
They're fine.
Here.
no, so you will be relying upon Suncraft.
That is the my lord,
As
let me
per-
ask
as
your
per-
lordship one thing.
As
As far as I know what is plaguing your lordship, Ecom Gill, perhaps Ecom Gill, that judgment which lordship was pointing out in the other, in my matter in the other day.
What has been held in Ecom?
My lord, Ecom Gill is only when there is an attribution of collusion.
No,
Yes, I'm giving Ecom Gill if your lordship wants to see.
no, not Ecom. So according to you,
My lord.
or in the Suncraft judgment,
My lord,
Section-
Suncraft judgment says, yes, lordship says,
Section
your lordship is the
16.
author of the judgment. Yes.
section 16(2).
Oh,
So if the supplier does not pay the amount,
Yes.
for that the purchaser cannot be held liable and his ITC cannot be denied.
Yes. This is in tune with Normada Bachao Andolan's case. My lord, I will show only 2 paragraphs.
But
আমাকে Normada Bachao দাও।
Mr. Bhattacharjee, what is your answer to section 41 of the
41, my lord, section 41, I will presently place 41.
41.
Availment of input tax credit. My lord is on which subsection, 1 or 2 or both?
two.
The credit of input tax availed by the registered person under subsection 1 in respect of such supplies of goods or services or both. The tax payable whereon has not been paid by the supplier shall be reversed along with applicable interest by the said person in such manner as may be prescribed, provided that where the said supplier makes payment of the tax, payable in the
That
respect
is
of.
the different thing. If he subsequently pays, you can re-avail.
Yes.
Re-avail.
But if the supplier does not pay, section
Yes.
41, so it will be rendered ocious.
Now, the only
This provision
question.
will be rendered ocious,
No.
Mr. Bhattacharjee,
No.
in all cases.
No, I will,
Mr. Bhattacharjee, the objective, as I have held in your that matter, the objective is that this revenue is being paid to the government.
Very true.
So now tax invoice may be a document.
Very
that it
true.
may show that I have paid to the supplier.
Very, very
But
true, my
the
lord.
supplier does not remit it
Yes.
to the government. So the government is losing this revenue. Whether
No,
you can.
no.
Yes.
There, my lord, I will subject to correction from my lord.
All right, so now.
Lordship, one, just one moment, my lord. I will clear the air on this. What is there?
No,
This subsection 2 is a
we
condition.
come in a different matter. Now, what is this?
Your
matter?
Lordship,
What is what now?
I would also like to
My
add,
only one humble submission is this: let the matter be remanded to the authorities concerned. Let the matter be remanded to the adjudicating
If
authority.
the others, you have to make.
other supplier,
Other
I
suppliers.
have
are
made
also
everybody a party.
But
All 14 I have made a party.
Mr. Bhattacharjee, if you rely upon Suncraft, then it's one thing. According to that, you are taking a stand. I need not see whether my supplier has paid or not.
Exactly, that is what I am saying.
So if that is so.
Then section 41
then
does
it
not
is
come
to be-
into.
Mr. Bhattacharjee, it is to be hard.
Lordship,
It is to be hard. Section 41.
my lord, what,
if Lordship has a
will be
suggestion, my lord.
rendered ocious if this view is taken.
No, my lord, section 41 is a directory provision, not a mandatory provision. Why I say this? Because
I will hear this. I will hear this. Because. that
will
will be
Lordship make it part hard?
No. Not part of, because while going through this, it struck my mind.
Very true, my lord.
So-
And that is, my lord, may I, for the purpose of academic
Because
discussion
collusion
only.
and other things, there may or may not be collusion. The fact remains, the only object of giving ITC that credit is that someone has paid.
yes.
You did
and
not pay doubly.
Very
Yes.
true.
So once has paid, you
You-
can
you
take
can
the
get.
benefit by taking credit. But if that amount does not go to the exchequer of the government, whether you
Very
are
true.
entitled-
Lordship, may I just
My lord,
two
And
paragraphs?
further, this burden can be fastened on the revenue to prove that, because you have entered into a transaction with your supplier, you know the
Exactly.
supplier. So you
Now,
have
my lord-
means and you have ways and means. What is that? Subsection that proviso says that if he pays, you can re-avail. So you can compel your supplier
How?
to pay. Has to be
I
otherwise.
cannot.
Mr.
Because
Mr.
the
Bhattacharjee, you can
registration
claim that
certificate
amount.
was given by them.
Mr. Bhattacharjee, if someone takes an amount without paying, you have remedies against him.
Money suit, Lordship.
Me, I do not know what
yes.
money suit or what suit, you have remedies. If you are supplier, you are taking advantage, you are taking supplies from that.
Yes.
And now you will be
But-
saying, yes,
Now,
let the
but my
department
lord,
proceed.
my lord will kindly
My
see.
lord, I am
It's a
willing to
historical
refer a
thing.
judgment, refer a
You have a
judgment.
party to that judgment.
Yes, my lord will kindly
This-
see one thing.
I think this aspect of section 41 was not
My lord,
considered.
may I just one minute, my lord, one thing. As far as my lord is saying that whether they have proved on, I have taken an advantage. My lord, I am supposed to take supplies only from registered dealers. Registration is given by the GST department after a prolonged inquiry.
The registration, the criteria for granting registration is one. But a registered dealer, if he fails to deposit,
Yes.
is a consequence.
Yes,
of
yes, that is different.
That consequence is, if he does not fail, if he does not pay, 41 comes into play. If you have taken credit, you have to
My
reverse.
lord,
If he pays, so it presupposes that you have ways and means to compel him to repay. If he pays, you can re-avail. But the only object of this giving credit is it has to go to the exchequer of the
My lord,
government.
on this,
Does not go to the exchequer of the government, whether you can take the credit. This
my
is
lord,
an issue
exactly
which
on
has
the
to be-
on the teeth of this argument, Honorable Supreme Court, in only 2 paragraphs, not more than 2 paragraphs, my lord. Narmada Bachao Andolon, Lordship must be knowing better than me. Paragraph 39 and 40, nothing else. The court has to consider and understand the scope of.
So what is the letter? We will
Acha.
consider this.
My lord,
Let us not.
my lord, on the basis of Supreme Court in the year 2023, Patna High Court, division bench held that it is clear.
No, Mr. Bonig, reserve all your energy.
Yes, yes.
For a future.
Moreover, 155 is there, burden of proof.
Why
155 of CGST Act is there regarding burden of proof. Yes, burden of proving upon him. That is my submission. Burden of proving is upon him.
Cannot say.
Absolutely.
Petitioner.
Absolutely,
You,
absolutely.
proceed against
We are-
him.
If I am claiming, if
we
I
are
am
not
claiming,
denying.
it is my burden to prove.
We
But
are
to
not
what
denying,
extent?
but the burden of proof is
Proof.
upon him.
To what extent, my
To
lord?
what extent it has been deposited.
Otherwise,
Otherwise,
how can I control that?
Mr. Bhattacharya,
Whether
otherwise,
here,
it has to be reversed. Unless it is paid, you can, if it is paid subsequently, that is the proviso,
Yes,
which you have
yes.
rightly pointed out. You can re-avail. So it's
Re-avail.
not that you are gone.
yes,
So
yes, it is,
No, my lord.
this case,
is the burden.
supplier is,
Then, my
so
lord,
you have control over the supplier.
not exactly
So you
control.
want supplier.
Lordship will see,
supplier.
Lordship will say, out of 14, only one has come. So Lordship can understand the control. Only one has come.
Out of 11, out of
My
11.
lord, I may be protected in the meantime. Because the
Protection.
because
kind
the
of protection?
demand is staring at my face, my lord.
What kind of protection?
A demand is
Then you
staring
have
at my
to deposit
face.
some amount.
Yes.
Kind.
Because tribunal, if you go to the, if you had gone to the tribunal, some amount is to be protected.
My lord,
Pay
there
that.
is
Pay
your
that.
lordship's order where it says that since the tribunal has not been made or constituted, this can be matter can be delegated to the tribunal. And I will wait.
Here also it can be given. Division bench judgment is.
Yes, division bench judgment is
So
also.
pay some amount.
No, my lord, the payment part has division bench only settled that no payment is needed to be
Where
made.
is that?
Yes.
No payment is required.
Yes, no payment
For
is required.
stay.
Yes, my lord,
I
at least
don't think-
8 or 9 judgments, my lord.
So
Thou.
Yes, Mr. Boni, what do you say?
Yes,
to
it
this?
is. The first matter was, I'll tell you, lordship.
There
The
is
first
no
one
question of
was
stay.
GL Kundu. That was your lordship's judgment. Then thereafter, after GL Kundu town nahi. After GL Kundu, then there was, my lord, Anish Patel's judgment by the
Show me
division
one
bench.
where the division bench said that you need not deposit any amount. But there are other judgments also which says a similar amount. The
Yes,
writ
I
court
will,
can
I will,
direct.
I will tell you, lordship. First was Rico India. First was Rico India in Bombay High Court.
Can pass directions as a condition of stay. That also is here.
That, my lord, I know, but that I will beseech your lordship not to venture into that.
These
Lordship,
something, what is the provision in the tribunal? If you had gone to the tribunal, what is the-
10%. 10%.
10%,
my lord,
10%,
kindly see.
What is the amount of 10%?
10%.
What is the-
10% that is out of
kindly
out
see.
of
What is the amount of
5 lakh 66,000. No, huh? 5 lakh
দাঁড়ো দেখে বলছি
plus আচ্ছা plus this তার মানে 10 lakh 11 lakh something 11 lakh 33 11 lakh 1 lakh something 1 lakh 25,000 around that.
because this was your lordship's judgment.
No, the division bench judgment.
Yes, division bench judgment is that is also referred in there. That is also referred there.
19
No,
lakh
with regard to
33,000.
the quantum.
Yes, that is also referred there, my lord.
No, you have to pay that judgment of the division bench for also there. You want to stay, here is, I say, liberty to approach for that.
I will take that liberty, my lord. I will take that liberty to approach.
Here can be decided, read court also can entertain.
But I will tell you,
What is
lordship.
the amount of 10%?
That I will say.
1 lakh 30. Pay that.
10% will be what?
My
After
lord, may I
calculation,
indicate one thing?
10% will be 1,25,000 something.
All right.
Nothing more.
Pay that.
My lord will not kindly direct me to pay. I will come up with an application later on for interim order. They are not pressing for recovery. They are not pressing for recovery. Lordship will not opine anything on that.
After hearing the learned advocates for the respective parties, this court feels that this court feels that this court is of the view that the issue involved with the retribution can be decided only after exchange of evidence. Mr. Bhattacharya, learned advocate appealing for the petitioner, does not press his prayer for interim order at this stage. So let affidavit in opposition be filed within 3 weeks from date. Reply thereto even if he filed within 2 weeks. 4-2, liberty to pay for inclusion in the hearing list after expiry of the period. Yes, call the next
My lord,
matter.
only one humble indulgence. this particular matter is running in your lordship's list from the very day one.
Which matter?
Item number 99, 93.
Yes.
93. He's a nonagenarian citizen, my lord.
That proceeds serially.
No, not today. Your lordship has heard me enough today. It is 93 of the day's list. If something can be done for the matter.
93, if
90
I can reach the motions, you will be finding there is
It's not
one large
hearing.
bunch.
It's not hearing. It's not hearing.
Motion.
First time.
Yes,
Appearing for
yes.
the first time, my lord.
Motion,
Yes.
you will be finding from 56 to, there is one bunch.
Yes.
So if that is taken up, after 2-3 matters, your matter can be reached. So let me proceed till that. Yes, next.
Very. I'm grateful to my lord.
Yes,
Lordship, in this matter, I need some time because
you are for the petitioner.
petitioner, Lordship, because I
I'm for
want
the
to
ESI, my lord.
notification that ESI scheme is not under the Alipurdwar. This scheme is not under the Alipurdwar. Alipurdwar is excluded. That's why we need time.
Want to file supplementary affidavit?
No. We want to
Which
rely
matter?
upon notification. That notification we are searching.
All right. So when do you want?
Next circuit.
As paid for by the learned advocate for the petition list. This matter before the next matter. Yes, next. Yes, 20.
20 I'm for the state.
And for the petitioner.
Yes.
My lord, item 20, 21 and 28 are praying for next circuit.
As paid for by the learned advocate for the petitioner, 20, 21, 22.
28, my lord. 20, 21 and 28.
20, 21 and 28.
Yes, my lord.
21 and 28. As paid for by the learned advocate for the petitioner. This matter before the next available circuit. Yes, call the next matter.
My lords, I am led by
I'm on the
Mr.
petition.
Ambush. Right. He's appearing.
Am I visible and audible both, my lord? Am I audible?
Yes, Mr. Rai.
Am I audible?
Yes,
Yes,
Mr. Rai, you are
I
very
could
much
not come,
audible,
my-
visible
my-
also.
He is supposed to come, my lord.
Also, no,
He
no,
left
I
on
did-
Thursday.
But
Mr.
I
Rai,
could not come.
No. Virtually, you
That
are
is
not
going
permitted.
on. No,
You
Where are you
assure-
now, Mr. Rai?
one matter is going on. I
You
could not
assure
come,
me-
my lord. I have a ticket. but I-
Beautifully decorated
one
ceiling.
matter is going on with the division bench.
Yes.
With the division bench.
Yes, Mr. Rai.
I place. Here. So logically come to page 28. We have a tea garden. Can you see the subject? Permission for is one.
Page.
Permission for 28.
28.
Yes.
Permission.
My district collector passed the order. We have the tea garden. Permission for felling of 515 number of shade trees in the retained area of the Shorini tea estate. That has been given in terms of section 4 of the West Bengal Land Reforms Act. My lord, because my junior can provide you the act. Can you see the Forest Act? Forest Act first.
Forest Act.
Forest Act.
এটা দিয়ে দেন।
Mr. Rai, what is the issue?
Is that, my lord? In my tea garden, it's a return land. They allow me to fell the trees. I felled it. Then the forest divisional forest officer has given me also TP. Then somebody lodged a complaint, FIR. Then that was, my lord, I challenged it. A person ordered a single bench. That was a final report was given. Then a person moved before the National Green Tribunal. Agreed, Green Tribunal said no, we did not interfere because criminal court has already decided the issue. Only said I had to, my lord, cultivate some saplings of the trees. That I also done. Now I ask them to allow me to leave my felled tree lying in my house. In contrary to the issue the notice for sale of my auction for sale of my goods. But the SDLR, I have no authority. It's absolutely misplaced of public office. I just
What is the order which you are challenging?
Kindly,
What is the order?
I have not changed the order here, my lord. No, I have not changed the order. They have issued the notice for
Where is
selling
that?
it. That, that is at page 92.
92.
Yes. In my absence, they have given this notice. The 30th December, that was done in my absence. SDLO.
Yes, what happened to this thereafter?
My lord, the goods is lying with us. So after this, we came to know
What
that
is the fate of this auction?
Auction was held, but I came to know from the SDO's
Auction
office,
was
my lord,
held.
in our absence. So, yes,
Auction
in
was
our
held.
absence.
After that, what
but
happened?
Goods are, but the goods are lying with us, my lord. At any day they can come and take the goods, my lord. My goods, how they have auctioned it, unless it is vested to the state government. SDLO has this is a case of misplaces of public office. I just place it, my lord. Can you allow me? Can you allow me to place it?
Yes,
Can
yes.
you come to page 28 for a moment?
Yes, yes.
My lord, before that, you also see the act itself. My junior has given a
Forest Act.
West Bengal trees protection and conservation and non-forest areas act. This books.
2006 Act.
Can you give the books? West Bengal Trees Protection Conservation Forest Act.
Yes.
Got it, man?
Yes,
Got
yes.
it, man?
Yes,
Can
I've
you
got.
come to section? Can you come to section 5?
Section
5.
5, yes.
A competent authority may, on receipt of the application from a person to fell a tree or otherwise dispose of any tree for such purpose as may be prescribed, and on being satisfied with regard to the legality of the document, was a proof of the ownership or lease of the land, such tree stands after making an inquiry, manner as may be prescribed, grant permission in writing to fell tree. Now, kindly come to second proviso. Provided further, second proviso.
Yes.
In Shodor subdivision, in Darjeeling, Kalimpong subdivision and Kashan subdivision, this is Darjeeling, no such permission shall be required. If a riot obtains permission under provision of section 4A of the Original Land Reforms Act 1955, read with rule 474 of the Original Land and Land Reforms Manual 1991. Can you see the Land Reforms Act for a moment?
Yes, Land Reforms Act. Yes.
Can you come to section 4A? You see, in the Shodor subdivision, Kalimpong subdivision, Kashan subdivision, the district Darjeeling, the collector of the district may from time to time give direction regarding the form of cultivation to be adopted by riot, this is a plot of land, and prohibiting a riot cutting more than one tree from the plot of land except with the previous permission writing to the collector. Such other officers may be prescribed by the state government in this behalf. So in exercise of this power, collector has given me permission to fell 5 numbers of shade trees. Can you at page 28?
Yes.
You also kindly see the species. The species of the Dhupi, Chiloni, and Simon. Can you see the Dhupi is there? Last species.
Yes, yes.
So this order was passed. Then my can come to page 30.
Yes.
The divisional forest officer, my lord, direct to the range officer, after verification, issue was TP for transit at page 30, my lord.
Yes.
The divisional forest officer, direct the range officer, after verification, issue the transit passes for movement of those transit, those felled trees, my lord. You also got it, my lord?
Yes, yes.
My lord, then what happened? There's a COVID has come. We have asked for extension. That has been given at page 34.
Yes.
Can you come to 34? So time was extension for felling within 60 days, my lord. We failed it.
Yes.
Now, my lord, now can come to page 35. All on a sudden, the range officer asked us, and the 2nd April 22, Sergeant Major, the undersigned instructed you the logs which have been kept inside your tea garden, said logs handed over to you for Jima until further investigation completed. Divisional was directed to issue notice, issue a TP. He asked me to keep it in my Jimba. So she got it, my lord, at page 35.
Yes.
So, my lord, the page 36 is my Jimba in the name of my employees, and the list of the measurement list are given. These are goods. Can you come to page 46 for a moment? This is total 69 duplities, 7 were logs. The at the last, my lord, got it, my lord, at page 46.
Yes.
So total 69 duplities, 7 and 2 are logs. Volume, this is the total goods are lying in our Jimma, my lord, till the further investigation. Now, my lord, kindly come to page, my lord, this page 48.
Yes.
A person lodged a complaint before the police that we are felling trees illegally. A criminal case was initiated. Can you come to page 48? Below, my lord, a criminal case was initiated.
Yes.
Against that, we moved the High Court. Can you come to page 49, my lord? The quashing petition. It starts from page 49, operative part at page 51. My lord, Honorable High Court directs the petitioner to produce all documents of the permission to the investigating officer of this case 7 days from the date of this order. If on the basis of the said order, it is found that petitioner entitled to cut the fees in accordance with law, he shall file final report in the meeting police station case number with or harassing manner in accordance with law. What is, my lord? Page 51. The opposite part of the order of the Honorable High Court. So Honorable High Court is directed them asked to produce the document. My lord, on the basis we produce it. Now police file the FRT at page 51. Yes, police file the FRT. So my lord, entire thing is complete. Now, my lord, in the meantime, another thing has come. Can you come to page 53?
Yes.
On the basis of complaint, the Green Tribunal in Principal Range has taken the cognizance that at page 53, my lord.
Yes.
You got it, man?
Yes, yes.
Page 53, my lord, on the basis of complaint, they took Suomoto case that there is a environmental impact for felling of trees. Say they initiate the case. Now, Your Lordship, can come to page. At next order is at page 57.
Yes.
My lord, in the order of the 57, Your Lordship can see paragraph 4, 50, it is at page 58.
Yes.
Everybody, the concerned officer, concerned department, and myself are having increased the respondents. Yes, my lord.
Yes.
Now can come to page 60. On 7 December 2023, man, see in this order you see relevant paragraph 5 at page 61. Can you come to page 61?
Yes.
Paragraph 5. The district magistrate Darjeeling Regional 4 has filed affidavit stating therein that in a meeting of convened by the district magistrate Darjeeling attended by the divisional forest officer Kassian, forest officer submitted recommendation on point of number 1 to which are as follows. No further cutting of trees on the sloping area of plot number 769 at Bhajang may take place, and replantation and stabilization of the area may be done with specific time named by the tea garden. 2. It was suggested by the ACF that indigenous species of trees duly prescribed by the forest shall be planted at the same plots, but the duty trees are failed in a ratio of 1.5 or the cost of the project plan. You got it, my lord? This is a recommendation. Now, my lord, this application was disposed of. Your Lordship, can you come to page 68, 66, paragraph 14. The green tribunal said, we find that since the Honorable High Court had already taken cognizance of the matter and issued accurate decisions, nothing further remains for adjudication. The present original application is accurately disposed of. So tribunal also, we get rid of the tribunal also. It's the only recommendation. My lord, next one, we ask them to leave the goods, allow to us to leave the goods. Next is 68.
Yes.
68 to 79, all the office I asked them to allow me to leave the goods. Now you also can come to page 80.
80.
Yes.
Yes.
The 80 divisional forest officer asked us to comply with this recommendation. Can you see? The government shall plant saplings of indigenous tree species as prescribed, forest department and ratio. That was a recommendation. Ask them to comply with this. This is on 19 January 24. They have given the next data, the same thing at page 82.
This you have done.
Yes. Next one can come to, we have said that at page 84, we complied with.
Yes.
At page 84, we have complied with. Now, all of a sudden, at page 85, we have seen that subdivision land officer has given notice for general auction of these goods. And this is the first notice. Can you see that 3rd April 2024 auction will be held. This notice was given by subdivisional land reforms officer.
Yes.
We immediately wrote to DM, my lord. Next page.
Yes.
My lord.
Yes.
After, when we wrote the DM, I can go page 91. They kept it, they stopped it. The auction was stopped. Page 91. By general knowledge, they stopped. In this situation, all on a sudden, I stated in my petition, my lord, that at paragraph 14A, page 13, I can come to page 13, my lord. At page 13, I say, page 13, my lord.
Yes.
Paragraph 14A. Recently, the petitioner too has learned from the office of the subdivision of the Misleading, the public auction of that failed fees lying at Scrutiny tea garden are held on 30th October 24 without giving any prior to the petitioner. Such auction was held on 10th in a secret clandestine manner. The petitioner too has now procured a copy of the general notice of public auction on Apple and copy thereof is enclosed herein. So that is the my lord last notice at page 92. So auction was held in our absence. So we have apprehended any day they will come with the police and take our goods.
Yes.
They may
anything more, Mr. Rai?
No, they may say I am not complied with. I am ready to comply with. They may say now, my lord, I am apprehending that we have not, my lord, cultivated the saplings. I am ready to. This is my point.
Have you complied with that, or you have not complied with that? Planting.
Once I have complied with, they have not given any objection.
Now, what is your prayer now?
My prayer to set aside this and allow me to release my goods. Goods are not taken.
Yes.
Yes. My Article 300A is infringed. My point is that Article 300A is infringed without taking any recourse of law. They can't do it. My goods.
Yes.
My lord, I have, my lord, an occasion to obtain a very short report for my consumption.
No, what happened with the auction? Auction held or not held?
Auction held. My
What
lord, before
happened
that,
thereafter?
the lowest bidder already, successful bidder already issued the allotment letter.
But it was the logs which was in the property of the
My lord, I am
petition.
my lord, this is the reason, my lord. My lord, may I hand over and along with this, my lord,
My lord, Your Lordship, kindly allow me to leave, my lord. Not as
Really,
Chief Justice.
No, I could not follow. You want to leave
Can you-
or read?
Yes, my lord. No, leave, my lord. Can allow me
Leave.
to leave. Can you allow
Leave.
me to leave, my lord?
Leave.
Chief Justice
Leave.
matters.
Yes, yes, yes. Yes,
Can- My junior is there.
yes.
Milord, the report for my own consumption and Milord certain document, Milord, which I have annexed, Milord, there I have handed over a copy, though it is my internal communication, still it's all our public domain.
Yes.
Milord, very interesting matter, Milord. First, kindly come to the page 7 of my report. Milord, kindly mark that is the first prayer that I would be filling 515 numbers of shade trees. Kindly, my lord, mark it shade trees.
Where it has been said?
7.
Page number 7 to 8. Page number 7 of this report.
No, 4.
4 of them. I was looking at
Not report in the annex.
all right, shade tree felling. Yes.
Yes, my lord. This is the first prayer, my lord, from the garden.
Yes.
Shade tree filling. This is to inform you, I would be filling 515 numbers of shade trees in the required tea garden. I do hereby undertake to plant 1:20 trees at the required tea garden. Then, my lord, I shall be highly obliged if the meeting of the said committee for filling of shade trees of the tea garden is held with the district manager with necessary recommendation favoring the mentioned work at the earliest. So this was the, my lord, first prayer. The shade trees for purpose of filling the shade trees.
What is shade tree?
Shade trees, well, yes, absolutely. What is shade trees, my lords? Because under the trees, beneath the trees, there will be a tea bushes, which can protect the tea bushes, my lord. These are the, my lord, the certain trees, not the forest. Sometimes it cannot be a forest produces. Suppose now shimun. These the other Chilone, these are the some varieties of the trees which can protect the soil as well as to protect the tea bushes. With my limited understanding, Miller. So and also in the garden, sometimes they also plant, suppose dhupi and also shal, teak. There are the other varieties of the
shade trees.
These are not the shade trees. These are not the shade trees. Because shade trees is totally different because under the Act of 2006, which ultimately in the district of Darjeeling, Kalimpong Hill region area, 4A, the such power is vested upon the district magistrate on setting up a committee. Then only if the district magistrate or the committee constituted for the purpose is being satisfied that these are the trees, shade trees, for the purpose of filling, for the protection for uprooting the tea bushes or for other purposes, for the replantation, then the shade trees may be allowed for such removal. But suppose not tea, so this cannot be considered as a shade tree. So their prayer is a shade trees for removal. So, my lord, kindly come to the 4, 5, 6, I think. It will be 6.
It's 6.
Yeah, 6. 6.
Yes.
My lord, this is the application form, right, my lord, which has been filled up by the welfare officer of the Sovereignty Estate. My lord, kindly see name of the applicant. Top, serial number
Welfare
1.
officer, yes.
So he is the person attached with the garden or tea estate. He made this application. Performer. So, my lord, the plot numbers was given.
Yes.
Now the
Number of trees have been given.
Now, my lord, kindly see the purpose 7.
Repairing of labor quarters
Yes.
and pipeline.
Now, my lord, kindly come to the application form.
Yes.
I do hereby this is to ensure that I will be filling 555 number shade trees in the required tea garden area, page that, my lord, 4. First application. And I propose to comment the filling of shade trees as soon as I receive the final permission from the district magistrate. Shall be highly obliged if the meeting of the said committee for filling shade trees of the tea garden is held and appeal for district magistrate recommending favoring of the above mentioned work at the earliest. So, my lord, the generally the shade trees removal of shade trees for the purpose of, my lord, the plantation of the area. Suppose the tree bushes are more than 100 years or 80 years, they cannot produce the leaves, then it should be uprooted. And so for that purposes, for, my lord, the for compatibility, my lord, these trees are removed and the plantations are made. But, my lord, here the purpose was that repairing of labor quarter and pipelines. My lord, repairing of labor quarters, my lord, this garden is also, my lord, also under the tea tourism project. I do not know whether it is approved or not. I have asked my officer to find it out. They are also running this business of tea tourism project. Around 6, 7, 8, my lord, the rooms are being sold. They use for this purposes. So that, my lord, is separate chapter. I believe. So, my lord, the under the garb of repairing the, my lord, the labor quarter, they intended to construct a further, my lord, the construction for such tea tourism project under the garb of that. Now, my lord, 9. These are the whether the tree proposed to be felled is rhododendron, ornamental.
Where are you
9,
getting this?
serial number 9, page 6.
Oh, page 6. Oh, I have gone to page 9.
Sorry, serial number 9.
The serial number 9. Yes.
Whether the purpose is proposed,
Yes.
that field is rhododendron, ornamental, or has any other ecological importance or not? No, said no. Ecological importance, said no. Not for rhododendron, other ecological importance. Now, that happened. The as per the 4 land reforms and in view of 2006 Act, the committee constituted a joint committee. Report is in their favor.
Report is in their favor.
Report is in.
Permission also granted.
Yeah, this is the reason why permission was there. Now the twisting. Very interesting, my lord. Then, my lord, this vegetable. Then the permission was the sought for from the DM by the DFO, the then DFO, which has been shown. Then district magistrate, my lord, issued the, my lord, the formal approval. That is, my lord, at page 12.
Yes.
Is given approval, my lord. So in the species, it is mentioned that Thupi, Chiloini, and Shimul pieces. Plot number 769. Kindly mark this 769. I'll refer this 769. Plot number.
Where is the plot? Yes. 7. No, there are 4 plot numbers.
I am marking 769.
Yes.
Because, my lord, what happened? I will bring to the record by way of filing affidavit of opposition. This 769 is fallen within the category of a forest land within tea garden. Now, my lord,
According to you, 769 is not owned by the petitioner, or is
Forest-
not the riot in
no,
this?
no, the lease may be granted. My lord, I have to check. Lease may be granted for these, my lord, the plots. My lord, I am not disputing at this juncture because I have to, my lord, unless I make a research, my lord, I will not make a wrong proposition. But it is within the classification, my lord, within the tea estate, that 769 is
Forest.
shown is a forest land. Now, my lord, first, now is a twisting. 1/6/2022, my page, my lord, page 40.
Yes.
Lordship got it?
Yes.
This is the subject, my lord, inquiry into filling operation at Shoreni Tea Estate. This is, my lord, after the post-approval letter has come from the DFO. May I read the second paragraph? No, first paragraph. Pursuance of this office order number quoted reference, inquiry into the filling operation of Shoreni Tea Garden was undertaken by the committee comprising Assistant Divisional Forest Officer, Kashian Range Officer, Bamanpukri Range, and Beat Officer, Puguri Beat. The inquiry report is attached here for your perusal. I'll deal with that later. The three main committee constituted BLRO, Mayor Biri, Beat Officer Satin Gram Panchayat recommended the filling of shade trees of plot number 769 Satin Sir, Shoroni Bosti under Shoroni Tea Garden. But it seems, kindly mark now here, that sufficient information was not furnished in the inquiry report. On field verification, it was found 253 numbers of thupi trees of plot number 769, which I have marked it below. Recommended for filling were not shade trees.
Yes.
And there were no tea bushes present beneath the trees. Since West Bengal Trees Protection Act of 2006 provides for filling of only shade trees. If your lordship kindly take up 1/2006 section 5, section 6, that it deals with the, I'll deal, Malad.
Yes.
Deals with the, with Mr. Day, Malad has placed before your lordship, deals with the permission for shade trees. Similarly, Malad, the 4A of the Land Reforms Act, it has given certain powers enjoins with this hill region area, the district magistrate, with the after constituting a committee made.
So here there is a recommendation for revocation of that partition. What happened after that? Yes, it was revoked.
Hence, you are, next paragraph, kindly see. Yes. Hence, you are requested to take necessary action for revocation of filling permission in this regard. A decision may also be taken at the earliest on the fate of failed produce kept under custody by Range Officer Bhavan Pukri on Jimmanama in Shoroni Tea Garden premises. Since the produce is perishable in nature, appropriate steps may be taken in this regard for the start of monsoon. Yes. So, Milord, this the report kindly consult, Milord, kindly turn to the next page, page 15.
This is the report. Yes.
Milord,
now what happened? That permission was revoked.
This is the reason the Milord auction sale was proceeded.
So where is the revocation
Where is the revocation?
of the page 18?
Lordship got it?
Yes.
Immediate
So
suspension
this
of
was suspension of felling operation.
Yes.
On 22nd of April 2022. And when these trees were felled?
Prior to that. Because what happened in the meantime, COVID, the embargo has, was in force. So by this time, they could not lift.
Oh, this is the reason this failed produce will be kept in the custody of range officer?
Yes.
Till the inquiry is completed.
Yes. So, my lord,
inquiry was completed.
Yes, this is the inquiry report which I was intended to place. Page 50.
Yes. What is the report of the inquiry? What does
Next,
it say?
kindly turn to the next.
Was not furnished on feedback furnished. Recommended were not shade trees and there were no bushes. Yes. So this is the final report.
My lord, kindly come to the report portions, second page.
Yes.
60, page 60.
Yes. This
the tea garden, next paragraph, management then started filling operation. Then photos and public opinion against the filling operation started appearing in the social media. Therefore, they have a huge filling of the that is a pine tree. Therefore, DFO Karshian stopped the filling operation, cancelled the extension order, and directed the red officer to take custody of failed produce. Again, sir, the ultimate
so
is that
custody was taken for this reason.
For this purpose. Now, my lord, they are to satisfy before this court that these are the trees falls within the meaning of shade tree. Then only, my lord, now what is the purpose of the auction? Auction is that to secure the produce. It is not that the amount which has been deposited or to be deposited through this auction process sale then it should be kept in the the exchequer of the state
If he
exchequer.
succeeds, he can
He
take
said,
back.
yes, he take back. Because it is a perishable nature. Otherwise he will make a, suppose he succeeds for the argument's sake, then he will make a damage. He'll ask for a damage. To protect and to preserve these purposes, the auction sale, for the benefits of the petitioner.
It has been sold.
It has been sold, auction, then the background I'm giving. Then because it was in 2019, the permission was granted. Then from 20, because the permission remained valid for 90 days.
Thereafter extension he has shown.
In the meantime, the COVID embargo. Then thereafter, this the extension. Then in the meantime, this has come to the in the social media. Then our team, petitioner, before the NGT, who is protecting the environment and the forest, they approached to the NGT, and also they filed a criminal case. Now, what happened, Milord? If you Lordship has seen in the quashing proceeding, the court said all the documents to be placed to the investigating officer. So, what are the documents he has placed? The documents which is in his favor. Lordship got it. Because
these documents are not before the.
Because this is the reason the FRT has come to a culmination into FRT. Then Milord showing this FRT, this how they are is a Milord what to say is organized mechanism. Showing this Milord this FRT, NGT was approached. Milord, see, we have invoked the jurisdiction of the Honorable High Court. Is season of the matter. So Milord, the NGT said, oh, all right, Honorable High Court is in season of the matter. Very good. We are not touching. Go back to the High Court. The moment High Court said this, now in the meantime, Milord, kindly your Lordship will recall, Milord, in 1997 or 1998, when we were in the Calcutta, Milord, there was a direction for a Milord afforestation. And there was a direction that if you remove these trees of 500, then the 200 trees to be. Then the report has come, yes, 200. Then when the special officer was appointed, has seen the spot, has seen the basil trees of 500 was planted. Lordship, remember that. So this is the situation, Milord, what happened here. There are other, Milord, the series of documents. Then we went for an auction. Then the government, the Forest Development Corporation say, as of now, it has not been declared or decided is the forest producers or the private producers. Then the forest producers, then there is a separate rate is already been fixed. But if it is for private producers, then to be decided the rate to be fixed for proceeding of auction. Then a committee constituted. Then the committee, when the committee constituted, Milord, then they have fixed the rate of these producers. Then the auction was floated. In the first round of auction, we could not complete it because the ensuing the Milord, the parliamentary election at the moment. It was stopped. Then again matter was revisited for such Milord taking auction. So that means it was in the public.
But the petitioner was also entitled to participate. Why did it
not even served any
It is
notice.
in the public domain.
Without notice.
It is in the public domain.
And my lords, under what
Just a second.
authority are they auctioning?
You could have intimated him.
My lord,
My lord,
news, my lord, kindly see the now even my lord, kindly appreciate one thing. For the process of auction, it has been intimated that these producers are seized, and we are now proceeding for an auction. That is intimated.
No.
Now then later which I hear. Then thereafter, what happened, Milord? There is a e-auction portal and also a public notices through Milord in the national dailies, Milord. So the petitioners are well aware about the
I
fact.
appreciate that, but what prevented you from communicating? Because
No, the
we have got
personal communication, Milord. Suppose now what happened, Milord? Suppose now he has been intimated. He has quoted suppose ₹2. Suppose. And the other bidders, Milord, because it is a e-auction portal, he has to participate through this e-auction process. So, Milord, he has chosen not to participate. What can we do, Milord?
My lords, may I?
Milord, Milord, when it is in the public domain, The separate notices, my lord, I'm asking myself, they're required to be given, my lord.
In, not in all cases, but here you know that this is the produce of certain persons in the tea garden area which is being auctioned.
No, my lord, even
And he has obtained the permission, maybe it
my
has
lord,
been revoked.
can I put it in another way? Suppose no, even he has participated, assuming the rate which has been fixed by the government by a committee constituted for this purpose, my lord. This rate is well protected because
If we can quote a higher price.
Yes.
let him say. I will disclose the rate. I will disclose the rate which the successful bidder stood.
Yes.
If he is ready to pay, then
My lord,
definitely I will revisit the issue with my office.
My lords, may I just submit something?
No, are you willing to
No,
match
my lords,
that price?
my lords, our question,
Are you willing to match that price?
my lords, we do not know firstly what
That
the
you will
price is.
disclose.
My lords, but our point
Then
is that
look at it.
under what provision of law are they auctioning this, my lords? As per the learned
that is-
AG,
You have not challenged this. This your permission has been revoked, and thereafter it has been taken to the custody. Look, there are two things. One is you have obtained the permission for pay.
yes,
Now, according to them, this you have obtained the permission stating it to be shade trees.
my lords.
The authorities have inquired and found that those trees were not, that does not fall within the category of shade trees. Permission was revoked. Thereafter, possession of that was that the forest officer took custody of that, but it was
Meanwhile-
kept within your jimma.
Yes, and
So you are holding on behalf of the forest. Now what happened? It has been, it's a perishable goods, you are also not disputing. So what is to be, you are interested with the value of that. With the value of that, now it has been put to the public auction. Your grievance is that you are not put on notice.
No, that is not the
you are interested to match the price, or you are interested to
From the court
participate in the auction. The learned additional advocate general says, yes, he will disclose the rate because your right can be prejudiced if you had quoted a higher price. For that, you did not get an opportunity. That opportunity he is willing to give you, provided you are willing to quote a higher price.
And also, my lord, one restrictions are there. And restrictions are there. When these auctions are floated, then there are registered, my lord, the certain the contractors or vendors, whatever, my lord, with certain my lord, I understand that it is not his producer. It is not his producer. My lord, I would have been there in the criminal case, my lord, as the FRT. I am even.
No, let us assume if it was shade trees, what would happen?
Shade trees, they are entitled.
So whether it's a shade tree or not, they can challenge that. That is the inquiry report. Did you communicate this inquiry report?
it was
This
not
revocation?
Revocation we have communicated.
My lords, we were never given the inquiry
Revocation.
report. And my lords,
Revocation order.
and my lords,
Yeah,
they have
Yeah,
filed
right.
the district
Show me that
magistrate.
it was communicated. Show me that this revocation of
My lords,
permission was
though no inquiry report was ever given to us,
No,
my
it-
lords. We were never given a chance to challenge
Lord,
that.
when-
And my
when-
lords, what
when-
happened? My lords, may I please speak for a minute, my lords?
No. Let me first ascertain whether this revocation order, how have you solved this?
And in fact, my lords, there is a affidavit
Lord,
filed by the
kindly-
district
my lord,
magistrate.
Before.
My lords, there's an affidavit
Just-
filed by the district magistrate in
In the
the
NGT.
NGT.
We've never-
We are carrying that, my lords. They had
80.
supported us.
Page 18.
1-8.
Page 80.
My lord, I am also carrying a report or affidavit filed before the NGT.
No. This
Because now
show,
which they are showing,
no,
which is
show that it was communicated to
manager
them.
to the manager of the memo.
But then the-
Where is that?
To the manager shouldn't it
No,
be
no, no.
sent?
This is show me it was served upon him.
My lord,
Where
then
is the
my office peon book I will bring them. I will register. I will be definitely, my lord, my government office. How can I deny?
Yes,
Which the-
because I'm only concerned because
My
they're
lord, I did
entitled
not
to
understand.
challenge this.
I did not
They're
understand it will come from your lordship's end that it has been really delivered or not.
We have
Because
not
but
been-
they are saying,
We have
because
not-
they are saying that
my
it
lord,
has
then
not been served.
then definitely I will show.
Yes,
Even my lord, kindly see one thing. Then they have, my lord, moved before the Honorable High Court for quashing. For why? What is the purpose?
Because the next document is that this auction will be held to deposit the sale proceeds. All these decisions, they were not aware because what Mr. Rai has placed, he has placed one side of the story.
Yeah.
So he has said permission was given, everything. Thereafter, we had done. We are also ready and willing to plant trees, but my property was put to public auction. You have come out with a case, no. We have inquired into the matter. We have found that he has paid for permission to fell shade trees. Upon inquiry, it has come to our notice that it's not the shade trees for which we have revoked. This revocation, if you have served, they ought to have challenged. To show that you have served, that they have not challenged, it's end of the matter. If it is that they were not served,
I will show.
then
They have a case. I do not know. I don't have any knowledge. But they cannot. They cannot say because because
this is one thing. And second thing is that for which they could not participate in the public auction.
Yes. Now, my lord,
So-
let them, my lord. What I am saying, my lord, even your lordship is even indicated that if they are ready to, my lord, quote the highest price, which the successful bidder had quoted, then definitely we will revisit the issue. I am taking the responsibility.
But what will
Because
happen?
always what-
Successful bidders will come. They
Well,
will say we were not notified.
No. My lord, that is the reason I will revisit the issue with my officers.
Yes.
Whether it is possible or not, that I will see. Because only thing is that we are interested about the exchequer.
No, what
They-
happened with
My
the
lord, but
locks? Where
these
are
are-
those?
Locks are there.
Logs are in our custody. my lord.
Locks are there.
But my lord,
There.
these are ours.
Because the Jimma was given.
Yes.
My
Jimma,
lord,
Jimma was given.
my lord, the
So,
question of us participating in
Please-
the auction does not.
Madam, please decide who will
One second.
address the court.
I'll do that.
You.
In the absence of Mr. Amlish Rai, I will at the moment. My lord,
Very
if I may just give one thing, my lord, the property act as per section 4 of the Land Reform Acts, the trees which are felled in the garden area, those trees, the proceeds of those have to be only and only be used for the purpose of the welfare of the laborers of the garden and nothing else,
Madam,
my lords.
That is not in
So,
dispute.
my-
The question is, you have obtained a permission according
Yes.
to them, suppressing an material fact by stating those trees to be shade trees, which they have on inquiry found to be not.
My lords, we did not
So,
name any trees.
That is,
The trees were named in the DM's permission order. These are the trees that you can cut. We did not name any trees while applying.
My lord,
While
your application
applying,
has been produced. Have you got a copy of this?
just now, my lord.
Which I have handed over the
Yes.
entire bunch.
Your
Shade
application they have annexed.
Everything I have.
mentioned, Ruby. This is our
Their application you have annexed.
This they are given, no.
Yes.
So one second, my lords.
So
My
whether
lords-
it's shade trees or not, they have on
So-
inquiry, they have found.
So my lords, while applying, we did not mention any species of the tree. We only mentioned shade trees. In the permission, the species Dhupi, Chiloni, Shemul, my lords, at page 12 of
But
my
you have felled
seniors.
some trees.
Yes, my lords.
So from
Again,
those
please
trees
don't misguide the
which,
court.
No,
which
we
you
are
have
not.
felled, from that upon inquiry, it can be found whether it was in the nature of shade trees
So,
or
my
not.
lords, we should have
So-
be given an opportunity to participate
That
into
is
that
why
inquiry
that-
proceedings.
Yes, but that
Secondly, my lords,
I wanted to know from the additional advocate general that whether these inquiry proceedings were
And-
initiated pursuant to a notice or a notice was given to you in connection with this inquiry. You had an opportunity to participate and this order was communicated to you. Let
my
it
lords,
show
may I
that-
just say
No,
two
no,
more
I-
things,
I-
my
I
lords?
feel from
Very
my
small things.
The inquiry committee which was constituted later part to identify whether for the falsification of the documents and the statements, I think that notice was not issued to them.
Then-
I think so.
So
But
if
Milord,
inquiry
Milord,
is
I
beyond
must be-
behind their
Milord,
back.
but as of now, it will be very
And-
tentative, Milord.
And my lords,
Because I have not gone through the entire Milord records.
No, but
Because
the
it's a
inquiry
tentative-
is final.
Tentative.
So inquiry, if you have inquired into the matter with regard to the nature of the trees,
Yes.
they were entitled to a notice.
Milord,
How could you do this without giving them a notice?
and my lords, two more points. May I just
Milord, kindly, which I have, because if you lordship see,
Mr. Additional Professor, please take instructions because there is two things. You may have cancelled. You have inquired. When they not entitled to a
Milord,
notice.
let it be, Milord, let's
Because
do.
this goes to the nature of the shade trees. They say it's a shade trees These are the trees which are,
My lord, I understand.
but you have,
My lord, I will disclose by way my affidavit, my lord. All documents, all I said is a tentative. Because within a 2 days, my lord, I have collected with my office, a tentative.
yes.
It's a tentative, my submissions, my findings even. If I go into a detail, then definitely other documents may come and I will definitely disclose by an affidavit. So, my lord, what happened today?
Only two things. You can disclose that by way of an affidavit. Please take instructions.
My lord,
whether this
within 2 days, it is not possible. 2 days is not
inquiry,
possible.
whether notice was served or
My lord,
not.
2 days, why is not possible, my lord? I am saying that today is Tuesday, my lord. Definitely, your lordship will not fix any matter on Friday. I understand, and I will not be even there. So, if I seek instruction tomorrow, it is in Darjeeling, my lord.
You cannot, you will not be
I
able
cannot
to get
use
it.
my, because my working day, I cannot, because lordship can see the other matters are also. My difficulty is that within a 2 days, volume of documents, because I had a discussion with the then DFO at night 12:45 AM yesterday. And the then DFO has provided certain other additional documents which are not annexed. Is a, I cannot say in open court. You can understand how the 482 petition has been dismissed.
No,
You can
for
NGT
that-
was taken into in consideration.
No, that you can definitely take
So-
steps. Nobody is preventing
Yes.
you
So,
from
Mila,
that.
let me
But
allow me to disclose everything by way of affidavit. They are well protected because the auction process, the money would be kept in a separate account.
No, but only one thing.
Let
There
them
are-
say now, we will pay the rate
My lord,
quoted.
why will we pay, my lord? The
Why will we
property is owned by the garden, my
Madam,
lords.
there are two things. Whether there is, whether this was done illegally or not. If you have done some illegal acts, you are not entitled.
No, no, my lords, what?
So for that, since the goods are of perishable nature, it has to be auctioned and the amount has to be kept.
My lord, the state was represented both in the NGT and both in the
Here is also
state.
state is
It is not
represented.
the case that this is the first time that the state is coming before your lordships.
Yes,
And in the
Past-
High Court matter also. In every litigation that has gone into the picture, the state has come in
Madam, then they have to
everywhere.
be given a chance to file their affidavits. There's no scope to
My lord,
pass any
meanwhile, no
interim order
steps
at
be
this stage.
taken. Meanwhile, my lords, no steps may be taken, my lords.
Huh?
No steps to lift the logs may be taken by them.
It will
The
perish,
status quo.
madam. It
My
will
lords, it has
perish.
been like that for many,
It
for,
will perish.
my lords, it has been like that for 2 years already, my lords. My lords, for 2 years, it has already been like that.
Then I will face.
3
I
years.
will hear the music from
3 years,
successful
my
leader.
lords.
This is the
3
reason I am
years.
saying.
My lords, without,
If they court,
my lords, without,
When the auction was held.
auction was held, my lord, just
my lords, if my lords is taking any other view, my lords and my senior may be allowed to appear and revert, my lords, because
December.
I,
30 December 2024, my lord, the auction was floated. Public auction was floated.
Yes.
Uh,
And when it was
2024.
finalized.
Finalized, my lord, I just a second, my lord. 13 January, reserve price 13 January 2025, 27 January 2025, 12/2/25.
3 years,
My lord, it is in the February it has been settled.
my lord, 3 years they were sleeping,
And
so
when the
few
fees
more
were
months,
paid,
Fees were paid in 1990.
2019, 20.
2019.
19, because this is the reason, my lord, NGT, 482.
All right,
Could
so
not-
Mr. Rai can make his submissions. Tomorrow I am.
Yes, my
keeping it.
lords, grateful, my lords,
Tomorrow I am. keeping-
grateful, my lords,
All right.
very grateful.
Tomorrow for, my lord, the further hearing.
For further hearing, further hearing will be only for the purpose of granting any interim order. What is the,
My lord,
what is
may
the
I,
scope
may
of?
I take back the copy and I will hand over the, just a second, hear me first. I will hand over the photocopies of the document, but my internal consumption I cannot. I will, ওই যতগুলো document গুলো দিয়ে।
The heard Mr. Rai and its senior advocate for the petitioner. The learned additional advocate general makes his submission. First of an accommodation has been sought for on the ground of Mr. Rai and its senior advocate. And accommodation has been sought for on the ground of Mr. Rai and its senior advocate to give his reply submissions.
And my lord, our report has, short form of report has been, annexing document has been relied upon.
The bunch of the report / statement of facts along with you
My lords, then a
have
copy
said
of
that
this.
brief history / statement of fact.
Then my lords,
The
give us a
report
full
/ statement of facts along with a bunch of documents which have been filed by the learned additional advocate general in court today is taken on record.
My lords,
Grateful.
we will get a
A
copy of.
photocopy of such,
Photocopy of the document
photocopy of the documents
handed over to import.
be supplied to the
Without the statement.
learned.
No, statement you are not entitled, madam.
advocate.
This is my
That
personal.
needs to be recorded, that
This
may
is also not for the court, that is for the addition.
Not for the,
For the
I should
addition
not
ad-
disclose.
should not disclose. Kila? The photocopy of the documents relied upon by the learned additional advocate general in course of his submission. Be supplied to the learned advocate.
Handed over, my lord. They have taken over.
Be,
Supplied. Otherwise, they say
now, has already been supplied to
got
the learned advocate on record of the petitioner in course of hearing of this.
Grateful. Get much of it. Tomorrow,
This matter
tomorrow to be mentioned.
next week only for the.
Then, my lord,
No difficulty in keeping, but
yes,
the
I
entire
understand,
thing
my lord.
is that the motions
I,
are
the
getting-
others matters is getting effect. That's why I said, no, my lord,
that
tomorrow,
is the-
your lordship, not, sorry, day after tomorrow, Thursday, my, the students matter.
Yeah, total.
Don't know what happened because today effectively all were hearing matters, though at the motion school.
But, my lord, my students will go, will be shut down. One day from the para request has come, at least one day be assigned for a hearing matter. This is our only, yes, you can hear the, my lord, the noise. So let that Thursday, my lord, at least a one part, not the both the part.
Start that from the next circuit.
We mentioned serial 29 to
My lord,
39.
I have started from Monday,
Lordship,
from
serial
beginning of the
29 to
circuit.
39 lordships, kindly keep for Thursday, lordship.
All matters will be keeping, no, for Thursday it will be called on serial.
Lordship, and tomorrow some accommodation will be.
Tomorrow we will
Some
not be available all day.
Great.
That accommodation will be given.
Great.
It
But
will be in
what-
the list. It will be in the list, that
It will be in
accommodation.
the list, that accommodation will be there.
But executive accommodation will not be given, my lord.
That is the, because upgradation will be a problem, because others will be affected.
Great.
And
Great.
because all these matters are in the hearing matter,
There is-
all are urgent matters.
there is-
Good.
yeah. Grateful.
Check the document.